You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and welcome to Immigration TalkShow. I'm your host, Napasa, and I'll be with you in this session for about an hour. So, thank you so much, everyone, for joining us. We are streaming live right now on YouTube and also on LinkedIn, Facebook, and on X. But you can also check us out on Instagram. So, connect with us and share this with all your friends and folks out there who can join us and benefit from this discussion that's lined up. But before we head on with the topic of discussion and we have our guest for today, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, I hope you keep that in mind throughout this whole session. And best thing is you can also participate, by the way, comment wherever you're watching us. And yes, you can also dial in the number which you can see on the screen above. The number is 425-436-6335, and the access code is 988-888. And today's topic of discussion you can already see on the screen: July 2025 Visa Bulletin. What changed and what's coming in August? So, folks out there, maybe, if you are in any of your family based or employment based visa statuses, something, a visa process, and you need to know something, you need some clarification, join us to ask your questions. And another best thing is we are going to have our guest for today. So it's really my pleasure, to welcome none other than Jennifer Beam to the show today. And Jennifer is a partner at Berardi Immigration Law and one of their most inspiring success stories. Well, she began as a legal intern and has played a key role in the firm's growth ever since. So she's known as the analytical one, and Jennifer brings deep expertise and sharp insight to every case she handles, they say. And we're really thrilled to have her with us today. So, welcome to the show, Attorney Jennifer Beam.
Thank you, Napasa. I'm excited to be here and I appreciate the invitation. As Napasa said, I'm a partner with Berardi Immigration Law. I've been with the firm for 14 years now, and we have just grown leaps and bounds. We have an East Coast and West Coast presence, as well as virtual offices in Toronto and in London. So we represent individuals for employment and family-based immigration matters who reside all over the world, and we love doing what we do.
Thank you so much, Jennifer, today, really. And I'm looking forward for this discussion. There's a lot to talk about, and we would really love, to be enlightened by all your expertise and whatever you can guide us with today. So, thank you once
Absolutely.
again.
Of course.
Thank you. So, well, since you're joining us for the first time, so a warm welcome to you to Immigration Talk Show, and we would really love to get to know you better. So, would you like to tell us how has it been for you and how's it going?
Yes, absolutely. Well, I mean, I've been doing this for nearly 14 years now. And it's always, we always see a shift whenever we have a change in the executive branch with different incoming presidents. It's been very busy for us lately. As you can imagine, you've probably seen US immigration headlines. So, we tend to try and quiet the noise and push past the media and serve our clients well The law has not changed. A lot of policy and attitudes have certainly changed, but as you know, Congress rarely makes any substantive changes to immigration law. So there's always a ton to talk about, and I'm sure that clients feel maybe some differences in immigration, whether it's attitudes by consular officers abroad or perhaps an RFE. If you're in the United States and you've submitted an application, sometimes the pendulum tends to shift with respect to policy changes. But at the end of the day, we stand by the law and continue to get cases approved every day. So I mention this because for those of you who are very intimidated by U.S. immigration right now, approvals are still happening. So try and shut out the noise that you may see in the media. And, cases are still getting approved every day. Green cards are still being issued.
Absolutely. I think the best of the best cases are being approved, and only the most deserving ones and the luckiest ones are able to be here in the US. So I think let's keep it at that. And I'm
Right.
very excited for our questions. I hope you're ready too.
Yeah, let's dive in.
All right. So let's start with our first question that I have for you, Jennifer. And well, F2A, saw a big jump from
Yes.
January 2022 to September 2022. So what caused this leap maybe, and should eligible families file now?
Yeah, so let me give a quick overview for some newer listeners with respect to how the Visa Bulletin works. Every month, the US Department of State publishes a Visa Bulletin. And basically, what that is a document that acknowledges Congress sets the limits of the number of green cards or immigrant visas that will be issued each year. So the Visa Bulletin sets two cutoff dates for each category, whether you're being sponsored by a particular family member or perhaps by an employer. And those two categories are then distributed across different, what we call oversubscribed countries like China, India, Mexico, and the Philippines. And what we're left with are two charts: the final action date, which controls when a green card can be approved, and a date for filing. And that's when someone can file the adjustment of status package if they're here in the US. Caps exist globally across all green card applicants for different categories and by countries. So with respect for the F2A category, we did see a bit of a jump. That is reserved for spouses and unmarried children under 21 of green card holders. And we saw that jump because of spillover. So this happens when other family preference categories don't use up all of their allotted visas by the end of the fiscal year. And then this frees up numbers for F2A applicants. So if a family's priority date is before September of 2022, they should file that now to get ahead in processing. And remember, for individuals who are already in the United States, they can go ahead and file the adjustment of status package. If it's an F2A priority date for someone outside of the United States who won't be filing an AOS package, they will need to go by the final action dates chart.
Thank you so much for taking that up and for those tips, I think, for folks out there to be ready. So,
Yes.
yes, looks like a lot of changes are happening, especially right now with all the updates we get every day, all the news that we see. And,
Yes.
well, definitely, I think that is also bringing up a lot of changes because maybe families are not able to reunite as well.
Mm-hmm.
And a lot is happening. So we will keep unfolding and as we go ahead with our session. And I'll just quickly say hello to Ricky right now. Ricky says hello too. So thank you so much, Ricky, for joining us. It's always nice to see you. He's one of our regular viewers, Jennifer. So
Oh, great.
welcome,
Welcome.
welcome, Ricky, once again to our show. And we will take up your questions a little later. Stay with us, all right? For now, though, Jennifer, if you can tell us about F1 and F2B, which moved slightly as well. So, do these changes mean family visa backlogs are finally being addressed, or it's not really like that?
Unfortunately, it's not really like that. These are pretty steady increments from the regular use of annual quotas. So the movement forward reflects a gradual progress rather than this big resolution of longstanding delays that I know we're all hoping for, but I wouldn't necessarily hold our breath on that. So the F1A category, that's for unmarried sons and daughters of U.S. citizens, that moved forward by a little over 2.5 months, and F2B for unmarried adult children of green card holders moved by 2 months. So again, consistent movement forward, but it certainly doesn't signal that the backlogs have cleared in any major way or that we're going to see that.
Okay, so thank you for taking that up. And Rag has also joined us. Hi, Rag, to you too. He says, hi, Nipa and Jen. So lovely to have you, Rag. We're ready for your questions. If you have any, keep dropping them. We are going to address them a little later in the show. And Jennifer, this next question is about employment-based category for the EB1. For India, it has not moved since February 2022.
Yeah.
So why is India still stuck when other countries are current?
So we've seen this big growing demand for EB1 in India, which continues to exceed its allocation. There is a 7% per country cap, and that limits the visas for each country. So what happens is we have this blocked movement, and compare that to countries with lower EB1 demand. They can continue to move to current status when their backlog is cleared. But unfortunately, we see this growing demand, and that's now resulting in more or less a freeze for that cutoff date.
Right. So what do you suggest? I mean, folks in India who want to be in the EB1 category or are applying for this visa, what should they do right now?
Yeah, well, it's stuck it stinks because we have this very restrictive immigration system. I would never discourage anyone from putting together a good EB1 package. It's certainly a faster way to get a green card than perhaps definitely the perm process or the EB2 and EB3 categories. Unfortunately, when you're talking employment-based immigration, it's a hurry up and wait, if you will. Everyone's eager to get their application packages in, their priority dates established. And if you are an individual who is of EB1 caliber, I still recommend the EB1 path for Indian nationals because it's going to be the faster way. But unfortunately, beyond that, there isn't any possibility of working around the Visa Bulletin.
Okay. Well, thank you so much, Jennifer, for taking that up as well. And hi to Pinky, Robinson, Jason. Thank you so much, all of you, for joining us. And I can see some of your questions. Just say stick with us because we're going to address them a little later in the show, just about a little later after the break as well. Maybe we will take up a couple of them. So for now, though, Jennifer, if you can tell us about EB2 category as well for India. It is frozen since January 2013. And if you could tell us what's really blocking it, and is there any realistic chance that it moves this year?
Yeah, so kind of similar to the EB1, but more extreme. We have this persistent high demand that exceeds the per country limit. Again, that's a number that Congress sets. And that combined with minimal spillover from other unused visas in other categories, I don't expect that to see any major movement forward without any sort of major legislative changes or a reallocation of visa numbers. So I think that we're pretty much where we've seen movement for the rest of the fiscal year 2025. That does reset come October 1st. So, mid-September, early to mid-September, we'll see what sort of movement we have going forward. But India's EB2 and EB3 tracks, there's just so many individuals who have applied for that category. And again, because of the way that Congress limits the number of green cards each year, and they are also capping it by countries of demand, there's such a high demand from Indian nationals for green card numbers in the United States. And what we're left with is this Visa Bulletin and these major, major unfortunate backlogs.
Thank you so much, at least for being straightforward and giving us the real picture. And we have a lot more questions, but it's time now for a short break. So, dearest friends out there, stay with us because we are going to take up your questions and we're going to talk more about the July Visa Bulletin of this year and also maybe discuss what we can expect in the upcoming Visa Bulletin.
Mhm.
Today, we are really pleased to have none other than Jennifer Beam with us here on this show, and we are going to speak more with her. She's from Berardi Immigration Law, and very inspiring she is. So definitely stay with us, but we'll go for a short break right now. Don't go anywhere. Stay tuned on Immigration Talk Show. It's me, Napasa.
Thank you, Napasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we are discussing on July 2025 Visa Bulletin, what changed and what's coming up in August. So it's been a very wonderful discussion so far with none other than our guest of today, Jennifer Beam from Berardi Immigration Law, and she's one of their most inspiring success stories and definitely began her legal intern and played a key role in the firm's growth ever since. So you should definitely check her out and join us to ask your questions if you have any questions, if you are navigating the family or the employment based categories from any country and you have questions. Definitely this is where you should be to ask your questions. So join us, and yes, Jennifer, I hope you're having a good time answering and taking up our questions.
Absolutely. I'm very happy to be here today with you, Napasa.
Thank you so much. Really, it's an honor. So, well, I'll go right back to our questions then. And you were saying we were talking about the employment-based category. So,
Mhm.
India moved just 1 week in the EB3 category, and it has, and is that even helpful or just symbolic at this point?
Well, for someone with a priority date between April 15th and April 22nd of 2013, it's certainly helpful. But, overall, I would say it's a very marginal shift and it's effectively symbolic. A very limited number of people with exactly that priority date and between that window will feel reprieve. But, on a greater scale, it offers almost no practical relief for those further back in the queue. Very little movement forward. And again, it's because EB3 India has such high demand versus, especially when you compare it to some of the other countries that are on the Visa Bulletin or all other countries. So pretty much symbolic.
Thank you so much, Jennifer, for taking this up. Well, what can I say? At least, you're being straightforward and you're not making our hopes too high up, I guess. So,
Yeah,
thank you
unfortunately.
for that. Well, let's take up some of our
Get
questions
excited
from the
about
viewers.
sorry, Nafasa. I was going to say it's tough to get excited about movement for India when it comes to the Visa Bulletin. And I'm sure that many of your listeners feel that pain every month. Every month we're keeping our fingers crossed, hoping to see greater movement forward. But in reality, unfortunately, Department of State's hands are more or less tied by those congressional officers who set those numbers and usage and how the bulletin works. So we're left with a very frustrating system for understandable reasons.
For sure, for sure. I really wish that, it would not be maybe country wise, but maybe
Mhm.
how proportionate or how much population each country has. Maybe that way, maybe some backlogs could be adjusted. But these are just
Yeah,
discussions for us. It's not really working that way.
you're
So,
right.
but yeah, let's take up some of our questions from our viewers. Let's not keep them waiting too long. So,
Great.
Ricky, you're the first person who asked us your question. So, let's take up this first one. Can you give some idea on the typical processing time that you are seeing for standard NIW based I-140 petition? Also, can premium processing increase chances of RFE for pending NIW I-140 petitions?
Yes, absolutely. So the first part of that question, for regular processing, we've seen a pretty consistent, it sort of varies, 8 to 11 months on regular processing for our NIW cases. And then with respect to, does premium processing increase the likelihood of an RFE? USCIS's official answer is going to be no. But in practice, we do see a correlation between RFEs on cases that are premium processed versus cases that are filed by a regular processing. That's not to say that a case filed by regular processing isn't going to get an RFE. There's been a huge shift in adjudication trends for NIW petitions in general. Particularly, I mean, it really started even a bit prior to the Trump administration coming into play earlier this year. But if you think about it, when you are filing a case by premium processing and you're submitting a case that has tons of documentation and lots of complex supporting evidence, sometimes USCIS adjudicators will feel squeezed to make a decision in that 45 business day window. And so the easier thing to do is for them to issue a request for evidence and punt it back to the applicant and perhaps their attorney. That's also not to say that RFEs are not able to be overcome. We certainly get an occasional RFE. We try to draft our cases. Nobody wants an RFE, but occasionally they do happen, and they can still be overcome with appropriate evidence. And go through that RFE very carefully, because sometimes USCIS is entirely wrong on their interpretation of the petition or whatever's been drafted and put in front of them. They make mistakes as well. So yes, that is my short answer to it.
Well, thank you so much. And you're right. We hear a lot of people doing premium processing. They get the instant thing they get is an RFE.
Yeah,
So not many are ready to take that risk. And plus, it's a lot of money, for premium processing.
I agree, Napasa. And what I tell my clients is, look, if you have time on your side, then perhaps be patient, file by regular processing. Um, Sometimes time is not on a client's side, and for whatever reason, they need that I-140 approval secured sooner rather than later. But if I and I don't feel this way about every visa category. We file tons of non-immigrant visas by by premium processing, and we see no correlation to RFEs. But it is one that we've seen just from a practice standpoint. The statistics do appear to feel they are higher for an RFE on NIWs and EB1s as well. Part of the game.
Well, there we go. And now we have Robinson with this question. There's a lot of talk online about retrogression and advancement, but honestly, what do those terms really mean for someone like me waiting for a green card?
Sure. So when we talk about the Visa Bulletin retrogressing or advancing, we are really referring to someone's priority date. So when you say that you're someone waiting for a green card, I would assume that we're starting with someone who has an established priority date. And what a priority date is, it's an applicant's place in line, if you will, when undergoing the green card process. So when it comes to the employment-based green card process, a a priority date is established when an employer files a perm labor certification with the U.S. Department of Labor. Now, remember, you need a certified perm before you can file an I-140 petition with USCIS. So the priority date for perm-based green card applicants is when the perm is filed. Perms are taking almost nearly 15 months right now for certification. So your priority date may be more or less set, and then it is memorialized in an I-140 approval after the perm is certified and the employer has filed a petition with USCIS. Now, some of you who can work outside of that perm system, whether that's through the EB1 category, the priority date for an EB1 is established when the petition is filed with USCIS, again, an I-140 petition. And some of you are able to work outside of the employment-based green card if you are eligible for sponsorship by a family member. Now, sponsorship by family members, unless it's an immediate relative, there's always quotas and backlogs. If you're marrying a U.S. citizen, or you are sponsoring you are being sponsored by a child who's a U.S. citizen, a child over 21, there are never quotas for those categories. But everybody else there is. And again, remember, Congress limits the number of green cards that they are willing to issue each year. And there's more complexities that go into that. But when we talk about a retrogression, we're talking about cutoff dates going backwards because of an overdemand. And when we're talking about advancement, we're talking about working towards a more current priority date. It's a little bit tricky to explain. I encourage all of you to follow me on LinkedIn. I have an article on how the Visa Bulletin works that I will repost for the listeners and pin that to the top of my profile. It was something I had drafted a year ago, but it really breaks the Visa Bulletin down primarily in the employment-based context much more simply. So if you're new to these concepts, I encourage you to follow along and check out that article.
For sure. And there you go, friends. You can also click on this link, which you can check this link, which you can see on the screen, and get to know more about Attorney Jennifer Beam. Well, also, you can check us out. I hope you are resonating with this conversation we're having, and especially these answers and responses which Attorney Jennifer Beam has. So check us out and subscribe to us. Our handle is @Immigration TalkShow. We are not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So check us out and stay connected with us. Now we do have more questions. Let's take up Pinky, who's saying August bulletin on EB2. Maybe she wants to know what's going to be the scene. But we would have to know, I think, which country she belongs to, right?
Yeah, well, and my simple answer is the August Visa Bulletin has not yet been released. We'll probably see that maybe mid-July. I'll be honest, for some of these categories, particularly in India, I don't expect to see much movement forward. I think what we've seen these past few months will probably mirror what comes out for August. And same again for September. October's Visa Bulletin is the one you're really going to want to watch, because that's when the government's fiscal year resets, and that's when we tend to see a bit more movement forward. So that should be outcome mid-September, and that will be the one that probably provides a little bit more excitement rather than June, July, August Visa Bulletins.
Right. We will have to wait for almost the end of the fiscal year. So, Pinky, thank you so much for joining us with your question. I hope that is what you wanted to know. And if there's any more questions that you want to follow up with, please feel free to keep asking.
Yes.
Now we have Rag. Rag has another question. He's saying, with an H4 EAD filed, I-140 and I-485, is secondary inspection at the port of entry more likely?
Okay, so I'm guessing this question stems because we've seen a lot of stories in the media about difficult entries for non-immigrant visa holders. My advice there, shut out the noise. My advice to individuals who have any non-immigrant visa, whether it's one that allows for dual intent, like H-1B, H-4, L-1, L-2, versus the O-1, the F-1 categories, you always want to have your best practices ready to go when you are entering the United States. And what Customs and Border Protection officers are trained to do is to see, does your intent for entry to the United States align with your current visa category, your current status request? So for someone who is here as an H-4 spouse who has an EAD, maybe that individual or their spouse has an I-140, there's no I-485 filed. All of those details are really not anything that CBP is immediately going to be inspecting or asking questions about. They're going to be asking, what are you coming in for? Do you have a valid visa? What is the purpose of your entry? And does it align to the category that you're requiring entry under? So for someone who's entering as an H-4 spouse of an H-1B holder, relevant details to that is, what does your spouse do? Who does your spouse work for? Is your spouse currently working for their appropriate H-1B employer? If you're traveling together, that adjudication process is probably going to be smooth sailing. If you're traveling separately, the H-4 spouse may want to have their partner's pay stub to show recent payment from their appropriate H-1B employer, and maybe even have a copy of the spouse's primary I-797 approval notice. Any hesitation in terms of where you're going, who you're working for, especially if you're here in a non-immigrant status that allows for work, that can cause CBP officers to raise an eyebrow. So you want to be confident in your responses, understand the purpose, understand the restrictions and benefits of your category that you're entering under, and ensure that you are abiding by the law. If you're an H-4 spouse who does not have an EAD, remember, you can't work. So those are the sorts of things that the government, a CBP, Customs and Border Protection officer, is going to be screening for upon entry. I don't think that secondary inspection is more likely unless you've engaged in some sort of criminal activity recently, you've had any sort of visa revocation, but for the most part, we are not seeing any sort of crazy increase in secondary inspection. And in those news stories where we're hearing somebody was not admitted into the US, there's usually a little bit more to it than what the media is able to provide.
Right. Well, thank you so much, Jennifer, for taking that up. And well, I think we have so many more questions from our audience and viewers. Really lovely to have each one of you. And we are going to take up your questions, but it's time now for another short break. So, Mehseen, Mihil, Sagar, Manisha, Alicia, Jason, please stay with us. We are going to take up your questions after this break. Today, we are speaking with none other than attorney Jennifer Beam from Berardi Immigration Law. You should check her out and visit this link, which you can already see on the screen. And don't go anywhere because we'll be right back after this short break on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle.
Welcome back, everyone, on Immigration Talk Show. I'm Napasa with attorney Jennifer Beam, and it's been a real good conversation getting to discuss about the July Visa Bulletin, what happened, and what can we expect in the upcoming Visa Bulletin. So also, it's been really nice to have such participative and engaging audience with all your questions, very interesting ones, I should say. And happy to answer, I think, Jennifer. I hope you are. Let's
Very
take
happy
up
to be here.
this. Thank you. Thank you for being such a sport. And now let's take up this next one from Jason. He's asking, is J1 visa back to normal?
With respect to, I would assume that question is with respect to the expanded vetting for F1, J1 visas. Earlier well, I guess it was really in May, the Trump administration was freezing visa appointments for F1, J1, and M1 visas. And what that means is they wanted to roll out deeper vetting for those visa categories. And a lot of this has to do with some of the action that's going on US campuses in the United States, and the Trump administration wanting to ensure that international students and scholars are abiding by the terms of their visa and more or less not engaging in political activism on campuses. Now, aside from some of the constitutional nuances and freedom of speech concerns associated with that goes above and beyond today's conversation today. What happened was the Trump administration froze visa appointments. They have reopened those windows, and they have told consulates and all visa applicants that J1, F1, and M1 visa applicants must make all of their social media profiles public when they apply for a visa at a US embassy or consulate abroad. And that's as part of the DS 160 vetting. So the government will do some deeper screening. With respect to, is it back to normal? I wouldn't necessarily say that we have enough data to see if it's normal. Students can go ahead and proceed to make their appointments, but time has yet to tell if it's going to take longer to actually get the physical J1 visa stamp in their passport, or F1 or M1 visa stamp. There are deeper security screenings, and I would suspect that it may take a little bit longer in terms of actual visa processing post-interview. So that is something to plan for in advance if you're applying for a visa in one of those categories.
Okay. Thank you so much for that update as well. And thank you, Jason, for a very interesting question, and Jennifer for taking that up. So let's take up Sagar Manisha's question. Heard of Dignity Act 2025 is going to pass on 8th of July. Can you explain the pros and cons of EB3 role, rest of the world?
Yeah, so let me first clarify that the Dignity Act of 2025 is some bipartisan immigration legislation. That is not yet law. It is nowhere close to becoming law. So really, we're not going to see any immediate change in EB3. And to be quite frank, I don't mean to sound pessimistic, but I've been doing this for a very long time, and it's very, very rare that Congress can actually get its act together to pass any sort of comprehensive immigration reform. I just know some of the highlights for the Dignity Act of 2025, and my understanding is that they've proposed a 10-year cutoff, like as a max period of wait time for receiving a green card. What that will actually look like in practice and whether that will really go through has yet to be seen. It takes a lot for Congress to pass and implement a law, but it is something we will watch in the coming months, if not years. But as of now, the takeaway, we're not going to see any sort of immediate change with respect to backlogs and how the current Visa Bulletin works.
Thank you for taking that up. And please do not forget to subscribe to our channel, folks out there watching us, and especially folks who are getting their answers, from this conversation and this episode. I really hope that, you have already subscribed. And even if not, subscribe now and hit that bell icon so that you're always notified whenever we have discussions like these and have special guests like Jennifer join us today. So thank you so much, Jennifer, for, patiently taking up each of our questions.
Of course.
And well, we have Mihil who's asking, hello, any predictions for EB3PH, I think Philippines, this coming August? Will it move forward or retrogress?
For EB3PH, I'm guessing for India. I'm sorry, Napasa, what did you say you thought that PH meant?
Philippines? I'm not very
Oh,
sure.
Philippines. Yeah, perhaps. I don't have the Visa Bulletin in front of me to look at the overall trends, but I'm happy to get back to you for that specifically. You're welcome to email me. My email is on our website, and I will take a closer look at that for Philippines and take a closer look at some of the trends over time.
Thank you. Thank you, Jennifer. And Mihail, do check out attorney Jennifer Beam in this link, which you can see on the screen as well. And yeah, I hope you get your answer. But keep asking your questions if you have any other. Now we have Messine. Is there any update about the Dignity Act, which is being discussed in the Congress?
Yeah, it's still in a very, very preliminary phase. It is, like I said, they've received endorsements from bipartisan groups back when it was introduced in May of 2023. And provisions for that act are expected to be reintroduced in Congress. So perhaps we will see that next month. But like every comprehensive immigration bill that's been put before Congress, it's going to definitely face political hurdles, and it's not yet been marked as imminent to pass. It's an ambitious thing to try and do, especially in the current administration. It does enjoy bipartisan sponsorship, which is always a good start in what we want to see, but the actual legislative future really remains uncertain. And immigration is such a hot topic right now in the current administration. And one of the complaints I have with the way that proposed legislation has tried to work its way through Congress is that it's presented as one giant, robust package. So it addresses immigration on the southern border, illegal immigration, family-based immigration, employment immigration, asylum and refugee immigration. We have the Dreamers and DACA in the United States. We have provisions for temporary protected status. What the average individual doesn't realize is that there are so many different facets to US immigration law as a whole. And I think what makes it very difficult for Congress to actually take any action on proposed legislation is that you have all of these competing factors wrapped up into one bill. And everybody wants this legislation to be tied neatly with a bow, and addressing these different facets to their constituents and what they want. And when you think about the United States and how you have Congress representing all of these different geographic areas, which in turn have different geographic considerations when it comes to immigration, you have all of these competing interests. And unfortunately, as we've seen time and time again, nothing gets signed, sealed, delivered. Very frustrating. I would love to see Congress tackle immigration in a bit more of a piecemeal style. That's not what we're probably going to see. But yes, I agree with you. Let's pray and hope that something better and have some advancements forward with this system that really does not necessarily serve America nor foreign national immigrants as good as it probably could have.
For sure, for sure. But thank you so much, Jennifer, for taking this up and for giving us these sneak peeks and overviews of what you've been seeing and what should we expect as well. So, Messine, thank you for your question, and let's hope and pray for the best to happen.
Yes.
So now we have, I think I skipped Alicia in between. So, Alicia, I'm so sorry, but let's get to this. Hi, Jen, she says. Is the EB1 under scrutiny now? I just heard about it in the news. Should we be careful about anything in particular?
I wouldn't say that it's under high scrutiny, but the EB1 has always been one of the more difficult categories to obtain approvals in. You do need to show that you are above others in your field. The government has a list of criteria, and the average the average candidate does need to show that they have satisfied at least three of those categories or three of those criteria to qualify for an EB1. And then on top of that, even towards the very end of the case, the government does what we call this final merits determination to essentially make sure that granting an EB-1 is going to be in favor of the United States and good for the US. So EB-1 can be a tough category. One thing that I know exists are a lot of vendors or agencies who promise to help applicants become qualified for the EB-1 by engaging them in pay-to-play media. And I think that that can get very muddy because those sorts of things don't necessarily really make someone of EB-1 caliber when it is a pay-to-play. USCIS expects it to be more organic. And we are hearing of trends where the government is looking into that. And if you're found to have kind of worked the system to get media that isn't as organic, if you will, that can come with some serious consequences of trying to misrepresent yourself to the government, which can lead to complex immigration determinations. So that's the one piece of advice. I would be very careful engaging in any of that for a strategy to make yourself EB-1 caliber, if you will, and maybe speak with an immigration attorney first to understand really what's the best way to go about qualifying for an EB-1.
Right, and maybe thank you so much, Jennifer, for taking that up. And I was just going to say that why not look for other options as well? And it's always best, to speak with an immigration attorney, and maybe you even fit into other visa categories. Why not
Absolutely.
consult with them and check? Maybe you have other options to even explore, right,
Yeah.
Jennifer?
That's right. And if you are an Indian national and subject to a very lengthy backlog, remember your priority isn't necessarily, I need to get EB-1 if you don't yet have a priority date. Your priority should be establishing a priority date, whether that's through the PERM process, which believe me, I know it certainly has its negatives and complaints. You're tied to an employer, you're stuck by an employer's process. Or maybe perhaps look into eligibility for a national interest waiver. It's not that those cases are any easier, if you will, from an EB-1 when compared to the EB-1 track, but they can involve a very different narrative that may be a bit more favorable to the applicant's reality and where they're at in their career. You can establish an EB-2 and EB-3 priority date and later carry that priority date over to an EB-1 petition. So my advice to my clients, focus less on EB-1, it has to be EB-1, it's all or nothing, and focus more on get your priority date established, and then let's regroup on the EB-1, especially if you're in the earlier phase of your career.
Right. Right. Thank you so much, Jennifer, for taking that up. And I think also, I hope that, Alicia, you got your answer. And folks, do not forget to subscribe to our channel. Our handle is at Immigration TalkShow. And also check us out, not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Stay connected with us. And also do check out attorney Jennifer Beam. You can visit this link on the screen, and feel free to keep commenting with your questions if you have, and we will address them in the show. Also, you can call us on the number which you can see on the screen above. The number is 425-436-6335, and the access code, when they ask for it, you dial the 988-888. For now, though, another short break, and you folks don't go anywhere. We'll be right back here on Immigration Talk Show. I'm Napasa with attorney Jennifer Beam.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we're speaking about the July Visa Bulletin, what changes we saw, and what can we expect for the upcoming Visa Bulletin, that is the August 2025 Visa Bulletin. And we are speaking with none other than our guest for today, Attorney Jennifer Beam from Berardi Immigration Law. And it's been such a great experience so far getting to know you, Jennifer, and also you being such a sport, taking up each of our questions so patiently. And of course, all your awesome audience out there watching us and throwing your questions at us. It's lovely to see such participation. So keep commenting. We are taking up each one of your questions as much as we can, as quickly as we can. And lovely to see Girish as well, who has joined us. So I think we should take it up. Jennifer is asking any planned changes to U visa program by present administrations?
Yes, I appreciate this question, Garish. Unfortunately, let me preface my quick response with a disclaimer that I do not practice in the world of U visas. I primarily focus my practice on employment and family based immigration. So I don't really have quite an answer for you, but for our listeners, a U visa is designed to protect victims of certain crimes, especially those who don't have lawful immigration status, and it offers them a path to remain in the US legally when they are assisting law enforcement in their investigation. Perhaps there is some changes to the U visa program with the act that we were just talking about, but I unfortunately don't have that answer out the top of my head for you. And it's not something that I am tracking, but I'm happy to put you in touch with some colleagues and other practitioners who do um, prepare U visa applications.
Thank you so much, Jennifer, for taking that up. And folks, you can get in touch with Attorney Jennifer Beam and visit this link, which you can see on the screen. Check her out. Also, Girish, thank you for your question and for participating as well. Ricky has more questions, but also we have more questions from our Facebook audience, so we will address them. But meanwhile, yes, can you give some idea, Ricky's asking, on the monetary charges you would apply for NIW I-140 petition premium, refiling with minor modifications? Should one consider filing premium processing if the NIW I-140 petition has been pending for the last 8 months?
So let me tackle that second part of the question first. If you have an NIW petition pending with USCIS and it's been 8 months, my practice would probably be to advise the client, you've waited this long. I may suggest that you wait it out, especially if you feel that it was a good case to begin with. Worst case scenario, best case scenario, it's ultimately approved. Worst case is that an RFE is probably issued. And at that point in time, when you look at the substance of the RFE, you can make a determination to respond to that RFE by withdrawing the case. So you're still responding, but you wouldn't necessarily provide USCIS with the evidence that they want to see. You instead ask the government or tell the government you're withdrawing the case. And maybe a strategy is to then take that RFE behind the scenes and work again to repackage an NIW to make it stronger. The first part of that question Ricky asked was for monetary charges. I'm assuming you mean like if I was to take on the case, and I don't provide legal fees without looking at the case as a whole. It's something that we would want to first review and determine if it's a case that we can stand behind and take on. And if there's a good narrative, we're certainly taking new clients and happy to work with them. But we are very selective with the cases that we do take on. And so legal fees vary based on the complexity of the work, especially for something that's been filed. If there's already a good substantive package, attorneys are going to need to charge for their time to review that. And it's not a quick flip through paperwork. There's understanding of an industry, reviewing someone's proposed endeavor, understanding how everything came together, and making sure that's presented in a format that is digestible and approvable for the service center.
Thank you so much, for taking that up, Jennifer. And Ricky, I hope you got your answer. Well, he has a lot more questions, but I think we should address some of our Facebook questions as well from the groups that we have. So, Control, I would ask you to please display them. So, this first one is from an anonymous participant saying, "Hi, I just got I-130 approved. I had applied for wife and I wanted to know when can I apply I-485 since my wife is outside in India."
So there's a couple of variables here. For individuals who are not in the United States in a current status, that can be difficult because bringing them in perhaps as a visitor conflicts with the concept of immigrant intent. With respect to the timing, it also depends if the primary sponsoring spouse is a US citizen or a green card holder. So if I was consulting with this particular client, I would be asking lots of questions first. If they're, when you have an I-130 approval on record, that immediately launches into, okay, we know that this individual does ultimately have immigrant intent. And that means the permanent intent to live and work in the United States. So if that spouse was showing up as a visitor and presenting a B2 visa for entry to the US with the intent to file an I-485 package, and they said that to CBP, the government would laugh and say, "Get out of here. You need to wait it out and you need to pursue immigrant visa processing abroad." I would, if the priority date is current and they're not subject, if it was a spouse of an American, I would recommend that the spouse pursue visa processing abroad. I know that that can be a little bit more cumbersome, but you are taking less of a risk by presenting yourself for entry to the US as a visitor, which again conflicts with immigrant intent. If the individual is able to come into the United States in a valid status, I'm guessing the sponsoring spouse was a green card holder or a US citizen. So they probably can't enter with a derivative, a dependent status, now that I'm saying that out loud. But if for whatever reason they were able to enter as a visitor, maybe perhaps they intend to come in as a visitor and then go back home abroad to complete visa processing. If they come in as a visitor and perhaps something changes and they aren't able to travel and their priority date is current, then yes, they could file an adjustment of status so long as they're eligible to do that. But keep in mind, a USCIS officer could question their intent. "Hey, we saw that you entered as a visitor and you filed an adjustment of status package 2, 3, 4 months thereafter. What changed? Because when you enter as a visitor, you're proclaiming that you intend to depart the US. Did you obtain an immigration benefit, that is, entry to the United States, while misrepresenting yourself to a border officer at the time of your entry?" So you got to be really careful there. And again, this is not legal advice. It's kind of just setting the groundwork for how the government officers are looking at individuals when they come in. Remember, does someone's proclaimed intent as a visitor, is the purpose of their entry aligned with the nuances of that category?
Right. Thank you so much, Jennifer, for taking that up and, for explaining, for giving us such a detailed explanation as well. This next one is asking from an anonymous member again, "Do I need medical exam for O1 visa consular interview?"
So typically, no. Most non-immigrant visa appointments do not involve a medical exam, but there is an exception to that. The Foreign Affairs Manual, which is the guidance for Department of State officers, that is consular and embassy officials, there is guidance in the FAM that says if an individual has had a DUI, I want to say it's within the last 10 years, and a DUI would be our equivalent is like driving under the influence of alcohol or drugs. If someone has an arrest or any sort of hiccup with the law that implies they may have had an issue with alcohol addiction, the interviewing consular officer can recommend that they attend a medical exam prior to approving a visa. and that's to ensure that they don't have any alcohol or addiction issues that might be a danger to American society if they were admitted to the US. But the short answer is there's rarely medical exams involved for any non-immigrant visa. The medical exam is a requirement for all green card applicants, whether you're filing from within the US by adjustment of status or you're completing the process abroad through consular processing at a US embassy to get that final immigrant visa interview inserted into your passport.
Okay. All right. Thank you so much for taking that up as well, Jennifer. I would just like to know how much more time you have that you can spare with us so that we know how much more questions to take, because there are a lot of questions from what I see from our
Yeah,
audiences in different platforms. Another 5-10 minutes. I hope you can be with us.
absolutely. Yes, I'm happy to stay on.
Okay, thank you then. Let's go on to take this next one. This is from another anonymous participant. After the I-730 interview at the New Delhi USCIS office, the officer didn't say anything about whether our application was approved or
Hmm.
not. However, they kept our passport and told us we would get them back in a few weeks. Anyone in the same situation? Is it approved or not?
I usually tell my applicants most of the time, whether they're applying for a non-immigrant or immigrant visa, when the government keeps your passport rather than sending you home that same day with your passport, when they keep your passport, that's generally a good sign. Now, there's always exceptions to that rule, if you will. I would recommend, if it's been a few weeks and you haven't received any update, I would recommend contacting the service center directly, or I can't remember where we said this was. I think it was New Delhi. I don't feel like you should have had some sort of update by now, unless your application has been put into administrative processing. But it may be time to follow up with some sort of government officer to do that. And the way to do that really varies based on the agency. I don't know about New Delhi off the top of my head and how you would contact them outside of your scheduling portal. But start with that.
That's a good one. Thank you so much, Attorney Jennifer. So now let's go on to this next one, which is I just have interview for I-130, not I-485. Will it be another interview for I-485 in the future?
So this is a great question. And actually, it's very, very standard for the interview to only be associated to that I-130. And I'll tell you why. Think of, let's assume it's a marriage-based case, which I'm guessing that's the case here. The I-130 petition is what you're putting on record to show the government that you are in a bona fide real marriage. In other words, you're not just filing an I-130 for immigration purposes to get a marriage-based green card. So the interview is tied to that. The interview gives the opportunity for the government to assess you and your spouse and ensure that this is a bona fide marriage. This is not a sham marriage. You truly live together. You love each other. You got married together because you are committed to spending your lives together and not just to file for an immigration benefit. It's very, very rare for there to be a standalone I-485 interview. And so what we usually see is after the interview, the I-130 will be approved, and then the I-485 should be approved thereafter, assuming you're still admissible and eligible for a green card. But the interviews associated to proving the marital bona fides when we're talking about it in the interview in the marriage-based context.
Thank you, Jennifer, for taking that up and for the detailed explanation. Now, this next one is also from an anonymous participant asking I-485 and I-130 filed together. Married to US citizen, legal entry to the USA. Just interview ended of April, I-130 was approved and I-485 is still pending. Anyone have the same issue?
Yeah, this is very standard as far as processing trends and processing times go. I would encourage anyone with a pending 485 to then go on to USCIS, and you can pop in your geographic area, the service center that is processing your I-485, and there are standard processing times. So I'm not surprised by this. They are very rarely issued, I-130 approval, and then boom, your 485 is still pending. It can take several months thereafter, and this is just part of the normal process.
Okay. Well, thank you so much for taking that up. We have Clarissa who's joined us. Hi, Clarissa. Thank you so much for joining us. And Clarissa is asking, EB3 third category, any prediction of movement?
EB3, it depends on it depends on the country, I suppose. Usually, sometimes we can tend to see a week or 2 weeks movement forward. If anything, I don't think it will be any great movement forward, but I would hope to see that come October 1st. And again, October, if you're joining us late, October is when the start of the government's new fiscal year. And so numbers are kind of reset, to put it simply.
Okay. All right, Jennifer, thank you so much for taking that up. And Clarissa, thank you again for joining us with your question. And I think we should take one more of Ricky's questions.
Yeah.
So Ricky's asking, can you give me some idea on the month? Okay, we've taken this. I think, yeah, what can be considered as the minimum high salary, more or less than $200,000 for EB1A petition or for professionals in semiconductor or electronics domain?
Yeah, so the salary item when it comes to EB1 is kind of one of my least favorites. And I think that a lot of applicants, to their detriment, tend to hinge a lot of power in that. It's one that doesn't necessarily hold the strongest weight with USCIS. And I would focus really on some of those other criteria. I'm not saying to leave the salary off, but you want to pull wage assessments for individuals who are similarly situated in your area and industry of expertise. 200 is certainly a strong salary, but that alone is not going to be enough to move the needle and get someone over the EB1 edge. You really want to focus on your work and how other professionals are citing it, something original that you've brought to the domain that is then, very exciting for other leaders within the industry. Those are the sorts of things that USCIS wants to see. The salary really only holds power when you can really justify and articulate a good narrative behind that. Why is this person so above the salary range? A high salary is not going to cut it. You need to justify, like, someone similarly situated is making X and this person is making Z because A, B, and C, which then form the underlying basis of a really good, strong EB1A case.
Thank you so much, Jennifer, for taking that up. And Ricky, thank you for being such an active participant, I would say. I really hope you've gotten all your answers. And, for most of your other questions, or if you want to have a one-on-one consultation with attorney Jennifer Beam, please check out her link, which you can see on the screen, and check her out, maybe contact her. And it'll be best because every case is different and you may want to get a consultation. So I suggest you do that. But thank you so much, everyone, for joining us. It's really lovely to have so many of your questions. I wish we could go on, but somehow it's almost time to end and wrap up. So, Jennifer, maybe if you have any end notes that you want to, say to our viewers out there or our participants who had their questions today, it'd be really nice.
Absolutely. I know the U.S. immigration system is incredibly restrictive. But, slow and steady wins the race. Sometimes it can take years, or months, if not years, to really build a strong profile for EB1 or the NIW. The NIW is in the EB2 track, but it does present some benefits to the alternative perm process, which ties you to a U.S. employer. But again, the takeaway should be, if you don't yet have an established priority date, whether that's through the perm or the EB2 NIW, your priority should be to get a priority date established and then perhaps continue to build your profile and tackle the EB1 criteria. I am taking on new clients. We're happy to have consultations with any listeners. So feel free to email me directly or message me through LinkedIn, and we'll get you squared away. If not with me, I have an awesome team behind me. We have a great team of attorneys who are just fantastic practitioners, and we love what we do. We love helping our clients achieve that American dream. And so please don't hesitate to reach out. Nipasa, thank you so much for having me today. I really enjoyed our chat and time together. I'm honored to be on your show, so thank you.
Jennifer. Thank you so much, Jennifer, as well. It's been really lovely having you, and I'm really looking forward to having you back again already. So I hope we can have you soon on our show. But
Sure.
Girish joined us with another question. If you can spare 2 more minutes, maybe. I don't want to leave
No
him
problem.
disappointed.
Yeah.
So Girish is saying prior 4 to 5 months of visa overstay and unauthorized work, return to home country, then applying new H-1B or L-1 visa. How USCIS looks on them, or they can be addressed through DS-160 for cons interview.
Yeah, that's a tricky one. And I'll be honest. So when it comes to the petition, it may not be an issue at the USCIS stage, particularly if you're already abroad and the I-129 petition is marked for consular processing. What I will say for the L1 is that you do need to have a 1-year period of full-time employment abroad. So I'm not sure how long you were in the United States prior to that. They look at the window for L1 qualifying employment within the 3 years immediately preceding your application date. Something to keep in mind. With respect to the overstay and unauthorized work, that does need to be noted on your DS-160. And in today's adjudication environment, I think that the odds are probably stacked a little bit against you. I'm going to be a straight shooter. The government is not tolerating much of anyone's overstay or unauthorized work. And it is a lot easier for a consular officer to deny a case for these issues than approve them. They have a lot of discretion. And while 4 to 5 months of an overstay doesn't necessarily make you flat out inadmissible or subject to a bar in that respect, a 3 or 10-year bar, it does not necessarily mean you're not going to overcome the presumption of abiding by the terms of your status for which you're requesting admission. And from a consular officer's perspective, they may see an applicant and say, look, this person did not abide by the terms of their initial visa. They worked in the US without authorization when they should have departed, or they should have filed for a change of status. They did not play by the rules. We're not letting them in. So I think that someone in that situation may have a bit of an uphill battle, and having an approved case with USCIS does not guarantee visa issuance and subsequent admission to the United States. It's a multi-step process. So if you have a visa and you're in the United States, make sure you're staying aligned with the terms of your category. And if you are unexpectedly laid off or terminated, definitely consult with an immigration attorney. Consider filing a change of status to that of a visitor to buy you more time. And then determine your next steps. But you don't want to sit tight in the US without taking action when there's been a major change in your status.
Thank you so much, Jennifer, for being such a spot today, and taking up each of these questions. And Girish, thank you so much for joining us with your questions. It was lovely having you as well. And Jennifer, once again, thank you so much for joining us here on Immigration Talk Show. Really such an honor and a pleasure having you today.
Likewise, thank you for having me. It's been fun.
Thank you. Have a wonderful day and see you soon, I hope.
Take care. Thanks,
You
everyone.
too. Thank you, Jennifer. So folks out there, please feel free to contact attorney Jennifer Bean. You can visit the link which you can see on the screen and definitely check her out, especially if you need to have a one-on-one consultation. And thank you, each one of you, for joining us here today. It was lovely having your questions, your participation, all your love and support. Is also incomplete if you do not subscribe to our channel. So check us out. We are at Immigration Talk Show on YouTube, but also check us out. We are on LinkedIn, Facebook, X, and on Instagram. So stay connected with us, and ring that bell icon on YouTube so that whenever we have discussions, you don't miss them. And also, please like and share our content with your friends and folks out there who can benefit most from all these information and conversations we have. So, once again, thank you, everyone. And bye for now, though. Stay tuned on Immigration Talk Show because there's a lot more coming. And this is Nipasa saying bye just for now here on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Hello and welcome everyone to Immigration Talk Show. I'm Nipasa. I'm going to be a host for this session that's lined up, and I'm very excited. I hope you are as well. It's going to be a very interesting session as we've got a very important guest who's going to be joining us in a short while. And before we start off with our session for, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. Let me tell you that I've got good news that you can also participate in this session with us by commenting wherever you're watching us. We are live right now on YouTube, but you can also check us out on LinkedIn, Facebook, X, and on Instagram. Stay connected with us. And also, don't forget to ring that bell here on YouTube so that whenever we have discussions like these, you're notified. And another good thing is you can call us, dial in this number, and you can join us on call. The number is 425-436-6335, and the access code is 988-888. So, friends, yes, without further ado, please help me welcome our guest for today, none other than Attorney Chand Parvataneni from SPB Law Firm, Dallas, Texas. Hi, Chand. Really good to have you back again.
Thank you, Nipasa. Yeah, really good to be back, and hopefully we'll have a very productive session today. We'll talk about the Visa Bulletin and how it's impacting people's ability to immigrate to United States, how long the processing times are, how for some people it is like really bad because some things are based on the country of birth, not on country of citizenship, etc. So we're going to talk about a couple of issues regarding the Visa Bulletin, the kind of timelines people are seeing before they can get a green card. That's one topic. And another topic is compliance regarding I-94. It is very, very important that people look at their I-94s. And there is a lot of confusion. We are seeing a lot of cases where people accidentally, they did not realize that their I-94 is expired. And there is a reason for that. People have their H-1B approvals. Then there is a CBP I-94. And sometimes people get confused. And many people, not intentionally, but accidentally, they get out of status. So it is very important. People have to look at their I-94s. There are very, very strict regulations on when somebody becomes out of status. There is something called last action rule. So we will talk about the importance of I-94 and how everybody should look at their I-94s, know what I-94 to look at to ensure that their status is always legal in the country. Because if they ever fall out of status, they are jeopardizing their careers, their immigration approvals in the future. So we'll talk about those I-94s and what people should do to ensure their status in US is always legal.
I'm ex- I'm really excited, Chand, for today's session, and I'm sure folks out there as well are very excited because I can already see, Ricky. Hi to you. He says hello, and Rag says hello, Nipa and Chand. Really good to have you both join us. And Ricky, thank you for your questions as well. We are going to take them up a little later in the show, so stay with us. All right. And Chand, yes, the visa bulletin just got out, so definitely a lot of people are having a lot of questions in their mind because they have been waiting since forever. They feel, no matter how long you have to wait, it feels very long all the time. So I have
Yeah.
this first question. If you can tell us, for family sponsored applicants from India and China, we are seeing around 9 to 19 years of wait time. And why are these timelines still so long? And
Yeah.
if there is any chance that they might improve.
Sure. So when we talk about the timelines, typically when we talk about family-based immigration, it is always China, India, Mexico, and Philippines. These are the only four countries that are heavily impacted. And the reason for that is there are a lot of these countries. The populations are large, so you have more people in the countries. And then on top of that, when you talk about Mexico or Philippines, they have a lot of family immigration to United States. And when we talk about family based immigration, so there are four kinds of family based immigration. Uh, so when we talk about immediate relatives refer to the spouses of US citizens or parents of US citizens. So spouses or parents of US citizens do not have any problem. They don't have any wait times. And when we specifically say family sponsored preferences, there are four categories. So one is F1, the other one is F2, F3, and F4. And F1 refers to the sons and daughters of United States citizens who are unmarried. F2 refers to the spouses and children of green card holders. So you have a green card holder in the United States and their spouse or their child is in some other country and they need to apply for a green card for their spouses. So that is F2 category. And then you have the siblings of US citizens. So you have a US citizen, they can sponsor their siblings, their brother or their sister, and so on. So that is the F4 category. And usually, I mean, the timelines are extremely bad. The numbers that you just referred to, and the reason for that is there is a fixed quota. So every year there is a limit on how many number of people can come into this country in these categories. And what happens is the demand, there is too much of demand, and it exceeds the number of visas that are available, the number of green cards that are available under these categories. So when you're talking about, for example, India, so in India, if you have a US citizen and the US citizen is trying to apply for his sibling, brother or sister, so people who have applied a long time back in 2006, in July of 2006, those people are getting the green cards right now. So what that means is we're looking at about 18 years. So almost 18, 19 years. So if somebody who is a US citizen in 2006, they applied for their sibling in 2006, their siblings are getting the green card right now. And similarly, China, it's almost 2008. So almost again close to 16 years. Mexico is even bad. So siblings for any citizens who are US citizens, but their siblings are in Mexico, it's almost 24 years. So almost 24 years. The wait time is almost 24 years right now. So what this means is uh, the quotas, we have limited quotas, and you can, by law, by regulations, you cannot exceed those quotas. So Department of State, the consulates are limited in only approving those number of visas per year. And when you have more demand from certain countries, because again there are something called country quotas, every country can only get 7% of the quota that is available. So once you hit that 7% quota, that country stops. You cannot give more visas than allowed. So this per country quota limits are causing a major issue to these four countries: China, India, Mexico, and Philippines, when it comes to family-based immigration. And going into the future, I don't think there'll be any kind of an immigration law that would change on the family-based side to increase these quotas, because there is nothing, no bill that is outstanding that is pretty recent where they're talking about increasing their quota, these quotas, these family-based quotas. So what this means is, until we probably have any kind of an immigration law passed, we will continue to see this extended wait times, and until these country quotas are either removed or the numbers are increased, we do anticipate to see this kind of wait times at least in the next couple of years.
Absolutely. Thank you so much, Chand, for putting this up, because, many hopefuls out there keep asking, are we going to have better news in the next visa bulletin or the next one or before the fiscal year this time? But seems like it's not going to change too soon. So thank you at least for being so clear about that. And Chand, looking at the EB2 and the EB3 for India and China as well, the wait is around 12 years. And what is your advice for people in these categories who are stuck in the backlog? And if they can switch categories or upgrade their cases, what do you advise?
Sure. So again, when we come to the EB2, EB3, or EB1, the employment-based categories, again, the wait time is pretty bad. And again, in general, what happens is the fiscal year for USCIS, for the government agencies, starts from October 1st. So what that means is, when you have the green cards, what USCIS does is, when it's the first fiscal quarter, the first fiscal quarter starts in October 1st. So October 1st is where all the numbers are opened up, and the numbers, as we go through the quarters, the first quarter, second quarter, third quarter, the numbers are getting depleted. And when we come to the final quarters, so right now the July bulletin got opened up. So July, August, September. So this is the final fiscal quarter for the year. Normally what happens is, most of the numbers are already used up, and it's only in October that we get the numbers back again. So historically, it is pretty normal that when it comes to the end of the year, end of the fiscal year, so theoretically, July, August, September is the fourth quarter, the final fiscal quarter of the government fiscal year. So the visa bulletins normally don't move. So last month and the month before that, and the July bulletin that just came out, it is kind of pretty disheartening, because we have not seen any kind of a movement. And if you look at India, the only dates that have moved are EB3, and even EB3 only moved by just 1 week. It is in 2013. So from April 15th, 2013, it went to 22nd April 2013, just a week. So it is not really great movement. The other categories, EB1, EB2, the other categories, they have not even moved yet, not even a single day. So again, the main thing is, everybody's watching out for the October visa bulletin. October visa bulletin will definitely see some kind of a forward movement. It will not be very, very substantial, but definitely not what we are seeing in the last couple of months. So in terms of what people can do, because the EB categories are backlogged, again, we are running into the same problem. There is a limited number of green cards that are available. So we have 140,000 per year. That is what is available in the entire EB1, EB2, EB3, EB4, EB5. And out of that 140,000, for example, India is only eligible to get 7% of that quota. And the reason for that is, green cards are based on country of birth. It is not based on citizenship. It is based on country of birth. So if somebody was born in India or born in China, so right now, even if they became a citizen of Canada or became a citizen of Australia, it does not matter. It is based on country of birth. So when you have your birth from one of the countries where we have a huge backlog, like India or China, so the other options that are typically available are, people should be looking at EB1 option. EB1 definitely has faster movement. The other option is EB5. So what a lot of people are doing nowadays is, they're really exploring at EB1 option. They're really exploring at EB5 option. And when you look at EB5 option, EB5 option, there is a $800,000 investment, and then there is $1,050,000 investment. So there is something called set aside categories. So the EB5, if you are looking at the set aside categories, the dates are still current for all the countries. So even if you're from China or from India or any of these backlogged countries, if you're investing into EB5 but only the set aside categories, the dates are still current. But if you're investing into the EB5 unreserved categories, the dates are backlogged for India. So anybody that is exploring at a faster green card approach, definitely look at the EB5 option, but look at the set aside categories. When we talk about the set aside categories, we're talking about the rural category, we're talking about the targeted employment category, or we're talking about the infrastructure category. So that is one option that a lot of people have been exploring in the last couple of months. EB1, I'm seeing a lot of people become successful in the EB1 option. So when we talk about EB1 option, we're talking about EB1 extraordinary ability, which is EB1A, where I'm seeing a lot of people explore the EB1A option. The reason is, if you look at people from India or China, they have been in this country for such a long time, 10, 15, 20 years. So they have contributed a lot, and not only contributions, it is all documented. Maybe they have published papers, maybe they have attended a lot of good conferences, they've presented some good papers in the conferences, maybe they wrote some papers. Some people have applied for patents. So in the last 10, 15 years, if somebody has been in US making very, very good salary, they're highly respectful in their profession. EB1A, extraordinary ability, is a good category. So that is something what everybody should explore, especially if they have good resume to back up. So when we talk about good resume, we're talking about a high salary. We're talking about, do you have any papers? Have you been a judge in any conferences? Have you talked in good conferences? And do you have some contributions to the industry that are very valuable? And when we talk about contributions, the government, they're really looking at some targeted occupations. So if you're working in, like, some say data science, artificial intelligence, something that would really help the nation, the country, you will be given a preference. So always, if you do think that you have extraordinary ability, that is something for you to explore and see if you qualify for EB1A. There is also EB1B, which is for outstanding researcher. So if you have like a PhD and you have good research going on, EB1B is a good option. But normally I've been seeing EB1A being more available for people who are in the IT industry. And also EB1C. So if you're working in a managerial capacity and your company is a multinational company, your company has offices abroad. If you work as a manager abroad for at least 1 year out of the last 3 years, and then you want to come back to US and then work in US in a managerial category, EB1C is a great option, and a lot of people have been exploring the EB1C option. So this is something that I think all of you should explore. And we also have the EB2, EB3 downgrade and upgrade. But again, EB2 is pretty bad. EB3 is pretty bad, because EB2 and EB3 both are extremely backlogged for India. The downgrade option right now is not a great option, because both EB2 and EB3 are at a similar point in 2013. Both are backlogged. So the downgrade option that did work for a couple of folks a couple of years back is not really a great option. So again, anybody that has an approval under EB2 or EB3 category, an I-140, if you do apply for EB1 category and you do get an approval, what USCIS would do is they do something called porting of your priority date. So what that means is they will take your EB2 or EB3 priority date and they will put it on your EB1 approval. So anybody that qualifies for EB1 right now, if you do EB1, you can take advantage of porting of the priority date. Okay, so by taking advantage of the priority date, so whatever was your EB2 or EB3 priority date in the past, you can get that ported over to your EB1 approval. So I think that is the best option that I would advise people in this backlogged areas to take a look at. Look at EB1A option, look at EB5 option. And right now, EB5 I think is a great option, but I think even EB5 in about probably 6 months to 1 year, you will see a retrogression. So if you are interested in EB5, I think now is a great time. But again, EB5 is not easy. You have to spend a lot of money. And not only that, you have to do a lot of vetting. You have to look at the project. You have to really be comfortable investing into that project. And that takes time. So anybody that is thinking about EB5, start your research and try to look at a lot of projects. Don't look at one EB5 project. Look at multiple EB5 projects, so you can analyze the risk and see what works out for you.
Thank you so much, Chand, for giving us that advice. I think this is what people wanted to hear as well. So thank you for that. And there is so much more to talk about. I just quickly want to say hello to Karthik. I am Ugandhar. RK, thank you so much, Jadav, for joining us. And we are going to take up your questions a little later in the show. But for now, stay with us. And I hope you're enjoying this conversation we're having with Attorney Chand Parvathaneni. So please do not forget to subscribe to our channel if you haven't as yet. To all viewers out there, and yes, also ring that bell so that whenever we have discussions like these, you're also notified. And yes, check us out not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram. So also, if you want to have a consultation with Attorney Chand Parvathaneni, maybe you need some advice or some guidance on your visa. So why not contact him? And you can check out the contact details in this link which is displayed on the screen. Okay, Chan. So I wanted to talk about for Mexico and Philippines. Some family-based categories show wait time over 20 years, and it's really very long. So is there any realistic legal workaround for families who don't want to wait that long, by any chance?
Sure. So, for anybody who's going through the family based immigration from Mexico or Philippines, the good thing for them is their employment based categories are not as bad as their family based categories. So, anybody from Mexico or Philippines who have a case pending under family based, they should be looking at employment based immigration because their EB2, their EB3, their EB1 is not as backlogged as the family based. The employment based is backlogged heavily for India, but not for Mexico and Philippines. So that's something what they should be looking at. Definitely see if that is an option. And another one they should be looking at is looking at family based immigration or immediate relative category. So in case they qualify either through a relative or either through marriage, immediate relative category is one option because sometimes people get married to US citizens. Sometimes uh, something else happens. So immediate relative category is used for the spouses of US citizens or parents of US citizens or children of US citizens. So at some point of time, if they do qualify as an immediate relative, IR, there is no numerical cap and they move like immediately. So if they do qualify under immediate relative category, that's the best option because they simply can convert their F1, F2, F3, F4 to immediate relative. And then that becomes very fast. There is no numerical cap. And what that means is it is immediate. There is no waiting time other than the processing time. So that is one best option. And the final option, it's you can also think about using a non-immigrant visa. When you if you are in the queue for F1, F2, F3, F4, typically there are some dual intent visas. So dual intent visas such as H1. So you can probably still come to US, work in US in a non-immigrant status using a dual intent visa. So maybe that's another approach that some people can take because you might be qualified to work in US. So explore the dual intent visas. So these are some of the ways where you might explore and see if it works out for you.
Interesting. Thank you so much, Chan, for that. And looks good for Mexico and Philippines that they have an option to check out the employment based preferences. So, yes, thank you for that, Chand. And we are here to also discuss about our second topic of discussion today. That is the I-94 and why is it maintaining a valid I-94 status so critical? It's very important. So we will touch up on that as well. But let's quickly take up a few questions from our audience. Let's not keep them waiting too long. So Ricky is asking for those on H1B, is there a way to print I-94 separately apart from it being mentioned on the H1B notice?
Um, so when we talk about I-94, so there are two ways you get your I-94. One is through CBP, Customs and Border Patrol. You just go to the website. You just type in I-94 online. You go to the website and you can get a CBP issued I-94. So the CBP issued I-94, the only information it will have is so anytime you come into the country through port of entry, that is the time the I-94 from CBP gets generated. So whenever you travel into the country, you get the CBP I-94. And when you apply for extensions or when you apply for transfers or when you apply for any petition with USCIS or any application with USCIS, USCIS also issues you the I-94. And that is the I-94 on your 797, I think that you're talking about. And what you should be doing is you should keep a copy of your CBP I-94, which will not change until you travel out of the country and come back. So if you don't travel, that I-94 stays as is. You should keep a copy of that. And then you should also keep the I-94 that is issued by USCIS. And then you should always see what is the latest one. And whatever is the latest one is the valid I-94. And that is something called last action rule. We'll talk more about it in this session. So from your perspective, you keep both the CBP I-94 that you can download at any point of time from the CBP website. And then you will have a USCIS issued one, which will be on your I-797. You should always keep a copy of both of them. And then you should always use the last action rule to determine what is most recent. And that most recent one is the one that you should use.
Thank you so much, Chand, for taking that up for Ricky. And Ricky, I hope you got your answer. Thank you for participating today as well. Let's take up this one from Jadhav now. For individuals transitioning from a non immigrant visa to an immigrant visa, what role does the I 94 status play in that process, and how does it impact the timeline for receiving the green card?
Sure. So I-94 is typically for non-immigrants. So anybody that's in any kind of a visa, they always will have an I-94. And I-94 basically simply says one thing. It will have an end date, and it simply says that you are allowed to stay in this country until that end date. So you always look at your most recent I-94. And since you're on a non-immigrant visa, that is the date you're supposed to depart the country. Unless, in your case, you said you're transitioning from non-immigrant visa to immigrant visa. The way you do it is you file a 485. So if you have a 485 pending, if the 485 is pending, then you are allowed to stay even if your I-94 expires. So if you file your 485 before your I-94 expires, then what it means is as long as your I-485, the non-frivolous application, a legitimate 485 application, as long as it is pending, and you are allowed to stay in the country. So when you're transitioning to immigrant visa, which is basically the green card, it is more about the 485. And as long as the 485 is pending, typically you should be allowed to stay in the country. And in terms of impacting the timeline for receiving the green card, again, 485s come under different categories. It could be for family based, it could be for employment based, and so on. And depending on your category, it takes time. If it is an employment based category, if it is or any kind of a category where your dates are current, more than likely, if your dates are current, 6 to 12 months is what typically you can expect for the 485 to get approved or get adjudicated. But again, sometimes what happens is there is retrogression, the dates go back. If the dates go back, what happens is you will not get a green card. USCIS will not adjudicate 485. They will keep 485 in a pending status. They will let you apply for EAD 765 or 131 advance parole. So you keep using those documents to stay back in the country. And even if your I-94 expires, if your 485 is pending, you can just stay back in the country and work as per your EAD card. You can travel out of the country using your advance parole and keep doing it. So I-94 is more for people who are on non-immigrant status. And if you're on non-immigrant status and you don't have a 485 pending, you do have to make sure that you can't overstay your I-94.
Okay. Thank you so much for taking that up, Chand, for Jadhav. And Jadhav, do not forget to subscribe to our channel. Our handle is at Immigration TalkShow. And folks, you can keep participating, keep commenting with your questions, or you can dial this number 425-436-6335, and the access code is 988888. Join us to ask your questions, and maybe you can treat this as a short consultation with Attorney Chandra Vithaneni as well. So let's go on now and take this question from Karthik. He says, "Hello, Chand. I would really appreciate if you take this question. I was wondering if part time work is allowed on a TN visa. Additionally, can an individual hold two jobs on two different TN visas?"
So when we talk about TN visa and you want to do a part-time job, so you're already in the country on TN, and then you have a second job, a concurrent job. If you want to do a concurrent job, your employer will have to file an I-129. So you're in the country. So either from Mexico or from Canada, you came into the country, you have a TN I-94. And say you want to do a second job, a concurrent job. The way you would do it is your employer has to file an I-129. They do have to let USCIS know it is a concurrent job. So there is an option on I-129 where on the second page where it says what kind of an employment it is. You would have to mark it as concurrent. And then additionally, on the I-129, on one of the pages, page 5, you will be able to let USCIS know it is a part-time job, and you'll also be able to let USCIS know how many number of hours you'll be working in this concurrent part-time job. The thing is, on TN, you do have to get an approval before you can start the job. On H1B, if it is concurrent, you get a receipt, you can start the concurrent job. If it is TN and you want to do a concurrent job, if you do your employer will have to apply the I-129, wait for the approval. Once you get an approval, because you're notifying USCIS, because USCIS is allowing you by approving the TN case, you should be able to do the concurrent job.
Okay. Thank you so much, Chand, for taking that up for Karthik. And let's take this one now from I am Yugandhar. Hi, sir. My H1B petition has been approved on 2024, stamping not yet completed. If I miss this year's stamping, will have to again go for lottery system? That's the question.
Sure. So normally the rule is once you get your petition approved through the lottery, through the process, you are counted against the cap. So the way it works is because you're counted against the cap, you now have 6 years to work on H1B. And if you have not used the 6 years, you are technically cap exempt. So what that means is you don't have to go through the lottery if the case has not been revoked. There is no fraud in the old approval. You are technically cap exempt. Say in 2028, say after 4 years, you have another employer who wants to file a H1B for you. They don't have to put you through the lottery. So they can simply file a H1B, ask for cap exemption based on the fact that you have been counted against the cap. So in your case, you have been counted against the cap in 2024. So based on that, you should be cap exempt. That being said, in case you're out of the country for more than a year, USCIS does allow you to go through the lottery once again and recapture again. You will be able to get your entire 6 years. So, but again, in your case, if there is no problem with the old approval, the approval has not been revoked, because you've been counted in the cap, because you got an approval, a new employer should be able to file a cap exempt petition without going through the lottery.
That sounds very interesting and good news, I guess, for I am Yugandhar. Thank you for participating with your question. And let's take this one now quickly for RK. I hope you're doing good, RK. And he's asking, do you see retrogression on any of the dates for the rest of the fiscal year? Second H1B possible? I think he's talking about the lottery. And do you see companies not filing, which would increase the chances? Lottery.
Sure, sure.
That was in parts, but
So,
I guess you got it. Yeah.
yeah. So when we talk about retrogression, say we talk, for example, we're talking about the dates for India, because India is a country which is like heavily backlogged. The dates are unfortunately extremely bad. I mean, we are looking at 2013. I don't think. I mean, again, even if there's retrogression, I don't think. I mean, there's like nothing else to go back, because since 2020, that is where the dates have been stuck at. I mean, in 2020 during COVID time, the dates went ahead, but again, I mean, again, most of the people from before 2012, they got their green cards, because in 2020 the dates were current for 2012, and so on. So most of the people did get their green cards. So the number before 2013, it is very low. So there are very few people before 2013 who have not received the green card. So there is not really much to retrogress for EB2 and EB3 for India, because the dates are already very bad, extremely bad. That being said, normally what happens is when we go into the last 1-2 visa bulletins of the fiscal year, because September is the last visa bulletin for this fiscal year. So, I mean, even if there is retrogression, I mean, again, it will come back up in October. So October, again, they will move the dates forward. So because the dates are so bad, I don't really think that there is any scope to really send the dates back. So maybe in the last visa bulletin, in the September visa bulletin, maybe they will move the dates a little bit back. But in October, I think they will again move it forward. So because the dates are really so bad, I don't think there is anything to retrogress any further in at least EB2 and EB3 categories. And
Thank you so much. Yeah. Sorry, Chan.
the
Go
other
on.
part of the question, I think, regarding H1B. So regarding H1B, I definitely think there will be a second lottery, because we are seeing a lot of petitions getting filed, but I'm also seeing a lot of petitions not getting filed. Maybe because of the economy, maybe because of various reasons. But because I am seeing a lot of people not file, I do think there's a second lottery. And if you say like, are majority of the people not filing? No, I think majority of the people are still filing, but I at least think that there'll be some percentage of people that are not filing, which means there is a good scope for a second lottery. So I definitely think that there will be a second lottery. I would not say it will be a huge number of selections, but I definitely think that there will be reasonable number of selections, just similar to last year. Because if you look at the last year's second lottery and the year before that second lottery, last year we had a second lottery, but not too many selections. But the year prior to that, we did have a lot of selections. So I think there will be a second lottery, uh, and again, I don't think it will be like too many selections, but at least I think we will see some reasonable number of candidates getting selected in the second lottery.
Yes, looking forward, Chand, and I hope so also. It's already mid June. So, if by any chance we have the second lottery, by when do you expect it to happen?
So normally it will be in the last week of July or the first 10 days of August. If they don't announce anything by first 10 days of August, more than likely you can assume that maybe not. But again, first couple of days of August, starting from end of July to August 15th is when I think you can expect some news about second lottery.
Okay, okay. Thank you so much, Chand, for taking that up. And let's take this one from Rag, and then we'll continue with some of our questions as well. Rag is asking, what are the consequences if I get a concurrent H1B and I work for the second company? Will it have any repercussions with the green card filing or issues at port of entry?
Sure. So if somebody gets an approval through concurrent H1B, all that means is if they want to go ahead and work on that second job, concurrent H1B, they are allowed by USCIS to perform that job. But again, employee does not have to go and start that job. If they don't want to join that job, they can resign. They don't even have to join the job. That being said, from a company perspective, what we always say is if you don't require that H1B, you should be revoking that H1B. The reason is if you keep the H1B active, tomorrow you might have a site visit and then you have to explain. So if you know the employee doesn't want to start, a good practice is the employer should go and revoke that H1B. So the employee does not have to answer in the future what happened, and the employer does not have to worry about having any liability for pay or anything. So, no, there is no requirement that just because you got a concurrent H1B that you have to go and start. Because if you're not interested in starting, let the employer know, and the employer should go through the formal process of notifying USCIS and withdrawing the H1B. That is the cleanest way. But the only time you'll have a problem with USCIS or consulate is if you work without authorization. So if you don't get proper authorization and you start working on a job, that is when you'll have a problem. But when you have an approval, you don't want to start that job, that is fine, as long as you maintain status, which means in your full-time other H1B, you are working as per the required means, you're maintaining status, you're maintaining your H1B status. If you don't start your concurrent H1B, that is fine. Resign that job, let the company know that you don't want to join that job.
Okay, all the best, Rag, and thank you for participating with your question. And folks out there, stay with us. We will take up some more of your questions a little later if possible. But now, Chand, I have a few more questions for you. So if you could tell us, for those with F, J, or M visas whose I-94 says D//S instead of specific date. So, could you explain what that really means and how it affects their stay or ability to apply for a green card?
Sure. So when we see a lot of people, their I-94 will always have like an end date, like somebody on H1, somebody on L1, somebody on any other non-immigrant visa. Typically, you will see an end date for I-94. But when it comes to the student categories, F, J, or M, uh, normally what happens is they will see something called D by S on their I-94. D by S means duration of status. So what is happening is they don't put an end date because they're not really sure when the program expires. For example, somebody is a student. It is very hard to predict the exact end date on their status. So what typically happens is they simply put it as duration of status. And what that means is as long as the student is participating in the program, for example, a student, as long as they're enrolled in the full-time program, as long as their service record is valid, as long as they are maintaining their OPT or STEM OPT, they are allowed to stay in the country. So the minute their student program ends, or their OPT ends, or their STEM OPT ends, that is when their status ends. So because it is very hard to predict that end date on the day of arrival, they'll simply get D by S. So whenever somebody sees D by S, all it simply means is you maintain your F1 status, or your J1 status or your M1 status. As long as you're continuing the program, you are good. The day you fail to maintain status, or the day your program ends, that is the day you fall out of status and you should not stay back in the country unless you have a grace period. For example, F1 students have like a 60-day grace period after their program ends, and so on. So D by S simply means maintain the requirements of your program. The day your program ends, depart the country. And when you talk about green card, before their program ends, they can always qualify for applying for 485. So, for some reason, if the company files for I-140 and they're allowed to file for 485, say somebody's from a country where the dates are the current, they might be able to file for a 485 even while they're on student status, assuming they have always maintained their status in the country. So anybody that is qualified for adjustment of status, they are allowed to file for 485 even while they're on F1, assuming that they have always maintained status, and assuming that on the day of entry, the day of their initial entry, they did not have an immigrant intent. And that is the case, they should be able to file for adjustment of status. So again, the bottom line is anybody that is on F1, always comply with your service. Always consult your DSO. Always make sure that you know when your service is getting terminated. So even though it is saying duration of status, it is not indefinite. It is based on your program participation.
Okay. Thank you so much, Chand, for taking that up for us. And folks, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. And I'm sure if you're resonating with this, do not also forget to share this content with your friends and folks who could benefit most, with our content here and this conversation we're having, of course, today with Attorney Chand Parvataneni. So, Chand, we do have more questions, and I'd like to take this next one, which is if someone overstays beyond the date on their I 94, even by a few days, what are the real consequences? And is there any way to correct it without triggering future issues?
Sure. So normally, what happens is if somebody overstays their I-94, they are at risk. That being said, if you do not cross 180 days, most of the time, if you have some genuine reason, you should probably be able to get through. And I'll talk about some of the ways that we can do it. If you cross 180 days and you overstayed your I-94 by more than 180 days, you are at risk for mandatory bars. And that is when you'll run into all kinds of issues. And normally, what do you do? So, because if it is not intentional and somebody made an accidental mistake and they overstayed their I-94, how do you resolve it? So normally, if I see somebody has not crossed 180 days, the easiest option is you depart the country and then you re-enter the country with another inspection, with another CBP inspection, or you go to the country, go out for visa stamping. If it is less than 180 days, most of the time you should not have an issue. You'll be able to overcome. Either if you need to get a new visa, you might be able. I mean, I don't typically see problems if you don't cross 180 days. If you cross 180 days, that is when you'll have mandatory bars. So what you normally do at that point of time is there is something called NPT, non pro tunc. So there is something called NPT where you go back to USCIS, you tell what exactly has happened, and you prove to them that it is not intentional, and you show them the reasons why this happened. And you also have to show that you're not in any removal proceedings. You also have to show that you have not done any crimes or anything else. So if all is good, this NPT process is a discretionary process. So USCIS normally, if everything is good, they see a good reason, they approve NPT. So going through this NPT process, non-pro tunc, is one way where you let USCIS know and you fix the problem. So NPT is one way where you go back to USCIS, fix the problem. Or the other option is go out of the country, re-enter to get a new I-94. So if you go out of the country, you re-enter, that old issue with I-94 normally is resolved. So in the future, they're not going to come back and cause you a problem if you left the country and you re-entered and got a new I-94 issued to you. So these are the two typical ways that people solve the problems, either by re-entering, getting a new I-94, or by filing an NPT, going back to USCIS and working with USCIS to get an approval for NPT.
Okay. All right, Chan. Thank you so much for taking that up for us. And I also had to tell you that many of our viewers are having trouble locating their I-94 online. So, what are some practical steps that they can take if the system doesn't pull up their record?
Sure. And again, this is very important. Everybody should be able to pull up their I-94 record online because any future extensions, any future applications, you always have to show your CBP I-94. It is very important. And sometimes, if you are not able to pull up your I-94 records, you apply with USCIS. USCIS sometimes will say that they're not finding a record. They could even deny a case. So what you should do is go to CBP online. You just Google I-94 online. You'll see a link, a cbp.gov link. Try to put your passport information and pull up your I-94. If you're not able to pull up, immediately contact CBP. And the way you do it is so the big cities will have a CBP office at the airport. So normally you should reach out to them. You can call them, you can email them, but most of the time they will say, come over to the office, come over in person. So go to the office, let the officer know when you came into the country, the CBP officer, and let them know that your I-94 is not pulling up, and they will be able to assist you. Not only that, sometimes we also see is when people pull up their I-94 records, sometimes some data is wrong. Maybe the end date is wrong. Maybe something is wrong. So it is everybody's responsibility that whenever they travel back into the country, they land in the country, within 2 or 3 days, look at your I-94 record. If you're not able to pull up your I-94 record or you see some issue with your I-94 record, such as wrong end date on your I-94, immediately reach out to CBP. If you reach out to them immediately, they will fix the problem. If you delay the process, sometimes they will cause an issue. So if anybody is not able to download their I-94 record, reach out to the CBP office or let your attorney. I mean, if you're working on H1B, let your company's attorney know about it. And it is highly important that you do have your CBP I-94. Every non-immigrant, anybody on a non-immigrant visa should have their I-94. But if not, there is a way to get it rectified through CBP office. Okay, so make sure you do it. If not, it is going to cause a problem down the line when you apply for extensions.
Okay. Well, thank you so much. It's very important, friends. So I really hope that you were paying attention and taking notes. And even if not, that let me tell you that you can always go back and watch this episode again even after the stream has ended. So thank you for that, and do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also, if you want to have a one-on-one consultation with Attorney Chand, visit this link which is displayed on the screen. So, Chand, we do have more questions and also some from our Facebook groups as well. But before that, I wanted you to tell us, if someone overstays beyond their date, oh, sorry, in one of the real cases, a professional entered the US on an O1 visa, but his I-94 was issued with the wrong expiry date, leading to a 9-month overstay and triggering a 3-year bar. So, what should travelers and visa holders do right after entry to avoid devastating errors such as this one? And how quickly can a mistake like that be corrected if they're caught early?
Yeah. Normally, if you catch the mistake early, CBP will work with you. So, and what that means is everybody, they have this responsibility that they check their I-94. I would say at least 2 or 3 days within their entry into the country. If you check it immediately, normally there are like two options. One, you can email to CBP. Sometimes when you email, they're fixing it. Sometimes they don't. And if they don't, you go walk into the CBP office. So if you entered somewhere, like port of entry, you entered in Dallas, you reach out to the Dallas Fort Worth Airport's CBP office. So they have an address. You look it up online, you'll see the address. You just simply go to the address and talk to the CBP. Let them know this is when you entered the country and you're seeing this issue. If you do it right away, what the CBP officer does is they look at the approval, they look at what's going on. Most of the time, they will fix the problem. It is only when you don't look at, because people do have they are required to check their I-94s. So if they don't check, and it's a long time, and like in this case, they realize after a very, very long time after their I-94 expired. Now, even if they go to CBP office, they will sometimes claim that it is their mistake that they overstayed and cause major issues. So to avoid that, the simple solution is anytime you go out of the country, you come back into the country. So anytime you're coming back from a foreign country back to US, you land into the country. Everybody has to go through a CBP inspection. Everybody, even US citizens, have to go through a CBP inspection because you have to go through the port of entry inspection. So once you come out, any non-immigrant, you simply go to the CBP website. It is online. You just type in your passport number, your date of birth, your I-94 will pull up. Look at the record. If it shows wrong information, or if it does not pull up, simply contact CBP. They will fix the problem. So, I mean, again, it's a good, educational thing, that look at your I-94. There is a mistake. Reach out to CBP, local CBP at the airport. They will fix the problem.
Okay. Thank you so much for taking that up for us, Chand. And also, I had another case study which is from our Visa Bulletin point of view. So let's say a US citizen filed an F3 petition for a married child over 21 years for their son who is in India back in 2013. So according to the current Visa Bulletin, the final action date for F3 India is around 2009, but the date for filing is 2010. So this family is now unsure whether they can begin NVC processing or if they need to wait longer. If you can just walk us through, what these two dates really mean in practice and how families in this situation can, plan ahead, especially when they're stuck and waiting years, after filing is like this.
Right. So normally, when you're going through this F3 process, what happens is you get an I-130 approval, and then it is stuck in NVC, and until the dates are current, they will not even send it to the consulate. So when you see the dates are current, at least in the second chart, that is the time where you reach out to NVC and work with NVC to make sure they're filling up all the documents, they're paying the immigrant fees, and they're working with NVC to send their paperwork to the consulate. And that is what they should be doing if the dates are current. And because that again takes some time for the interview to be set up. And that being said, there is something called Child Protection Act. So according to the Child Protection Act, the dates will be frozen. So even if somebody is crossing 21, based on certain rules, the dates will be frozen. So if some particular things happened in some particular sequence, based on the time they had to wait for that I-130 approval, all that period will be added up. So the first thing they'll be looking at is to see when their actual Child Protection Act's ages, to see if their age has been frozen or not, and then work with NVC simultaneously to get things over to the consulate and get a visa interview. And that being said, it is unfortunate that the dates are so backlogged, more than 15, 16 years for these F1, F2, F3, F4 categories. But again, I mean, all they can do is patiently wait for the visa bulletins. The day they see the date current in the second chart, contact NVC, work with NVC to at least making sure that all the documents are uploaded. They pay the immigrant visa fees on the NVC website, and things start moving towards the consulate. But if the dates are not even current, there is nothing that they can do, and they just have to wait.
Okay. Thank you so much, John, for taking that up as well. And we do have some Facebook questions from our groups. So let's quickly take a few of them first. And this first one is from an anonymous participant asking, we filed I-485 and I-30 concurrently for my parents. We got RFE for not sufficient income and had to co-sponsor my sister-in-law. We have interview in 2 days. What to expect in the interview? I'm very nervous.
Sure. So a lot of, so when somebody applies for a family-based green card, so in this case, U.S. citizen applied for their parents. So anybody that is applying for a green card, we do have to prove that they're not a public charge. So a lot of people think that a lot of these immigrants are coming into the country and the country has to bear all their expenses. No. So the reality is, whoever is sponsoring, in this case, the child is sponsoring their green card. So what typically happens is, to get the green card, they are actually required to show that they have enough finances, enough income to ensure that they don't become a public charge. So they're not a burden on the government. So in this case, what happened is they don't have sufficient income, but the government says that you can always use a joint sponsor. So even if the US citizen does not have enough income, they can always use a joint sponsor. And the joint sponsor, basically what they do is they also sign the I-864 as a joint sponsor. And when they sign the I-864 as a joint sponsor, they show their income. and they will be able to show that because they have enough income and because they are giving those attestations that they will sponsor uh, uh, the immigrants, USCI should not have a problem. So what to expect? So what to expect is they will look at the sister-in-law's income. They will make sure the sister-in-law's I-864 is properly filed as a joint sponsor, and if that is done, they should not have any problem. So I think it is simply the question of having a joint sponsor. In this case, looks like they already have a joint sponsor, the sister-in-law, and by looking at the sister-in-law's income, I don't think they will have any problem with getting the green card for their parents.
Okay. And I think by now the interview is also done. I really hope they got through it. So now let's take this next one. Hello, has anyone had a situation like this? My mother-in-law had an interview for I-485 and was told she was approved at the interview, and few months passed by and was sent a letter that more evidence was required to decide on her case.
Yeah, it does happen a lot of times. I mean, I've seen this a lot because in the interview they say it's approved, but what happens is again something shows up on the background, and more than likely it is something small. Because sometimes I've seen like, hey, can you send us the I-94 from so and so time, or can you show that somebody has maintained valid status from that time, or sometimes something very very simple. So I did have cases where this happened, where at the interview they were said everything was good, and then they got an RFE, but most of the time my guess is that RFE is something very simple because at the time of interview, if they said the case was approved, they probably passed all the background checks, but they found something, and that's why they got an RFE. I would not worry about it. I mean, as soon as you get the RFEs, immediately respond back to the RFE. Most of the time, the 485 RFEs, if you respond back, they are very quick at approving those 485s once you submit all the documents that are required by the RFE.
Okay. Well, thank you so much, Chant, for taking that up. Now, this next one is from Andre. Just a question: what kind of questions should a under 12 child expect at on interview?
Most of the time, because you'll have the parent. I don't think. I mean, I've not seen children under 12. I mean, I've not been in any interviews where a child under 12 was asked any questions. I'm not sure. But I mean, again, I'm not. It depends on the category they're applying, and it also depends on what kind of a filing it is, and so on. But I mean, again, most of the time, I think it'll be on the category. What kind of a category they're qualified uh, for that particular benefit? Is it a parent-child kind of a green card? Is it a green card child kind of a relationship? Or is it like a employment-based 485? Or is it something else? So I'm not sure what exactly is the benefit they're seeking, because a lot depends on the benefit they are seeking and what kind of interview it is. Is it a green card interview? Is it N600 interview? Is it N400 interview? And so on. Because if it is a child and if it is something like an N600, they typically waive those kind of interviews or have their parents come for the interviews.
All right. Thank you so much, Chant, for taking this up for Andre. This next one is from Dave. I am on my 14th month waiting for I-130 to be processed. Is this normal?
Uh, Nowadays, it's normal. I mean, I-130 is like extremely, extremely slow. So previously, when I-130 was done for somebody who's like spouse of a US citizen or parent of a US citizen, they used to be very, very quick. But the I-130 is for sibling quotas, like for somebody who's like a sibling of a US citizen. It used to take time. Even before it used to take like 3-4 years for sibling I-130s. Nowadays, even for immediate relatives as in like spouses of US citizens, even for them, the I-130 is taking a very long time, and I'm not seeing any I-130s, standalone I-130s get processed before a year. And the USCIS website is taking as long as 24 months. So I think anywhere between 1 to 2 years is what somebody can expect their I-130 to be approved, and looks like nowadays it is normal. And what I think everybody should be doing is go to the USCIS website. You will be able to look up the processing times, and processing times differ based on where your I-130 is. There are multiple service centers with USCIS. So look at where your I-130 is and look at the timelines for that particular service center, and you'll be able to know. But again, I think that is what you're seeing is pretty much normal nowadays.
Okay. So delays have become very normal now. Has it doubled by any chance? Like, suppose it was like 6 months back. If it was like 6 months, has it become like a year now?
I mean, it's not anything to do with the current administration because the I-130 backlogs, I've started seeing it like almost like from last
Yeah.
2 years. From the last 2 years, I think things have been pretty slow. So even last year, we were looking at like over a year timeline for I-130s. So I-130s have started going, have been taking a little bit longer time, and looks like, I mean, for the last couple of years, they have been bad. And this year I think it's going to be even worse because all the backlogs are accumulating, and on top of those backlogs you have more applications. So I want that is one thing. Unfortunately, we don't have premium, so things are a little bit slow on that standalone I-130 side.
Okay. Well, thank you, Chan, for taking that up and for the detailed explanation. So, this next one is from an anonymous participant. Is it safe to go to the biometrics appointment with everything that's going on?
So when we talk about biometrics, there are two kinds of things. One is like say the 485 biometrics. The other is very recently, starting from last, I would say 4 to 6 weeks, we have been getting RFEs, and I've seen like a whole bunch of RFEs, probably more than 10 RFEs, where you file for a benefit, either an I-140, either a H4 or a H1B, for example. We are getting hit with this biometric appointment notices. And then when I go back and talk to these people who got these biometric appointments, always, every case that I have dealt with, they had some kind of a brush with the law. Or sometimes like a DUI arrest, or sometimes like driving without a license kind of an arrest, sometimes like domestic violence. So whenever there is some kind of an arrest record and they had some issue with the law in the past, looks like it's flagged. And USCIS, anybody, if anytime they see some kind of an issue, some kind of a criminal record, they're getting hit with these biometric appointments. And I did have like a couple of our own clients call us and say, hey, is it safe? Should I go? Because they know that they had this issue with some kind of a criminal infraction in the past. My answer is, if you're applying for a benefit, like either a H1B, H4, or I-140, you get hit with this biometrics appointment. I mean, I would say it is mandatory. You keep up that appointment. You do that appointment, because what we are seeing is right after they go to that appointment, after a few days, they're getting an RFE, and in the RFE they're saying, yes, we did this background check, because biometrics is used to do a background check. Now USCIS is coming back and saying, yes, we did this biometric with this background check. We are seeing this criminal history, asking us to explain, and more than likely that is what is going to happen. So I do strongly encourage people to follow up with the biometrics appointment, and say in the future you get an RFE because you had something that they found with the biometrics. You follow the legal process, answer the RFE. Again, the good thing is, say you go to the biometrics appointment, USCIS does not see anything incriminating, anything bad, then you're good, you're all set. But again, if they see something, you can expect an RFE where USCIS will ask you to explain that criminal infraction, give all the criminal records. So typically they ask for police records, they ask for all the court records. So you do have to submit all the certified police records and the court records, because these two are independent. And then you have to answer your RFE, prove that you have not done any crime that makes you deportable, because not all crimes are deportable. All crimes are bad, but some crimes are definitely deportable. And your whole thing is, you do have to show USCIS what kind of a crime it is, and do you qualify for any kind of exceptions. So that is pretty much what's going to happen when you see these kind of biometrics appointment that are recently being given to a lot of people.
Well, that was very interesting. Thank you so much, Chand. And I do hope that you have a little more time to stay with us because we have so many questions and I just want to keep going if that's fine a little bit. So this is from Charlie asking, hi, I just filed I-130 for my 17-year-old son and unmarried 24-year-old son. Do I need to file also the I-130A? Thanks.
So typically, I-130A is for the spouses. So when you file for a spouse, I-130 for spouse, I-130A is typically required, not for children. And I've not seen the recent instructions, but typically it's not for the children. It is for the spouses. I might need to check back the instructions, but I don't think it is for your child if you're filing for an I-130.
All right. Thank you, Chand. All right, I think those were some of our questions from our Facebook groups, but we do have from our live audience as well. So let's take this one from Manya. Hi, Chand. This is regarding the H1B amendment. Do I need to file an amendment if I move in MSA? I just moved 6 miles away from the initial work location, which is on LCA. Do I need to file AR11?
So when it comes to amendment, it's location, you're only moving 6 miles. So the only question for you is, are the job duties still the same or not? If the job duties, the work is still the same occupation, uh, you don't have to file an amendment because the move is within the same metro area, only 6 miles away. So check with your employer to see if your duties are different. And if your duties are still the same, your pay is still the same, I don't think you'll have to file an amendment. There is no material change because it's only 6 miles away. But when it comes to AR11, AR11 is your address change. So anytime, anybody, including green card holders, if you ever move your address, even if it is a different apartment number, same apartment complex, but a different apartment number, anytime there is any kind of a residential address change, immediately within 10 days, file an AR11. You simply do it by going to the USCIS website. You can do it online. It is like a 5-minute kind of a thing. So AR11 is like you follow that whenever you change your residence. But amendment is not, I don't think it is required unless, in your case, especially unless you have different set of job duties.
All right. Thank you so much for taking that up for Manya. And Manya, I hope that you've gotten your answers. Folks out there, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And I'm sure, especially most of you who got your answers, don't forget to also share this content with your friends. So we have Sishu from Facebook. Thank you so much for joining us again. And he's saying this is actually a follow up to my question in the previous session. Okay. Welcome back. And a quick recap. The question, I recently had a client change within MSA region. Okay, I think we just took that up. So that was Sishu, I guess. Okay, let me read it anyway. And after considering my scenario, you suggested need not file an H1 amendment but instead do an LCA posting. When I asked employer about it, they mentioned LCA posting will be done only for fresh H1s and not for someone like me. I have my H1 started in October 2024. Would like to verify that info with you. Can you please confirm that? At this point, do I have anything else to do? When I go for the interview for H1 stamping, what documents should I carry as proof of evidence for not filing an amendment? And if you have any other suggestions for me to keep in mind.
Sure. So in terms of amendment, yes, you don't need to do an amendment. But regarding the LCA posting, you can Google it up, and there is a link. There is a clear DOL link where they talk about moves within the same metro area. So they clearly say that when you move within the same metro area, you don't have to do an amendment. So amendment is not required because there is no material change. But there is something called LCA posting. The reason they require that to be done is because people at the new work site, they need to be notified about a non-immigrant working and the conditions for that. So it's a DOL requirement, not a USCIS requirement, but a DOL requirement, and it is out there. There is a link from Department of Labor. So I mean, normally, again, check with your employer's lawyer because they will have that link, and they will be able to send you that link where DOL clearly specifies that LCA posting. So all they have to do is simply put the LCA copy on the wall. That's all they have to do. They don't really have to do anything. It doesn't cost money. It's just a posting, and it is mandatory. There is you can Google it and you'll find that, you'll more than likely find that link on the dol.gov's website. So don't use any third-party links. It is a DOL link. So use that link. That being said, in terms of filing with USCIS, no, you're good. If you have a site visit, you should not have any problem in terms of your H1B employment.
All right. Thank you so much once again, Chishu from Facebook, for participating with your question. And thank you, Chand, for taking that up. And also, Chand, I think before we leave, because with so many people entering through different ports, are you seeing an increase in I-94 errors lately? And what should travelers be especially mindful of, during entry?
Sure. I see a lot of issues. The reason is, I mean, again, what happens is people always think that their H1B approval or their H4 approval has a I-94. So when they come back into the country at port of entry, they just give their passport, and the passport probably has a visa from their old employer, because a lot of times people, they do transfers, and when they do a transfer, they get a H1B approval with a 3-year validity. the visa is probably from an old employer, so the visa will have a different end date. The I-94 has another end date. Sometimes the passports expire, so the passport expiration date is sometimes different. And what happens is when they travel back into the country, they simply give their passport. They simply and the US nowadays CBP, they don't stamp the passport. They simply say yes, you're allowed in, and they expect people to look at their I-94 online. And a lot of times what I see is people just assume that because their H1B approval has a different end date, they assume that the CBP officer also put the same end date on their I-94. But a lot of times what CBP officers sometimes do is they match the end date on your passport, or sometimes they match the end date on your visa. Because sometimes it's a mistake. They don't look at the I-94 on your approval copy. So mistakes happen. So just to avoid that confusion, I do see it all the time. Every week I at least have one case where the employee thinks that the I-94 is till the end date on their approval copy, but the CBP officer shortened the I-94 to the passport expiration date or the visa expiration date. Made a mistake probably sometimes. So people don't realize that. So yes, I do see this all the time, which is why we always have the burden. So like employee, you're traveling back to United States, you do have the burden to download the CBP I-94, because you see a mistake, CBP will correct it. But again, you do have to download and then look at it. In the olden days, what used to happen is they used to give a paper I-94 at the port of entry. You used to look immediately, spot a mistake. Nowadays, because it is online, people are not realizing that. So the simple solution is you come into the country, go to CBP website, download the I-94, keep it with you. Any mistake, they'll resolve it.
All right. Well, thank you so much, Chand, for taking that up, and for patiently actually taking up each of our questions today in this session. I wish we could continue on and on, but I think we will have to leave some of the questions for our next session. And I really hope to have you back soon again, Attorney Chand.
Sure. Thank you so much, Nipasa. It was very nice talking to you.
Same here, Chand. And all the best then, and see you soon. Folks out there, thank you so much for participating as well. If you want to have a one-on-one consultation with Attorney Chand, and you all you need to do is visit this link which is displayed on the screen, and yes, go check him out. Thank you so much, everyone, for joining us. And also, if you have any questions, or you want to get in touch with me for any questions which we can push it to our attorneys, you can reach out to me in my WhatsApp number as well. And my number is 408-335-6444. This is also my dial-in number. You can call me on this number. And my email is nipa@staffingme.com. So feel free to reach out to me. And yes, check us out. We are Immigration Talk Show. Our handle is at Immigration Talk Show here on YouTube. So subscribe to our channel, ring that bell, so that whenever we have discussions like these, you do not miss out on any, because we have very important information to share with all you folks out there. And also check us out. We are on LinkedIn, Facebook, X, and on Instagram to stay connected with us. So thank you once again, everyone, and stay tuned on Immigration Talk Show, because there's a lot more coming. Have a wonderful day.
You know why I'm vacationing in Dubai right now? because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
Hello, everyone, and welcome back to Immigration Talk Show. It's me, your host, Sam. And today we are back again with another very exciting and very important discussion that is lined up just for you. So make sure to watch this session till the end and also participate here by posting your questions on the comment section as we are live here for an hour. And don't forget, friends, to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. Also, before moving ahead, let me read out this very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. And with that, friends, we are also live on YouTube, LinkedIn, X, and do follow us on different social media platforms like LinkedIn, Facebook, X, and also on Instagram as well. And with that, coming back to our today's topic is again very important and very timely one. What to expect when entering the United States for green card holders and visitors. So stepping into America sounds really exciting, right? But the real adventure begins at immigration. Whether you're holding a green card or visiting for a few weeks, what happens at the airport can really make or break your trip because US immigration is no joke. One wrong move and your dream trip can turn into a nightmare. But don't worry, friends, because we have got your back. In this session, we are going to talk exactly what happens when you enter the United States, what questions the officers should ask from you, and also, how you can give the answers, what documents you have to carry, and what are the red flags that you have to look for. And to help me in making this session a wonderful one, I have a great attorney who will be joining me in a bit, none other than attorney Nandini Nair, who is a partner at AY Strauss and leads the immigration practice with over 25 years of unmatched expertise. Her insights have been featured in the New York Times, CNN, Bloomberg, and even more. So I think I'm really excited for this session as Nandini brings up a lot in this webinar. So hi, Nandini, really excited and happy to have you again. How are you doing today?
I'm very good, Sam. Thank you so much for having me. It's a pleasure.
Same here. And also, Nandini, how things have been going. I'm sure, as immigration policies are keep on changing. So how everything is going.
It is really very difficult. I think the rapid pace of changes is, it just keeps you dizzy and it keeps you almost like with a pit in your stomach as to what else is coming next. So I think practicing and, just for the individuals involved in immigration, it's just a very difficult time right now. So, but we will get through it. We will navigate through it as we all have to do that. So, and that's what I'm here for.
Absolutely. That's great. And that's lovely. And friends, the best part is that you can also get in touch with attorney Nandini Nair. You just have to visit this link that is on screen. And you can also go ahead and check on the comment section that is on pinned comment. You can click on that link and get the contact details of her and reach out to her. Ask any question or query that if you want any help or any advice. And with that, I think, Nandini, we have a very important topic and a very timely one too, because from past few months and few days, we have been seeing that even green card holders and visitors, they are also feeling some stress and they are also getting some, difficulties in entering the USA. So firstly, I would like to know it from you, like what our viewers can expect from today's webinar.
I think what's important today is what we're going to discuss is some practical stuff. What is the reality on the ground? Does this type of status provide safety for me? or am I still at risk? Those are all the things I want to discuss today, because I think there needs to be an education for a lot of people about what happens and how, just like you said, one wrong step takes you from being in this country to being permanently barred, possibly, from entering. So I think it's a very timely discussion we're about to have.
Absolutely. All right. So I think, friends, keep ready and, start, noting down all the points, because we have something very important to unpack. And I'm sure this webinar is going to be really very insightful. So with that, I think, Nandini, without any further ado, let me go ahead with my very first question. And this is regarding the green card holder. Because when we talk about green card holders, we think that if they got the green card, they are all set. There's no question, no secondary inspection. But right now in 2025, it is happening. So firstly, I would like to know it from you that what is the reason behind it? Why green cards are going through secondary inspection? Is not a green card enough? Please go ahead.
No, being a U.S. citizen these days is not even enough at this point. No, absolutely not. It does not provide you the safety net that you think it does. And green card holders have been pulled into secondary for decades. It's not something necessarily new, but what it's new is the volume, where, certain things might have been passed through. Now it's not being passed through, and, individuals coming into the U.S. are being pulled into secondary. Why? There's a lot of different reasons. One could be that you traveled too long outside the U.S. as a green card holder. There are limitations to how long you can step outside the United States, and you have to be aware of those things. It's not a free, I'm going to step outside for 10 years and be able to come back in. It does not work like that. There are other times there's a lot of frequency on trips. Again, maybe there is a criminal issue in the background that obviously maybe it ended 10 years ago, but now it's still coming back to haunt that individual. Common is usually DUI, shoplifting, things like that. So there's a variety of reasons. It does not give you the protection of being automatically being able to enter. CBP has every right to question even U.S. citizens if they want to about, their background, about their, history, travel history, purpose of trip, all of those type of things. So don't be complacent is what I would say. Oh, I have a green card, I don't need anything to worry about. In this administration, you absolutely have to worry about it.
That's right. And I think, Nandini, you have mentioned great points. Just to take a follow-up, I'm a little curious if you can let us know the comparison between 2025 and before, how green card holders used to face, these situations, or were they even used to get into these trouble, or how was the situation for them?
I think there was leniency in the past. For example, if somebody stepped out of the country for 7 months as a green card holder, there was a more leniency, like, oh, okay, we're not going to even check about this. Okay, because there's a rule that says, 6 months out, they can question you. Now you are at 7 months, they're going to be like, what were you doing outside that for that long? And they really, delve into your background and find out what were you doing. So that is what I've seen the past, I want to say 6 months, is things that were lenient. There was lenient about things that they just let go of, is not being let go. CBP has been empowered by the Trump administration to use whatever they feel like, to check into someone at this point. So it's a little bit nerve-wracking for anybody who's traveling at this point. And I'm very concerned for anyone who has a criminal issue. That I am advising my clients, do not travel until this administration is over. If you can help it. If there's an emergency, you got to do what you have to do, but try to avoid it if possible.
Absolutely. And I think that is one of the very important pointer. So I'm sure, friends, you are keeping a note of it. And in case if you're having any questions regarding the topic, and please go ahead, put them on the comment section. Don't hesitate, because this is the time you have to be vocal. You have to keep on asking more and more questions. And we are having these very insightful webinars for you guys. Don't forget to subscribe to our channel also, to stay tuned and stay connected and keep yourself informed. Okay, and with that, Nandini, as you have explained about green card holders, right? Now let's move ahead with my next question. And now it is for travelers. So travelers, they are just happy-go-lucky type. They are just packing bags, tying up their shoes, and having a very good positive vibes, to go ahead and have a life in the USA. So, what
Yeah.
is the real purpose that they are also being questioned? So, what can be the reason behind it?
Oh, there's many reasons. Number one is security, right? Every country has a process to vet people when they're trying to come into their country to make sure they're not criminals, felons, they are not terrorists. The various reasons of security. That's a common thing, and it's not unique to the United States. Every country has that. When I travel to any country, they're going to question me as to my background if there's an issue. So that's one. Second thing for tourists, the bigger, or the other question that really comes up is, are you going to be an overstay? What does that mean? Meaning, like, okay, you're telling me, oh, I'm just coming here to tour. I want to go see the Statue of Liberty. I want to see, San Francisco, et cetera, et cetera. But is that really your purpose? Or are you going to just come in? I'm going to let you in if CBP, and you're not going to return. You're not going to go back. So they want to, question the background of this individual. I always tell people who are about 18, let's say 18 to even their 60s, that you are, in the eyes of CBP, a potential overstay. That you have a reason, possibly, and again, it's possibly, allegedly, to come into the United States and never return back. And you're going to say 50, 60, yes, because maybe they have a relative in the United States that says, just come in, you can stay here, don't worry about it. Younger people, come here, work, get a job, do some whatever under the table, things like that. So those are two really big things as to why travelers are being questioned. Security purposes. Second is, are you going to be an overstay and be another individual that is illegal in the United States? Because the United States has a big population of that, obviously, because it's a country that has a lot of opportunities for individuals. So those are really the two big reasons that the questioning happens.
Absolutely. And those were, very insightful. So I'll just say thank you so much, Nandini, for putting up so much important information in, this webinar. It's really going great. And with that, as usual, I enjoy a lot having these lovely conversations with you. And I'm sure our viewers also enjoy a lot. So Rennie is here. Hi, Rennie. Thank you so much. Stay tuned and stay connected. Soon we are going to take up your question. Don't go anywhere, and just wait for some more time, and we'll be coming back to you. Okay, and with that, Nandini, I have another question for you, and that is about Indian visitors, because Indian population is one of the largest population in United States in terms of immigrants. So is it like, do Indian visitors also face more scrutiny at US port of entry than travelers as compared to the other countries? What do you have to say on that?
I would say that there is definitely a bias, and there's definitely a hierarchy of bias. People from Europe probably face less. It's just, and these are just reality on the ground. It doesn't mean, there's any sort of agenda I have behind that point. What my point is that when I see travelers when face scrutiny, generally, again, this is generally, I am seeing individuals of color from certain countries facing a little bit more. African countries, South American countries, Indian, country from India, Bangladesh, from Pakistan, they face those type of scrutinies. Now, why does it seem like Indians are being picked apart a little bit more? Because they travel more, versus an African national, right? They may not even get that visa because they have a high incident of denials in a lot of these African countries, and same in South American countries. Indians have a little bit more ability to get the visa. So it seems like they're targeted a little bit more. But is that the reality of just Indians? No, I want to say you're going to be in the bucket of people of color. They're definitely facing it. The other thing that people who face things are, and how they look at it, is people from certain third world countries, right? CBP believes those are individuals, again, who have the higher intent to be an overstay in the country, and higher intent to bring, maybe like from South America, bring in drugs into the country, other banned substances into the country. It just seems to be, when you look at the statistics, individuals from these type of countries are the ones bringing in these type of things, or having specific issues. And so when you look at it holistically, it just seems that Indians, Africans, South Americans, people of color are just continuing to be scrutinized more than someone from Europe, someone from Australia. I think the reality is that. Is anything we can do about it? Not really. CBP seriously has a lot of power and control, and they have their biases and stuff like that. So
Yeah, that's pretty sad, but unfortunately, we can't do anything. And I'll say that thank you so much, Nandini, for putting up these very important, and I'll say, hidden facts, or I'll say hidden pointers, in front of everybody. And it's very important for everyone to get in touch, with these realities and get a reality check. So yeah, I'll just say that you're doing a wonderful job, and really, great. But with that, friends, I think it's time for a short and a quick break. So don't go anywhere. We'll be coming right back on Immigration Talk Show. It's me, Sam, your host, having a great conversation with none other than Attorney Nandini Nair. Stay tuned, stay connected. Also subscribe to our channel. Our handle is at Immigration Talk Show. Don't go anywhere. We'll be right back just after a break.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
All right, friends, welcome back to Immigration Talk Show. And today we are having a great discussion on the topic what to expect when entering the United States for green card holders and travelers. So till now, we have unpacked some of the reasons behind like why green card holders are being questioned and why travelers are also being, getting the secondary inspection. So with that, I think let me go ahead with my next question. And hi, Nandini. Hope you're doing great and enjoying the session too.
thank you, Sam.
Okay.
Happy to be here.
All right. So let me go ahead with my next question. And this is for you that can a green card holder be denied entry just because an officer feels like, something is off?
Well, I think an individual can be pulled into secondary because something is off, because CBP is trained, to look at certain factors, certain indicators, certain, biases, or certain ways, right? They're trained on that, right? To look at people like that. And so they have the right to do that. So I think they get pulled into secondary because they feel something, right? Now, getting denied is a larger issue. The denied is just not automatic. Have to state a specific reason. Now, what I've seen in my practice is some of these reasons are not valid necessarily, or they are not made up, but they just seem to be off to the facts on the ground. But unfortunately, they have a lot of power. But does CBP, just like a police officer, right? If a police officer is walking by and they see something they feel like is this weird or this doesn't seem right, the CBP has those exact same rights. It doesn't, they can say, hey, I feel like there's something off with this individual and I'm going to take them into secondary. Can they deny entry, like I said, on just that feeling? No. They do have to have some facts in the background and stuff. It's just the validity of those facts is what will change entry to not being sent back home.
All right. I think that was very important because Nandini, most of the time we have been hearing rumors a lot, misinformation and fake news. So people are saying a lot about, immigration system, about CBP officers themselves. So I think, yeah, these were very important. And I hope, friends, you are getting to know about the reality and, just keep yourself updated with all these very important information. And it's better not to mislead yourself. Okay, now let me go ahead with my next question, Nandini. That can a green card be taken away just because someone stayed too long outside the USA, or how is it going to be?
Absolutely. That is a absolute thing that can happen. Green card holders need to understand there is a limitation of how long they can stay outside the United States. So this is what they need to know. You can stay outside the United States for 6 months, up to 6 months without an issue of being able to come back. Generally, okay, again, this is saying that there's nothing in the background, there's no issues, etc. Okay, you're not bringing in, banned substances or anything. 6 months to 1 year, CBP has the right to question you. And if they feel that your answers are not credible or valid, unreliable, they have the right to deny you entry. So 6 months to 1 year. It's not automatic, but they have the right. 1 year onwards, it's automatic. Okay, so you cannot stay outside the United States for that 1 year and be able to come back in unless you have applied and received a re-entry permit. The re-entry permit is something you will file as a green card holder prior to your departure, and you have to do fingerprints and things like that. It can be approved later, but you need to have that in your hand. So let's say it's through, you are on the 400th day of being outside the United States and you're coming back in. You need to have that re-entry permit in your hand at CBP at the airport, for you to show, hey, I took permission. That's how you want to look at it. I took permission from the US government to be outside the United States past 1 year. And the maximum time I can stay, your viewers really need to know, with that reentry permit is 2 years. So it's not 5 years, it's 2 years. Yes, when you come back in, you're here for a little bit. Can you go back for another 2 years? Yes, you can. But there is going to be a period of time where that stops. Generally, I tell my clients the maximum you're going to do is about 3 times. So 2, 4, 6. That's it. Like you come in, you stay for a few months, you go another 2 years, come back, another 2 months. Because if they see this pattern of you keep doing this, you are not considered a permanent resident of the United States. You are just using this as a tourist. It's like you just hop over here and your real home is somewhere else. So yes. And if they continue to see that, they can take away your green card. So you have to be mindful of these rules. What is my time limit that I can stay outside? Once you become a US citizen, you want to stay out for 20 years? That's fine. You can come back in generally, unless there's some, again, background issues. But so that's perfectly okay. So I always tell all my clients, mindful of your green card, try to stay here, get your naturalization done, your US citizenship, 5 years, 3 years, whatever category you're in. Then if you want to go back to India because that's where you want to retire, or you want to go to Europe or wherever you want to go and live, okay. Don't do that because when you get your green card.
All right. All right. That was really insightful. Thank you so much, Nandini. And I'm sure, these other pointers very helpful. And I'll just add on, like, it's not always, yes or no to answer, because right now people are saying that why immigration system are becoming so strict, why scrutiny is happening. So I'll just say that I think, people have also misused a lot of policies, and, at the end, the system also doesn't have any other option. So maybe they are thinking that after, scrutinizing or making things little strict, they can now make the system more fair and more transparent. I just want to know your thoughts. What do you think about it?
I think that's absolutely a fair statement. I think you have it right on the money. I think that the laws are pretty fair. I think when you look at it from top view down, and the reason you're seeing the tightening is because people abused it in everything, right? Whether it's on green card holders travel, whether it's on the work visas, whether it's federal programs. people end up abusing the system, which then forces the government to tighten it. So it's not the laws that are bad, it's the people who abuse it, and then that creates problems for the people who are not abusing it. And it's just that trickle down effect that happens. So, but you're absolutely right. It is, it is the abuse of the systems that causes this.
That's right. Absolutely. And I'll say that, yeah, these were very great points. And thank you so much, Nandini, for putting up them in the conversation. Okay, now let me move ahead with our next very important question. And this is regarding social media.
Mm.
So right now, social media is also trending, because of this topic. So is it that the CBP officers are quietly checking the social media post of each and every green card holders and visitors before they allow them the entry?
They are not checking green card holders of every green card holder that's entering. They don't have the capacity to do that or the bandwidth to do that. There are certain categories like students that they are checking all of this when they apply for visas. But what CBP is doing at the airport is if they feel something is off or they feel something, right? They are taking the phones. They're pulling them into secondary and they are looking at the phones, and they will force you, and you have to comply to unlock that phone. And then they will say, open up your Instagram, open up your WhatsApp, open up your, Telegram, open up Facebook. We want to see what's in there. So that is 100% happening. They also have the ability, if they really feel something is off with an individual, to go and basically pull back some deleted messages. I have people who said, okay, well, I'm going to wipe my phone, before I travel. Well, guess what? The minute you wipe your phone, the CBP is like, why is there nothing on here? That's suspicious, right? Because most people will have something on their phones and stuff like that. So that is not going to solve the problem either. You might add to you sitting in secondary for many, many hours while they try to unlock, the phone, your text messages, or any of those type of things at this point. So yeah, watch what you're putting on social media, go through your maybe history from years ago and whatever's public, out there. Maybe you should delete some of it, maybe not. It all depends on what all you've been saying and stuff like that. But yes, they're definitely checking this, and you must allow them to check your phones when you are at the airport if they ask for it. If you don't, and you say privacy rules and all of these kind of things, you are about to get sent back. So don't think that is going to be the winning argument here. They have a right as an officer of the US government to look at the interests of the United States, and that overrides your privacy. So be mindful of that.
All right. And Nandini, as you're saying, something off. So I just want to get more knowledge on this. If you're saying that if the officers are going to see any traveler or any holder or something off, then what does that mean? Means missing any documents or answering something wrong? If you can justify that something off keyword in a better way, so that will be easier for our viewers to understand.
All right. So let's be practical, okay? The airline you pick.
Okay.
You pick Air India. They know it's all Indians on that plane generally, right? So they're ready. CBP, like JFK, Chicago, O'Hare, they're ready. They're like, Air India is landing. We're gonna have all Indians. They're gonna kind of come together and be like, okay, this is a population that we need to check a little bit more carefully, right? Versus you take Lufthansa, for example, right? And you're the one or two Indians on the plane or something like that. Less potential. Again, these are just practical things I've seen in my experience and stuff like that. I know that I recommend always clients never travel through the Middle East. Never travel on, love Emirates and love all these airlines, and they're cheaper and they have a better route to India. But the problem is you are going to do pre-inspection in the Middle East, in Abu Dhabi, in Dubai, right? And those people are very much unaware of a lot of the rules, right? So you will not have an opportunity to fight your case. They won't let you board the plane. So I always say, Don't go through that route. Don't go through Ireland because that's pre-inspection there. Try to go through a direct flight where inspection is going to be here in the United States. That's another important thing that you need to be aware of. 3 is missing papers, obviously, right? You are not prepared. Clients, I say be over prepared. Be prepared for the worst thing that can happen to you at that airport and make sure you have everything. If they don't ask you a single question, thank God, but always be prepared for the worst things. Your pay stubs, if you're a tourist, I want to see that you have an agenda. Where are you going to go and visit? Did you book your tickets for the Statue of Liberty? Did you book tickets to go to San Francisco and see the Golden Gate Bridge? And if you come in and say, well, I'm going to do it when I get here, that's going to be something that's going to be, not that it's odd, because a lot of people will do that, but you tick it off like, you haven't done all that already? Where are you planning on going and stuff? Be ready for those type of questions, right? Don't be like, oh, my daughter, I'm just going to visit my daughter and I don't know where we're going. No, you better know where you're going. Those type of things.
All right. That's very well said. And I think, these were great examples, and it's very much clear right now for everybody, what does that mean? And with that, I'll say, Nandini, we have a lot of viewers also who joins here, but maybe they're not comfortable, sharing their questions in the comment section. So friends, you are getting this opportunity to get in touch directly with the expert who is sitting right here, none other than attorney Nandini Nair. So you can visit this link, or you can also go ahead and look in the comment section. It's pinned comment, and you'll just have to click that link. Go ahead and ask any question regarding your immigration journey, and I'm sure she would love to help you out. So don't gamble, don't procrastinate. This is the time. Take the stand and ask questions. And with that, I think, friends, I think it's almost time to take another short break. So don't go anywhere. We'll be right back, and keep watching till then, Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
Hello, everyone, and welcome back to Immigration Talk Show. I'm sure this session is very important and giving a lot of insights for you guys. So I'm sure you're watching this session till the end and be with us for another half an hour. Please go ahead, put questions on the comment section. And now it's time to get some questions from our viewers. So I think, Nandini, I have a lot of more questions, but now let's not wait to our viewers too. Okay, Rennie is here. And hi, Rennie. Thank you so much for your participation. I hope you have subscribed to our channel. If you haven't, then please do it right now. Okay, Rennie is asking that I'm a skilled row PD 25 April 2023, almost current in the next Visa Bulletin. My question is, the 4 tool shows Nairobi consulate processing DQ cases of 2023. So how can I expedite my case or change consulate in Mumbai? I think so. I'm reading it fine. I'm so sorry.
No. She's a beneficiary of a green card application, employment-based, I think, skilled, EB3 skilled. And she's thinking that her priority date is going to be current very shortly. So she wants to know, how can I get to the front of the queue when it becomes current? I think that's what she's asking. And really, there's no options. What I try to do is when my client's priority date is current, I have to wait 30 days. Okay. So let's say it gets current in, where are we? July, the August Visa Bulletin. Okay. First of all, nothing's going to happen until August when it actually is current. And then I wait 30 days. And if in 30 days my file hasn't picked up and something hasn't moved on my client's case, then I'm sending an inquiry to USCIS or to maybe the consulate to see if there's any movement on the case. But is there a way to expedite it? Really, no. It's a queue-based system, meaning that whatever they have the file, they sit it like, I got this file, even if it's done the same day, I got this at 101, I got this at 103, 105, and it will go like that where they're going to assign it to officers to review it. Now, you want to change the consulate? Okay, well, here's the thing. You are going to have to file what's called the I-824, changing the consulate for the immigrant visa processing. Let me just say this to you. That is a long, drawn-out process, meaning that the processing time of an I-824 is just incredibly long. And, by the time, you don't want to be in a situation where your priority date retrogresses, while you're waiting for your file to be switched to Mumbai. Maybe once you get the email from the National Visa Center, the recommendation then would be is to contact them. They have emails and try to see if the file can be moved on to Mumbai. That's your best option at that point. File the I-824 as soon as possible, have that receipt notice, talk to National Visa Center that process the interviews and stuff at consulates and see if they will be able to move the file. Let me tell you, moving the file, dangerous also. They can lose the file. I've seen that happen many a times. So my recommendation, if you can get back to yourself to Nairobi for some reason, if you've been there and, for whatever reasons, go to back to Nairobi and just run it through there. Trying to switch it is going to just delay the whole process for you.
All right. Thank you, Nandini, for taking up this comment. And Rennie, I hope you are happy with the answer. In case if you're having any other question regarding the topic, then please feel free to put them on the comment section and we would love to take that. Okay, Imran is here. And hi, Imran. Thank you so much for your participation. He's asking what are the key rights and responsibilities that green card holders and visitors should be aware of when entering and staying in the US? And how can they ensure compliance with US laws and regulations?
Okay, so let's take the visitors first. I think that's a little bit easier. So visitors are visitors. You are here to visit. You are here to tour. You are here to meet family members. You are here to attend a wedding. You are here for whatever that encompasses as you are here for a very temporary purpose. And you are planning to go back. Now, what you should be doing, coming here and then working, somewhere else and stuff, because that's illegal. Right. So what you should be aware of and what you should be compliant with as a visitor is what was the intent of your trip here? What is it that you told the consulate? What is it that you told the CBP when you were entering as to why you were coming? Follow that. Don't deviate from what your intended purpose was and do something that is against the tourist visa or the business visa. I have individuals who come here on a business visa and they're supposed to just attend meetings. And then what happens? They're working. They stay here and they work. And that's illegal. They're not allowed to work. And they'll be like, oh, well, I just needed to attend a customer meeting. No. That's working. That's illegal. Also remember the duration of time you are allowed to be here. Make sure that you don't overstay, even one day. Make sure you depart early. So I have individuals who are like, oh, I can be here till the 10th of July. And they book a flight on the 10th of July. And that flight gets canceled for whatever reasons. And they're like, oh, that wasn't my fault. Will they understand? No, they will not understand. So you book a flight for the 7th. So you build in cushion time in case the flight gets canceled or something happens and stuff like that. Your goal is to get outside the United States by the 10th of July. Now, green card holders. Again, we talked about this, right? You're not allowed to just step out of the country forever or for years at a time. You need to make sure you have the permission of the US government by having that reentry permit if you plan on staying out past 6 months. Now, you cannot use the green card as a visa. Like, I'm just going to come in and, go back, do those type of things. Those are you don't have that right. You should be maintaining a presence in the United States. What does that mean? Bank account, credit card statements, house or apartment or something that shows you are actually a resident of the United States. That's going to help you prove that even though you've taken some of these trips and stuff, hey, I just had to go to India, or because I was selling a property, my parents were sick or something like that, but I'm really living in the United States. So you've got to be aware of all of those type of things. A misstep is not going to be rectified easily, and sometimes it just has such long-term consequences. No attorney is going to be able to unwind that for you. It becomes incredibly difficult. So don't put yourself in that position.
Absolutely. Those were great points. Thank you so much, Nandini, for helping Imran also, and Rennie also for, their difficulties and their complexities. Now, with that, let me go ahead, Cynthia. So, hi, Cynthia, and thank you so much for your comment. She is saying that if a green card holder or visitor is denied entry into the US, then what are their options for appealing the decision or seeking relief? And what are the potential consequences of being denied entry?
Okay. That's a very complex question in the sense of what are the consequences of being denied entry? For example, let me step from there forward. It depends on the reason. Okay, why were you denied entry? For example, they found out that you misrepresented on your application. You committed fraud or something like that. That means you are subject to a permanent bar. So that's not unappealable if you can invalidate those facts or any of that, but if it's real and if it's true, you're done. You're not coming back into the United States. It's a permanent bar. There's no waivers that we can really try to overcome. I mean, there might be, but it's incredibly difficult. Now, if you are denied entry because you're traveling, you stayed out for too long, different story. That's, again, maybe there was a legitimate reason as to why you stayed out for 9 months or 13 months or 15 months. Maybe you were, God forbid, in an accident. You were in the hospital. Those are things that absolutely appealable. So what I always tell people is, if those are questions that are being, and you are get denied entry, do not surrender your green card. Do not sign the 407 form where they're asking you to voluntarily surrender it. No, say absolutely not. They will parole you in, and then they will, send you basically a notice of deportation. But we can fight that in court here. If you voluntarily give up your green card at the airport, we're done. Then we have to prove coercion and all this, and we weren't in the room. So it's really difficult to do that. So I always tell clients, no matter how much they press you, how much they harass you, say no to signing that. They will let you in, but what will happen is you'll get a notice of deportation. That is a fight we can win based on those type of facts.
Absolutely. And those were very important pointers, Nandini. And I think these are the rights, everybody should understand, because right now people are just thinking that, everything is out of control. There's nothing that they can do about it.
Mhm.
But I think, yeah, those were great points. And friends, you still have some rights, you just need to know more and more about what rights you have, what are the legal, information you can have for your side. And it's nothing that, Nandini, people are saying that they are in big trouble or they don't have any other option. So it's like misinformation is also happening, and people are just taking the advantage of their, being scared, and a lot of things are happening. But you're putting up great points, and I'm sure that these, pointers are really helping our viewers to get to know what actually is happening and what people should do right now. So with that, Seema is also here. And hi, Seema. Thank you so much for your comment. Okay, so Nandini, Seema is asking that I accidentally overstayed my visa validity. What steps can I take to rectify the situation and avoid potential immigration consequences, such as deportation or future visa denials?
Okay. So it depends on how long you overstayed. Okay, so if you stayed less than 180 days, generally you'll be able to get through that. There won't be a bar. So there's two sets of bars you have to be aware of. There's the bar for staying past 180 days. It's a 3-year bar from reentry into the United States. You stay past 1 year, it's a 10-year bar. So again, it depends on how long you overstayed. So if you stayed 60 days, you'll be able to get back in and stuff. Will you have future visa denials? It's going to be a little bit of rougher road, sure, of course, because on the DS-160, you do have to show that you did overstay. They're going to find that. And if you don't claim it or be honest about it, that's going to come back to bite you a little bit more. So again, you need to know how long you overstayed and, where the bar sits, right? So if it's at 190 days, you're looking at 3 years. So I always tell everybody the facts matter on your case. Everybody's case is not the same. So if you overstayed a little bit, you should be okay. But if you hit that mark, you're going to have a problem.
All right. Okay. And thank you so much, Seema, for putting up this question. And I hope you got your answer. Now, Nandini Mangu is also here, and he's asking a question. He's saying that I understand that a re-entry permit is only required if you are staying outside the country for more than a year. So has anyone had any trouble for re-entering recently? Okay, and there's a continuation to that. Elderly green card holders facing pressure. CBP has been pressuring them to sign Form I-407 to voluntarily surrender their lawful permanent resident status. Yes, Nandini, please go ahead.
Okay, so yeah, the target has been elderly green card holders because again, they use the green card as a tourist thing, right? And what I see is children are here. They get their citizenship. Then they want to bring their parents over. Parents, whatever, they stay for a certain amount of time until they get their green card, but they never really want to be here, right? They just want to have the freedom not to have a visa, and they just want to be able to come in and out. They're like, I don't want to move to the US. I want to stay in India, all of these type of things. Again, that's not the purpose of the green card. The green card is you are vowing when you get that, you are going to reside in the United States. This is your home. Not India, not Europe, not South America, United States. So when they see, what they do is, they scan the passport, right? You have a bar on your passport. Shows up and right there on their screen, in and out, in and out, in and out. They can see all your travel history. The minute they see all of these things and they look at the time difference, they're going to be like, this is what she's doing. Immediately. It's like, I can see it immediately, right? So then, they're going to be like, then they start questioning them and they're aggressive. They are aggressive. I'm not saying they're nice people. They are generally not. They're mean, they're tough. And so, of course, an older person is going to get scared and they're going to be like, I don't know what to do. I'm just going to sign this so I can at least go back home. And, I'm so afraid and stuff. And that's the whole thing that happens at secondary. But grandparents, parents, big targets right now. So you have to look at that and make some decisions. Is your parent going to come back to the US, or they're going to give up that green card and have to apply for a visa later on if they want to come and visit? Choices, personal decisions that have to be made here.
All right, that's very well said. Thank you so much, Nandini, for making these great points, and I'm sure it is really helpful for our viewers too. Okay, and with that, Jason is also here. And Jason, I hope, Nandini, if you can look to it, that are visa sponsors hurting after the J1 pause?
Of course, everybody is hurting because of the pause right now. Universities are hurting. J1 sponsors are hurting. They're in a limbo. They don't know what to do when everything is actually going to be lifted. Supposedly there's a lift because they're going to vet the social media profiles of these individuals and stuff like that. But that is, it's so silly when I think about it, because these officers at these consulates are already so burdened, with work, right? They're just like overwhelmed. Now you're going to add this that they have to look at. And this is not like there's going to be one little sheet. Somebody could have 5 different social media profiles. They got to go through this, and how long are you going to go back? Somebody's had a social media profile for 10 years. So you are just slowing down the entire process. You're going to see the queues just get longer and longer and longer for these type of individuals and stuff. So if the J1 doesn't come in, like eventually this program sponsors are just going to be like, we can't do this anymore. So yeah, of course, they're all hurting. You're going to see tuition rise for students here because we're not going to have foreign students coming in at the levels we had before. So there's a lot of consequences to all of this.
Absolutely, absolutely. And I think, friends, till now, we're getting a lot of insights from this session, and I'm sure you're enjoying it too. We are here for another 15 minutes, so please don't hesitate. Put questions or your queries on the comment section, and we'll be coming back just after a short break. And the best part is you can also get in touch with attorney Nandini Nair. Just have to visit this link and get her contact details and reach out to her right now. And with that, friends, don't go anywhere. We are coming just after a short break. Till then, keep watching, everybody. Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
All right, friends, welcome back once again to Immigration Talk Show. And this is the last segment of today's webinar that we are going to have. And with that, Nandini, we have covered a lot of viewers' questions and my questions that I have prepared. Now, with your permission, can we go ahead with Facebook questions? Because there are also viewers, who are asking constantly topics regarding green card. So can we go with that?
Sure, absolutely.
All right, that's great. So this is the question that we got firstly from Rebecca. And Rebecca is asking that, has anyone done the green card process by yourself or without a lawyer?
Absolutely. Absolutely. They've done all of that by themselves and stuff like that. Do I recommend it? It depends, honestly. I don't necessarily take a lot of naturalization cases, for example, okay? Because I think that's a simple form that people can fill out, and I'm not here to charge people for that. So I'm like, just do it yourself. It's okay. I don't want to take that case on and stuff. Like, you don't have to waste money on a lawyer for that. Green card depends. Some cases are easy. Some cases you need help. There's nuances. You have to have a better understanding that you may not be able to pick up by looking at the USCIS website or by WhatsApp groups or, Reddit or any of those type of things and stuff. So, but simple answer, yeah, you can do it by yourself. You don't need a lawyer to do this.
Okay, all right.
My recommendation, but yes, you can do it.
Okay, all right. Thank you, Nandini, for taking up this. And let's move ahead with our next question. So we got this question, and it is, hi, I have one query. I want my EVL from employer for POE, and my internal designation is company internal grade based like project manager. However, LCA, petition, job duties, etc. are aligned with client requirement like system test engineer, which I do in my day-to-day job. So is it problematic if EVL says project manager based on company designation system?
Not necessarily. So I see this all the time, right? Because companies sometimes don't have these solid processes, or they have a process where everybody is named a certain grade, and so that grade matches this position, et cetera, and stuff. But the client requirements are different, right? And so they go with the client requirements. When I'm looking for that employment verification letter, that's what an EVL is. And I see that discrepancy. What I actually put in my EVL is I will put the job title from the company, or from the LCA, I should say. And then I will, in parentheses, I will explain internally this position is designated as a project manager. It's it's the functional title, and that's the appropriate word. Functional title at ABC company is project manager. And usually that has been sufficient enough to not cause any problems in the future. So stick with the LCA title and then add this on top of that to explain it.
All right. Thank you, Nandini. Now, let's move ahead to our next question. And this is from Joe. So Joe is asking that, can anyone help me out on how to apply for a green card, please? So many things.
Well, Joe, I don't know what you mean by that. Like, there's many, many ways to apply for a green card, family-based, employment-based. So I think you need to be a little bit more specific on what you're talking about before me to answer and stuff. Otherwise, we're going to be here for a few hours. So if you want to, ask a specific question, more than happy to help you.
All right, no worries, Nandini. And we can ask Joe if you can be a little specific, let us know whether it's a marriage base or through work. Okay, Gora is here, and Gora is saying that, hi everyone, we are in need of getting a temporary green card extension for my dad. He needs to travel to Mexico next week, and his green card expires on the 10th of August. He has filed for his citizenship last September, but still no luck with everything that's going on. So has anybody ever been in this situation or knows what he can do in this situation? Because they are not giving us any appointments. Also, we can't walk in there. Yes, Nandini.
Okay, well, I mean, if he's traveling next week, we're only in July. So when is he needs to come back before August 10th. That's the simple answer to that. If you're not able to get a temporary extension by getting an appointment at the local office. I mean, there's no other thing about it. I would not tell him to stay out of the country past August 10th. Make sure he comes back like by August 8th. Emergency, it's only July, 2nd at this point. So again, you can try, what I try to do is you can go to the USCIS website, use the chat, Emma, and try to explain maybe as to if there's an emergency requirement as to why he needs to stay past August 10th or something, like maybe, some operation or whatever the situation is and stuff. Through the chat, I've seen a little bit more success than calling the number. See if anything can work like that. But otherwise, my recommendation is come back before August 10th.
All right. Okay. I think these were the questions, or do we have more question control? I think no. Okay, these were the questions we got from Facebook. So thank you so much, Nandini, for putting up these questions. And we have one viewer who has joined us. So Ricky, absolutely, we are going to take up your comment, but you are a little late. Go, when we are going to end this session, then please go ahead and watch this session from the beginning, as this is going to be very important. Okay, so Nandini, Ricky is asking that our WhatsApp calls also subject to social media scrutiny for visas and petitions?
Absolutely, 100%. They're going to look at all your messages, your text messages, your social media profile, WhatsApp. They're very aware that a lot of foreign nationals use WhatsApp, right? Because obviously it's free, and all of those type of things. So they're not unaware of the usage of WhatsApp. So yes, the simple answer to that is yes, that they're also going to look at that to vet your ability to enter the United States or get a visa, or all of those type of things. It's not just Facebook and those type of things.
All right. Okay, that's great. And thank you, Ricky, for being here and participating in this session. And with that, Nandini, I really don't want to say goodbye, but it is the time. It is 1 hour and we didn't even realize it. So thank you so much for being here. And I'm eagerly looking to have another session with you. I really enjoyed this session, so much to learn from you. And it's, again, a great experience. Anything that you want to share without leaving the session, then please go ahead.
Well, first of all, thank you so much for having me. I think what you guys are doing is incredibly good, for the public, and this information sessions that you're doing. There's so much value in this, and I hope that your listeners and your viewers are really taking stock of all of this stuff that all the attorneys, provide We're here to help them. And we are very aware of the situation that's going on at this time. So, please be careful out there. That's all I say, and don't make sure you understand what's going on before you take any sort of action. Don't assume what the world was yesterday is the world today.
All right. That's wonderfully explained. Thank you so much, Nandini, and looking forward to another session with you. Until then, take care, and thank you so much for being here. Have a great day.
Thank you.
All right. And friends, in case if you're having any question or any query regarding your immigration journey, then please go ahead and you can directly visit this link. You can reach out to Attorney Nandini Nair and ask any question regarding your journey, and she would love to help you out. With that, it is the end of our session. I hope you guys enjoyed and learned a lot from this webinar, as this was really important and very insightful. In case if you're still having any queries or any doubt, then post them on the comment section. Even after this live stream ends, we will get in touch with you and will provide you the answer. Thank you so much, everyone, for being here, being a sport. And, it was really amazing and great session, and always lovely to have a discussion with such expertise here. If you want any other topic to have, for our next session, you can also reach out to me on my email address, sam@staffingme.com. And with that, friends, thank you so much. That's all for today's episode. Don't forget to subscribe to our channel. Our handle is @Immigration TalkShow. Stay informed, stay motivated, and keep watching Immigration TalkShow. It's me, your host, Sam, signing off for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome everyone to Immigration Talk Show. I'm Napasa and I'm going to be your host for this session that's lined up. Thank you so much everyone for already joining us, and please feel free to share this link with your friends and folks out there who can join in and benefit most, because it's going to be a very awesome session and a most participative one. So I'm really looking forward for a lot of engagement, because it is going to be Ask the Attorney edition, where you know you can ask your most pressing questions about employment based visas, and certainly they will be answered by our guest who's going to join us. But before all of that, I have this important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So I hope you keep that in mind throughout this whole session. And once again, thank you so much for joining us. This is Immigration Talk Show. Check us out and subscribe to us. Our handle is at Immigration Talk Show. And we are live right now on YouTube, LinkedIn, X, and on Facebook. So check us out and also connect with us. And another best thing is that apart from commenting wherever you're watching us, you can also call us. So dial this number if you want to ask your question directly to the attorney. And the number, you can see it on the screen above: 425-436-6335. And when they ask for the access code, you dial 988-888. And absolutely, our guest for today is going to be very, very amazing. And joining us is the highly accomplished attorney Poonam Gupta, who's a legal expert with over 25 years of experience in US immigration law. So her practice spans not only business and employment immigration, but also includes deep knowledge of intellectual property and litigation, making her, uniquely positioned to address the complex and evolving landscape of employment-based visas. So whether you're an employer, international professional, or student, navigating the US immigration system, I think this is your chance to ask your questions directly and get real-time insights from, well, this seasoned expert. So do not hesitate, drop your questions in the chat, and please help me welcome attorney Poonam Gupta once again to Immigration Talk Show. Hi Poonam, good to have you back.
Hi Napasa, great to be back, and looking forward to an exciting show where we can address some of the pressing questions our viewers may have.
Absolutely. I too am excited, and I'm hoping that they drop their questions soon. But I think as we wait, we do have some questions already, which, our controller can display on the screen. This is from our YouTube channel. So I think they are going to be very relevant and employment based. So, control, if you can please display them. All right, this first one is from Karthi. My H-1B application was selected in the lottery, but my current employer is not filing my petition. Can another employer file the petition for me? June 30th is the last date. Please help.
Karthi, you're in a tough situation, and I'm sorry that your employer's not willing to file the petition for you. If another employer also submitted an H-1B lottery registration for you, then both employers or multiple employers, as many employers as you want, applied for it, then all of those employers would be able to submit a petition for you. It's less than 5 days now for the deadline, but It is possible. If, however, the other employer that is willing to petition for you did not submit an H-1B registration entry for you in the lottery, then unfortunately you may be out of luck. So I hope that you had multiple employers submit the lottery submission for you, and I wish you the very best.
All the best, Karthi, and I really hope that something falls in place for you. But thank you so much, Poonam, for taking that up. Let's go on to our next one. This is from Jaskaran. So, hi, ma'am. I have question about 14 visa. My priority date is 21st June 2006 and 30 December 2024. When I will expect my interview?
So this is actually about a family-based green card priority date. And it is, I am unsure what country they're from. Based on the name, I'm assuming India, but and I'm not sure what December 30th, 2024 is, but based on the Visa Bulletin, they will be able to find out what is the priority date. If their priority date is already current, then they can reach out to the consulate asking for additional guidance. If they have not heard from the National Visa Center yet, then that may be the first stop before they go to the consulate. So there are lots of steps. I would encourage you to work with your attorney. If you don't have an attorney, then please consult with a seasoned professional who can guide you through this process. This is not a time to save money. This is a time where you want to be advised properly and correctly and timely. Otherwise, you may lose out on all the time. You've been waiting almost 20 years, and you don't want to lose out on this just because you don't think an attorney is needed.
Definitely much needed, especially that immigration could be a very, very complex process, especially right now, from what we hear every day with new updates. So it's always best to consult with an attorney, and do check out this link which you can see on the screen in case you want to have a consultation with attorney Poonam Gupta. And Poonam, we have viewers who have joined us with their questions, so I'm very happy that they have. And hello to Ricky, Bhargav, Sakshi. Stay with us. Let's take up this first one. This is from Ricky. Ricky's asking, is there any benefit for one on H-1B visa to consider moving to O1 sponsored by the employer?
Depends on your situation, Ricky. There are some situations where an O1 may be better. Sponsored by an employer, if you are going to an O1 sponsored by an agent that gives you the flexibility to work for multiple employers, that may make sense in some situations. Moving to an O1 sponsored by the employer may make sense in other situations. But if you're already on H-1B, and which is sponsored by the employer, then switching to an O1 sponsored by the employer may make sense only in a limited situation. And there may be a few situations, but the one that comes to mind is where you are running out of your H-1B time and the employer needs more time to complete the firm process for your green card. So there are lots of nuances, a lot of hypotheticals, but by and large, H-1B is a better visa to be on because of its dual intent. One, two, the ability to extend it beyond 6 years, and ability to even file your green card and retain the ability to travel while the green card application is pending. So there are a lot of benefits to an H-1B. O1 has plenty of benefits, but sponsored by the employer, by the same employer, will depend on a lot more facts. So I will need a lot more detail than just that to tell you whether or not it would be advisable.
Right, Ricky, if you have more information that you can share, do let us know. And we are on right now, so we'll be here for a little more time, say almost about 48 minutes to go. So you can drop your questions and let us know more about yourself, Ricky. Thank you so much for your question and for participating. Thank you, Poonam, for taking that up.
Of course.
We got Bhargav now. Bhargav is asking, I'm currently working on an H-1B visa, but my employer is planning to transfer me to a new role within the company. How will this affect my visa status, and what steps do we need to take to make sure everything is compliant?
So, if your employer is transferring you to a new role, they will need to file an H-1B amendment before you are transferred. That amendment should be filed ahead of time and not after the fact, or you may be non-compliant and the employer may be non-compliant. Especially, as Nipasa mentioned briefly before, given the current climate, we want to be extra cautious about compliance, and we want to be sure that we follow all the rules. The rules require that prior to any change in the terms of employment, an employer advise and notify USCIS of those changes, and typically that is through filing an amendment petition with them.
All right. Thank you so much, Bhargav, for participating. And folks out there, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. I hope Bhargav and Ricky are pretty happy with the question, with the answers you've gotten. So also share with your friends and family who can join us and benefit most from this, session that we have today. Ask the attorney anything, especially with regard to employment-based U.S. visas. So well, hi Rag, good to see you again after a real long time. We are going to take up your question, but stay with us. I think it's time for a short break, so we'll quickly go. And Sakshi and Rag, stay with us because we'll pick up your question right after this short break. And yes, this is the Pasa with attorney Poonam Gupta here on an Ask Me Anything session with. So don't go anywhere. Yes, if you want to also contact attorney Poonam Gupta, check out this link which you can see on the screen.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm Napasa, your host, and today we have with us none other than attorney Poonam Gupta, who is a legal expert with over 25 years of experience in U.S. immigration law. And we are having an Ask the Attorney Anything. So please feel free to drop your questions about employment based visas. So ask the attorney anything you wish. And really, Attorney Poonam, it's good to have you. I've been enjoying the session already, and I'm looking forward for more participation from you folks. So share now, ask your friends to join if they have any questions, because this is an opportunity for you. All right, so Sakshi, as promised, let's take up your question. I've been working for my employer on an L1A visa for over a year, but now they want to promote me to a managerial position. Will this affect my eligibility for the visa, and should we be preparing to apply for a green card sooner than expected?
Thank you, Sakshi, for joining and for asking that question. So you said, you mentioned that you're an L1A visa already. I'm assuming that you are already in a managerial role and moving to another managerial role within the company. And that moving to another role does not impact your eligibility for the L1 visa if you're moving from a managerial role to another managerial role, unless it is substantially different and material, unless there is a material change, which is the term of art used by USCIS. Then at that point, there may be an amendment that is required. But if it is career progression and you're moving up the career in your role to a different managerial position, that should not impact your eligibility for the visa. In terms of applying for green card sooner than later, please note that even though you may be in a managerial role right now and you may already be in L1A status, to be eligible for the green card under the multinational manager role category, you need to have been in a managerial role outside the US, and you need to be in a managerial role in the US. So both roles have to be outside managerial, both inside and outside the US.
All right. Sakshi, there you go. I hope you've gotten your answer. If you have more follow up questions, feel free to keep commenting. And thank you so much, Poonam, for taking that up for Sakshi.
Of course.
So, this next one, this is from Rag, and he says, "Greetings, Nipa and Poonam. Good to see you too, Rag. Really, I was saying after a long time. He's one of our regular viewers, but I sort of missed him in our shows. So, thank you so much, Rag, for joining back." And Rag is asking, "Can I manage my startup without taking a salary on H4, no EAD, non-executive CO, no pay?"
So, Rag, thank you for joining and thank you for asking that question. This is a question that a lot of people get wrong, and this is a lot of question that people think they're okay to do. And I'm sorry to tell you that that's not true. What US immigration law requires is that if you are going to work in the United States, then you need to be authorized to do that work. If you are on H4 and you say you have no EAD, which means you have no work authorization, but if you are working, then whether or not you take the pay is immaterial, right? Whether you get paid in the US, whether you get paid anywhere else in the world, it doesn't matter. If you are working in the US, you need to be authorized to work in the US. If your role is a role that would have been a paid position were it not for your special circumstance. So, say you had an EAD, say you were authorized to work in the US, would you be taking a salary? Would this still be a non-executive, non-salaried role? If yes, then maybe it may be possible for you to do. But in 99% of cases, that is not the case. So please be careful in how you interpret the rules and how you interpret the US law, especially under the current environment. You want to be extra careful.
Yes, absolutely. Very well put, Attorney Poonam. So thank you so much for taking that up. And Rag, I already see another follow up. So, okay, let's take it up. If I file the I-485, can I travel with my valid H-1B or H-4, or is an advance parole necessary to avoid secondary at point of entry?
So great question, Rag. This is something again that is causes a lot of confusion for a lot of people. H1 and L1, H4 and L2. These are the only categories that have the ability to travel with a pending green card without the need for an advance parole. If you file for an advance parole and travel outside the US without it being approved, then that advance parole is going to get denied. But is that H-1B and H-4 still going to let you come back into the US? Absolutely. I always recommend that my clients travel in H or L status if they have that status, and to always maintain that status while they have a green card pending. Because you do not want to be in a situation where you lose your H1 or your L1 status while the green card's pending. And if the green card gets denied, then you're left with no options. So always maintain your non-immigrant status, and where possible, travel with the H or the L status and not the advanced parole, because once you enter with an advanced parole, you lose your H or L status for that period. It's not as if you lose it completely and you can never get it back, but it is preferable to travel with the H or L status where it's possible.
All right. So thank you so much, Poonam, for taking that up. And Rag says, thanks, Poonam, for the crystal clear replies.
You're
That's
very
really
welcome.
sweet. Yeah. Thank you. And now, Ganesh, let's take up Ganesh's. Hi, Ganesh. Thank you so much for joining us here on Immigration Talk Show. Tell us where you're from, folks. As you join us to ask your questions, we'd also love to know where you're based. That way, I think we can connect more, and you'll get better answers also. Sometimes some questions also depend on state law, so I think that way. And yes, absolutely. If you want to connect with Attorney Poonam Gupta or have a one-on-one consultation with her, check out this link, which you can see on the screen. And now we have Ganesh's question. He's asking, my manager says the perm process for an EB3 green card always takes years, so I shouldn't bother. Is this really true, or are there ways to speed things up?
Hi, Ganesh. Thanks for joining, and thank you for asking that question. I'm sorry to hear that your manager is telling you that you shouldn't bother. And in all honesty, I would say, if your manager's telling you they don't want to sponsor you for green card, because that's what in effect they're telling you without telling you that they don't want to sponsor you for the green card, you need to find an employer that will sponsor you for the green card. It is true that the perm process currently takes years. The current processing time is upwards of 2 years right now for a perm to process from start to finish. But that does not mean that an employer should not start the process, because if there is no pending green card process for you, then you have no ability to extend your H-1B, which means once your 6 years on H-1B are up, you have to go back to your home country. All your hopes and dreams of building a life in the United States fall by the wayside. So yes, it's true that the green card process, the perm process takes years, but not doing it and not starting the process is misleading to you. And I would encourage you to reconsider whether you want to continue to spend your time and energy at an employer that does not value you.
So true, so true. Thank you so much for that response, Poonam. And sometimes we look for support from the employers we are going to, give our efforts, energy, and all our time to. And when that is not worth it, I think you should be able to read between the lines and just take your next step. Don't wait, because sometimes things will never turn for you in the good direction, especially with employers like that, I think.
Correct. And the critical piece to remember is that for your employers, you are dispensable. Everyone, every single person in any company is dispensable. The business will move on whether or not you are there. So you have to look out for yourself. You have to put what you need to do for yourself and for your family, for your career progression above anything else. And that includes taking charge of your immigration journey. That includes being mindful of what you need to do about being on top of what will get you to the front, to the green card sooner than later. So I would encourage everybody to stay on top and be mindful of what steps they need to take for their immigration journey and not rely on their employers to look out for their best interest, because only you can.
Yes, look out for yourself. Thank you so much, Poonam. That was very nice and very great thoughts. Thank you for sharing them here. I think that goes out to everyone out there. I'm sure that was very helpful. And sometimes these are things you just need to hear from another person. So thank you again, Poonam. And if you want to have a one on one consultation or contact Attorney Poonam for anything, maybe nowadays, especially now that it's very complex, these immigration processes and all your visa processes. So it's always best to get an expert guide you, help you, and direct you in the right path. So check out this link, which you can see on the screen, and get in touch with Attorney Poonam Gupta. All right, so we see Mansi also has joined us. Mansi, let us take your question. Is this still relevant that international students can sometimes be denied entry at US borders, even if they have all the right documentation? If I were an international student and I'm detained at the border, what legal protections do I have?
So, Mansi, thank you for joining and thank you for that question. I'm going to take your second question first. Um, if you're an international student and detained at the border, what legal protections do you have? I will say, and this doesn't apply only to students, this applies to every single person coming into the US. At the border, you have no protections. You have no right to an attorney. You have you are at the mercy, so to speak, of the Customs and Border Protection. They can choose to interpret and basically use their discretion to admit you or not. That is not to scare anybody. That is just the reality that most of us do not experience. The reality, that is the reality, but the other part of the reality is that 99% of the folks do not get to see the negative aspect of this discretion. Most people see the discretion being exercised in their favor and they are let go. So be mindful, be aware of this, and be prepared. Now, coming to your first question, can a student be denied entry even if they have all the documents? Potentially. It depends on what the basis for the government is to deny that entry. We've seen situations where people have worked with staffing agencies that take money to place people, and those staffing agencies are on the government's, red flag list, blacklisted. And if the government sees those staffing agencies on your paperwork, or they get alerted by an agency as to something that you may have been involved with, not you specifically, but anyone may have been involved with, then they may flag you as someone to question and then potentially detain and deny entry. So, as I said, 99% of the people do not experience this issue, but in some situations where there may be something that may be impacting your situation, you may be denied entry. And if you are aware of any situation that may adversely impact, or you've heard of, and the internet is a great thing, and various forums and chat forums and whatever are great because people get to know about all the things that are happening in real time sometimes. So if you've heard of people in a situation similar to yours that are getting detained or are having a hard time gaining entry into the US, it may be worth doing two things. One, talking to that person directly to find out what specifically went wrong for them, what specifically was flagged for them. And two, talk to an attorney to figure out if there is anything. Is there anything you can be prepared with? Is there anything you need to do? Is there any documentation you need to ask? Or if you are detained, what is the way to present yourself and so on? So there are lots of things that you can do, but for the most part, if you have the right documentation, you should not be denied entry. But can it happen? Yes. But does it happen most of the time? No. Most of the time, it's a smooth process. No one has any issues.
Thank you so much, Attorney Poonam, for taking that up. And you also answered in the end some frequently asked questions, especially with all these complexities and the recent news updates we also heard. So thank you so much for taking that up. And Mansi, thank you for participating here on our channel, Immigration Talk Show. So feel free to contact Attorney Poonam Gupta by visiting the link which you can see on the screen. And every case is different, so every case needs extra attention. And for now, though, it's time for another short break. And folks out there, don't go anywhere because we are speaking with Attorney Poonam Gupta. And you can ask your questions about employment based visas. It's an Ask the Attorney Anything session. So it's Nipasa taking a short break for now. Don't go anywhere. We'll be right back on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, after the break on Immigration Talk Show. I'm Napasa with Attorney Poonam Gupta. And today we are taking up questions from all you folks out there about employment based visas. So feel free to participate because this is Ask the Attorney Anything session. And, we are giving priority to all of your questions. So ask your friends to join in if they have any questions about any employment based US visas. We are here for a little more time, so join in to ask your questions. We are live right now on YouTube, LinkedIn, Facebook, and on X. And you can also check us out on Instagram, by the way. So connect with us and join us. Subscribe now and also ring that bell so that whenever we have discussions like these or opportunities like these where you can ask your questions, that you can join us. And yes, you can also join us by calling in and dial this number. The number is 425-436-6335 and the access code is 988-888. So join us, friends. And well, Rag, happy to see you have more questions, so we'll take this up as well. Rag is asking, what the consequences if I get a cap exempt H1B plus a concurrent H1B and I don't work for the second company? Will it have any repercussions with the green card filing or issues at port of entry during travel?
Rag, thank you for all your questions. It feels like I'm giving a law school exam with all your questions. But no, great questions. Jokes apart, great questions. You can get a cap exempt H-1B. You can get a concurrent H-1B. And if you're authorized to work for two companies and choose not to work for the second company, then that second company has to withdraw that H-1B for the company to be compliant and for you to be compliant. There could be repercussions with the green card filing, there could be issues at the port of entry during travel. So it just depends on what the specific situation is, but staying compliant at every step is absolutely critical.
All right. And I see Rag has more questions, but Rag, we will take it up a little later. We also have Gautam, Yuri, who have joined us with their questions. So, hi to both of you. Thank you so much for joining us on Immigration Talk Show. And I hope you have subscribed to our channel. Our handle is at Immigration Talk Show. If you haven't as yet subscribed, subscribe now. So, Yuri is asking, I'm in the early stages of building my business and I'm wondering, does the E2 visa require me to show that the business is already generating profit? Or can I apply as long as I've invested enough to set things up and plan for future growth?
Thank you for joining, Yuri, and great question. Um, the fact that you're asking about E2, I'm assuming you are from a country that has a treaty with the US that permits E2. So with that assumption, getting to your question, your business does not need to be generating profit. You only need to show that you are making the investment in the US with plan for future growth. And the premise is that you are setting up the company, you as the owner, or at least more than a 50% owner of the company, will be setting it up, making that investment in the United States to grow the business. If it's an existing business, then you have to show other aspects, but there is no requirement that the business has to already generate profit for an E2 purpose. Simply showing the investment with the intent to conduct business and a growth plan for the future is sufficient.
There you go, Yuri. You have your answer. If you have any more questions, keep commenting. And if you want to consult with attorney Poonam Gupta, visit this link, which you can see on the screen. And now for Gautam. Gautam, thank you again for joining us. And let's take up your question. I was previously employed in the US on an L1 visa, but my employment was terminated due to company restructuring. My former employer has since revoked my L1 visa. Can I still apply for a new employment based visa such as H1B or O1? And what are the implications of the revoked L1 visa on my new application?
I'm sorry to hear about your situation, Gautam, that your employer terminated the employment due to restructuring and they did not plan to keep you on. You can absolutely pivot to other visas. The H1B would require you to go through the lottery unless you're working for a cap exempt H1B. And the one thing to be mindful of is any time that you have spent in L1 status already counts towards your H1B time. So if you have spent 2 years on L1 status, then you're able to pivot to H1B, then please note that you only get a maximum of 4 years on H1B unless there is a green card that your employer files that gives you the ability to extend that H1B beyond the maximum of 6 years. For an O1, there is no such limitation. You can apply for an O1 if you qualify and meet the criteria for the O1, and then by all means pivot to that application, and there is no implication of the revocation of the L1 or the rescission of the job offer to you in this context. The one thing to be mindful of is you only have a 60-day grace period from the date of your termination of employment. So please be mindful of that date. File for a change of status within that 60-day grace period or leave the country. Do not take chances and stay here past the 60-day grace period. It's absolutely critical that you be mindful of the deadlines and file something before the expiration of the 60-day grace period. And good luck to you.
All the best, Gotham, and I really hope that, yes, you find a good job. All the best for all your future endeavors. So we have Ishita join us, and Ricky also has another follow up. So let's take them up one at a time. Or should we just address Rag's one? I don't want to get you upset, Rag. Thank you again. So, won't a G28 agreement with the attorney work at the POE and CBP?
So, great question, Rag, again. So, a G28, for those that are unaware, a G28 is a form that an attorney files with the government saying that the attorney represents that client. So you could carry a G28, and POE and CBP, I'll expand for those that are unaware, that may be unaware. POE is port of entry, and CBP is an abbreviation for Customs and Border Protection. So CBP are the officers that you meet with when you enter the US at the airport, and port of entry is whatever airport you enter, or land entry, whatever way of entry you're using to get into the US, that's a port of entry. So having a G28, I believe you're talking about my question that I addressed previously about student visas and being detained and having no rights in the US. So having a G28, you can present it to the officer and tell them you are represented by an attorney, but there is no right to an attorney at the port of entry. You can present it and they will toss it aside. They will say there is no right to an attorney. So the only thing you can do is be prepared, have a detailed, thorough discussion with your attorney on what to expect at the port of entry. If you anticipate issues, then go prepared with and have mock interviews and mock prep sessions with your attorney and figure out what is it that you need to be able to present to the government all the information and documents that may be required in a polite, respectful manner. You do not want to be aggressive. You do not want to be pushing back on the government in any aggressive manner whatsoever, especially given the current climate. So G28 is great, but you need to be prepared with your attorney ahead of time, Rag, sorry. It doesn't help you at the port of entry.
Okay. All right. So, Rag, all the best. And thank you so much, Poonam, once again for taking that up. So, thank you again, Ishita, for joining us. We are going to take up your question, and also Ricky, we will take up your question, but it's time for another short break right now on Immigration Talk Show. We are having a very good Ask the Attorney Anything session actually with attorney Poonam Gupta today. And you can ask questions about employment based visas. So keep commenting. We will address your questions very, very soon. Or please feel free to dial this number to join us to ask your questions yourself. The number is 425-436-6335, and the access code is 988-888. Don't go anywhere. Let's go for a short break on Immigration Talk Show. It's me, Napasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm Napasa, and today we are having an Ask the Attorney Anything session, with attorney Poonam Gupta, who's a legal expert with over 25 years of experience in U.S. immigration law. Well, her practice spans not only business and employment immigration, but also includes deep knowledge of intellectual property and litigation, making her, a very, very uniquely positioned attorney to address any of your complex statuses or visa processes. So keep commenting. Feel free to join us to also ask your questions yourself. The number is 425-436-6335, and the access code is 988-888. And we are live right now on YouTube, LinkedIn, X, and on Facebook as well. So check us out and comment wherever you're watching us, and we'll address your questions one at a time. So before the break, I was saying we are going to take up Ishita's question. So, Poonam, are you ready for it?
Absolutely. Bring it on.
Ishita is asking, I'm currently working in the US on an H-1B visa, and my employer has filed a perm application on my behalf. However, due to delays in the perm process, my H-1B visa is set to expire before the perm application is approved. Can I concurrently file an I-140 immigrant petition, and there's a continuation, and an I-485 adjustment of status application while my H-1B visa is still valid? And what are the risks and benefits of doing so?
Welcome, Ishita, and thank you for that question. And obviously, you know the steps in the green card process, but I would like to take a step back and give you a quick 2-minute overview of what the green card process looks like for those that may be not as familiar. So a perm-based green card process has 3 steps. The first step is filing the perm, which in itself is a multi-step process and a multi-year process. Once the perm is certified, then at that point, the employer files the I-140 immigrant petition. And once that is approved, then the employee can file the I-485, which is the application to adjust status from a non-immigrant status to permanent residence. That is, go from an H-1B to a green card. There are very limited circumstances where the employer's I-140 petition and the employee's I-485 can be filed concurrently. So the first premise and the first assumption here is that the perm has to be certified before the I-140 can be filed. So your question about can you file the 485 I-140 while your H-1B is valid, but before you said your H-1B will expire before the perm will be approved. So the I-140 cannot be filed before the perm is approved because the basis for that I-140 is the perm certification. So from that perspective, please be very, very clear that that I-140 can only follow a perm certification. I'll come back to your H-1B status in a minute, but I also want to address the concurrent filing of the I-485. The I-485 can only be filed concurrently when the priority date for an individual is current. The priority date is determined by where the person was born. For anyone born actually anywhere in the world that is going through the perm process, the priority date is not current. It does not matter where you were born in the world, your priority date is not current. So if you're going through the perm process, which means that the employer can file the I-140 petition, but you will have to wait to file your I-485 petition once your priority date becomes current. Now, going back to the H-1B, the question is, How will you stay in the US if your H-1B expires? You have the ability, or your employer rather, has the ability to extend your H-1B if they filed for your green card at least 1 year before your H-1B expired. There are strategies, there are pathways to ensuring that calculation works out in your favor. And I would encourage you strongly to talk to your employer's attorney and figure that out so that you will be able to extend your H-1B until you can file for your green card, and actually until you receive your green card physically with you. So there are lots of steps before you can get your green card, Ishita, but it is a process and you can extend your H-1B. And I know it's a lot of things that I throw out at you and at everyone, but these are nuanced things, nuanced topics that I'm trying to explain in 2 minutes. So if it went right over your head, please talk to your attorneys and they can help you provide more clarity on what is the best path forward for you in your specific situation.
Right, Attorney Poonam, and thank you so much for the detailed explanation, for Ishita. I'm sure everything was clear, Ishita, and if you resonated, please do not forget to subscribe to our channel and also share this content with your friends and folks. And also, contact Attorney Poonam Gupta to get to know further on what you should do for your next steps, maybe. Visit the link which you can see on the screen, and yes, ask your friends to join us to ask their questions as well. So, all right, so we have Sunish, but before that, let's take Ricky's question. Can India born green card holders have dual citizenship? Sorry, citizenship, yeah, Indian and US.
So, Ricky, the citizenship is determined by the country. US permits dual citizenship, India does not. You have the ability to be an overseas citizen of India, but you cannot hold an Indian passport if you take up another citizenship. So the answer to your question is no, but US does permit dual citizenship and there are plenty of people who have multiple citizenships, but India is not one of those countries that permits dual citizenship.
That's very interesting. Thank you so much, Attorney Poonam, for taking that up for Ricky.
Sure.
Now let's go on. Yeah, let's go on to take Sunish. Hi, Sunish. Thank you so much for joining us with your question. And he's asking, I'm interested in applying for an EB5 visa, but I'm unsure about the source of funds requirement. Can I use a gift from a family member or friend as part of my investment? And if so, what documentation and evidence are required to show the lawful source of these funds?
Sunish, thank you for joining and thank you for asking that question. I will give you a one-line answer because I can talk about this for an hour and still may not be enough. But the bottom line is you need to be prepared to show the how the money was earned. So if the money was earned by a friend or family member as their salary, they need to be prepared to show their pay stubs, how it went into the bank, how they saved up that money over time, and how they transferred it to you. This is a very simple, basic scenario. If it's business income, then they need to be able to show on their books no cash. Cash cannot be like if there are cash transactions that are not accounted anywhere and not documented anywhere, that does not work for EB5 purposes. So there has to be a paper trail connecting for how that money was earned to the point where that money will be invested for the EB5 purposes. So, but again, very nuanced, very complicated, and very specific to your situation. Please connect with an attorney I'm happy to recommend a few names if you don't have someone. But I do not handle EB5, but I have plenty of colleagues that do, and I'm happy to make a recommendation if you want some. But please do not try to do this on your own.
Right. Well, there you go. You have the warning already. Do not try it yourself. So, Sunish, you have to contact an expert, an attorney, and why not contact attorney Poonam Gupta? She can direct you how to go about it. And thank you for participating with your question. I hope you are happy with the answer. And it's true, all the funds need to be traced and they all have to be um, good sources, white sources, no black sources, to say the least. Anyway, let's go on now. This is Amor. Hi, Amor. Thank you so much for joining us on YouTube. He's asking, can I use private survey data to serve as a comparative salary data to compare my salary in EB1A? Glassdoor and PayScale are insufficient.
Thank you, Amol, for joining us, and a great question. So private survey data is only acceptable when you're applying for PERM or H-1B in those contexts. Glassdoor, salary.com, PayScale, all of these are not uh, surveys that the government considers accurate or in compliance with the legal regulations for any purpose, let alone EB1A. For EB1A, the criteria is that the individual who's applying for EB1A is compensated at a high level. And the only way to do that is to use, and I mean, maybe it's possible to do a private survey data, but it would have to be compliant. But so far, I have not seen any situations where this has been possible. I would encourage you to use the DOL data, the Department of Labor data. And if you can't meet the Department of Labor threshold for high salary, then I would focus on your energy on other criteria and not rely on that criteria for EB1A. So rely on DOL, in short, rely on the DOL surveys. And if you don't meet the threshold based on those surveys, then try for other criteria for EB1A.
All right. And Amor actually has another question. If my company is small and does not have any award, can I still prove distinguished organization? Thanks.
Potentially, Amal. It is the size of the company does not necessarily matter, but what has the company done? What is the impact of the company? How much funding has the company received? So all that matters more, and it is a contextual question that is better answered when there are more facts. It's difficult to provide you a comprehensive assessment on whether or not you meet those criteria just based on that. If you're looking for EB1A, if I can do a plug, go to my website. I have a free visa, AI visa assessment tool that's free for everyone. There is no obligation. Go to the website and try that assessment tool and see for yourself what chances of success currently you have with your EB1A. So I wish you the very best. And as I said, there is no commitment, there is no cost to taking that assessment. That's just my service to the immigrants in helping them take charge of their journey. So good luck.
That's very nice. So check it out, Amor, and go visit the link which you can see on the screen. And he was also saying my salary is outside the US. Do you want to add anything else to Amor with that?
No, again, if your salary is outside the US, then depending on where you are in the world, you may not meet the US thresholds. And if you're not meeting the US thresholds, then you have to meet the US thresholds to qualify for a US visa and US green card. So you may be doing great work, but it has to meet the requirements for US immigration. And I do realize sometimes it impacts people negatively, but it's US immigration. And those are the rules and requirements we need to follow.
Yes. Thank you so much, Poonam, for taking that up. And well, what can I say? We do have more questions from Ricky, and I think this will be one of our last. So, Ricky is asking, can you give some idea on the monetary charges you would apply for NIW I-140 petition premium refiling with minor modifications?
So, Ricky, it depends on what is it that what the modifications are. And I am more than happy to take a look at your prior filing and see what is it that you're looking at. Please, by all means, schedule a clarity call on my website or a strategy call, depending on what it is, and complete the assessment online and share your petition filings, and we can talk about how I can help you and how I can support you.
There you go. Well, thank you so much, Poonam, for taking up each of our questions, so patiently answering them, and for all the detailed explanation which we all really needed. So it was really lovely having you. Such an honor and a pleasure, really.
Thank you. And thank you all for joining and asking your questions. I can tell you you're not alone. There are lots of people who have similar questions, who are in the similar boat, who are shy to raise their hand and ask questions. So thank you for asking your questions and helping everyone. Um, all immigrants, we as immigrants have to support each other and bring each other forward and up. So good luck to all, and thank you, Nepasa, and to the Immigration Talk Show for hosting this session and giving me the opportunity to help more people. So thank you.
Thank you once again, Attorney Poonam. Have a wonderful day ahead.
You as well. Bye-bye.
Bye. And folks, please feel free to join or visit this link, which you can see on the screen, to contact Attorney Poonam Gupta. And really, if you still have more questions, keep commenting. We would like to address them in our next session, or I will try to push them forward to Attorney Poonam Gupta so that we can come up with an answer for you. So, yes, you can comment wherever you're watching, or also you can message me or call me on my number to ask your question. My number is 408-335-6444, and my email address is nipa@staffingly.com. So this is it. It's a wrap. And thank you so much. I hope you all resonated. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And check us out not just on YouTube, but also on LinkedIn, Facebook, X, on Instagram as well. And share this with your friends and folks so that they can also subscribe to our channel and join us and not miss out on any of our very important and informative content. So thank you once again, y'all out there. Have a wonderful day and stay tuned on Immigration Talk Show because there's a lot more coming for you that you do not want to miss out on. It's Nepasa saying bye for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and welcome back to this very exciting and important webinar that is lined up just for you. Make sure to watch this session till the end, and also it would be lovely if you can participate in this webinar. And also don't forget to like, share, and subscribe to our channel. So before moving ahead, let me read out this very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. All right, friends, with this very important disclaimer, once again, welcome back everyone to Immigration Talk Show, and it's me, your host, Sam. And talking about today's topic is again very important one and a very demanding one. US green cards through work. What are your options in 2025? So, friends, in 2025, getting a US green card through your job can feel challenging because there are so many different categories, rules, and new updates as well. And it is very easy to get confused. But don't worry, because in this webinar, we are going to break it all down for you, from the fastest options to the lesser known ones. We will talk about the popular EB1, the flexible EB2, NIW, also EB3, 4, and 5. So stay tuned, and I'm sure by the end of this session, you will have a clear and a very simple roadmap to make your green card dream a reality. And you know what? To make this session a wonderful one, I have a guest who has an expertise in the employment-based visa category. None other than attorney Jessica Ways, who's a top immigration attorney, also known for helping entrepreneurs, investors, and professional athletes with visas like the E2 and O1A. She is also awarded the 2019 Global Chamber Award for Immigration Legal Services. So it's been a long time, and Jessica is here. So really excited for this webinar. And hi, Jessica, once again, a very warm welcome to Immigration Talk Show. How are you doing today?
I'm doing great. Thank you so much for having me back. Thanks.
That's lovely. And friends, it's our honor to have a show with you, Jessica. And you can also go ahead, friends, just by clicking on this link. You can visit this link and you'll get the contact details of attorney Jessica Ways in case if you're finding any complexities or any difficulty in your immigration journey. She would love to help you out. All right, so Jessica, do let us know more about you. You know, we have been meeting after a month, I guess. So how was your work going? How was everything?
Great question. Well, pretty much every day things are changing in my field. When TPS got canceled for certain individuals from different countries, that affected my field a lot. I'm getting a lot of calls from employers that are trying to work through to figure out ways for their workers to stay here longer or to switch to other categories, or they just want to know what their rights are. Are they complying with I-9? Do they have to do E-Verify again? There's a lot of, this could be a whole nother actually class on E-Verify, I-9, and what employers need to do now because they're nervous. They're getting watched by the government. So there's a lot of that. There's also the new, in April, Trump made mandatory registration for people that are in this country that are foreigners. So everybody has to have their papers in order. If they get stopped for a traffic violation, if they're traveling on a domestic flight, they have to show proof that they have a legal right to be here. So that's also made immigration lawyers tell their clients, like, you really have to have your papers in order. Like, you have to have your receipt notices when you travel, just have to have things in order. So it's definitely keeping us busy. It's been busy.
That's right. And it's us also, Jessica, because every day we have been coming up with so many different updates, new rules, new policies. So, friends, I think this time it is very important to stay informed and stay updated with all the latest news that's happening in the world of immigration. So, kindly go ahead and subscribe to our channel. Our handle is at Immigration Talk Show, and it is very important. So, I hope you won't regret it. Okay, all right. So, Jessica, I think without any further ado, we should directly jump into our questions. And I have so many questions for you. And our audiences are also waiting eagerly to ask those questions for you. So, let me go ahead with the very first one. That have there been any big changes in how USCIS is handling EB1 or EB2 NIW green card cases this year? Are approvals harder to get now, or is it becoming easier?
Wouldn't that be great if I said everything's moving along smoothly and everything's getting approved easier and very high percentages are getting approved? But the reality is it's not. So what's going on is the EB2 national interest waiver is getting harder to get approved. I have some statistics here. It looks like in 2024, the approval rate hovered around 43%, and it was down from, it was 80 to 96% in previous years. So it looks like the denial rates are getting higher. It's getting harder to get approved. Why is it getting harder to get approved? They're asking for a lot more detail. They want more specifics. They want to show how, for national interest waiver, the work that you're going to do is going to be a substantial national importance. That's important to show. They also want, they're saying now that, like, even though the position that you're going to be working for may have national importance, they want it to really, it's the actual position itself, not the job duties of a position, like, okay, those are important job duties, but they want the whole position to have national importance. And I know it sounds like a fine line to distinguish, but they're distinguishing it. So you have to show that what you're going to do is not just going to impact your job and your local community, it's going to impact the whole nation, the services you do. And so they're being much more critical of that. And that's causing, I think, some of the denials. So EB2, national interest waiver, was an easier path for a long time because you avoid the labor certification. But it's hard. It's getting harder. The EB1As, I love EB1As. National interest waivers are interesting too. Can be very interesting cases. But EB1As are people that are in the top of their fields, you know, the extraordinary, like, top 1% of their industry. And so how do you show that? So EB1A is a lot of documentation. It's a very high standard. It's always been a high standard. So I don't think there's been a huge change, maybe a little bit of them being more critical of the EB1As. I think that the EB2s, though, are really getting hit more with the changes in 2025 because they're much more critical of those. That's what I see. I mean, I have a statistic here. I think for EB1As, it was in 2023, 70.5% were getting approved. Now it's about 60.77%. So it's dropped a little bit, but I still think the EB1As, we usually don't take the EB1A cases unless we really evaluate it to determine, do you hit 3 of the criteria strongly? So we're doing a preliminary evaluation right at the beginning. And if we feel that way, then we're going to fight for them. And hopefully we get it approved. So that's the story with EB2s, EB1As.
All right, that's wonderfully explained, and thank you so much, Jessica, for taking up this question and explaining it beautifully. All right, so Jessica, as you have been saying that the process is becoming a little difficult and also scrutinies are happening. So recently we have gotten news where the F1 and the H1B, they have to go through a social media screening process. So nowadays their social media presence and their profile is being highly considered and very important. Are we seeing the similar process that may include an employment-based category, or what is the update for that?
So it's interesting. I heard it more with the F1s than the H1Bs, but it could be that you're hearing from people they're also getting scrutinized through social media. But F1 is because they are concerned. We need to understand their background before we let them come in as a student. So that's why they're doing the social media backgrounds. And they stop the F1 visas processing out of the country. They stop that because they don't feel their systems are in place exactly to examine the people coming in properly. So now they just suggested that we're going to look at social media. But in terms of anyone who's trying for any type of visa, the consulates have a right to scrutinize social media. They always have. They even have a right when you're entering this country. They could say, can you open up your phone? I'd like to take a look at it. Or your computer. I'd like to take a look at it. So I always tell people, like one of my clients said to me, well, I'm not such a huge fan of Trump, and I think I've put that on social media a little bit. I'm applying for citizenship. Do you think that's going to affect my case? And I said to them, that would be a very sad day if you don't have a right to your political opinion. If you're saying something dangerous that's going to harm the country, that's a different story. But just because you don't appreciate, value who's the president of the United States, that should not be a reason that you can't come in. So I think anything's fair game. They're just looking for any violence, anything that, they feel someone would harm the country. And anybody, they can look at anyone's social media if they wanted to.
That's right.
Yeah.
Yeah, absolutely. That's very well said. And I think it's not only about F1, H1B. I think everyone, who is trying to go ahead, live and work in the USA. So, friends, I hope just in the beginning of the session, you are getting a lot of insights from attorney Jessica Ways. And Jessica, all the time, you are superb. You are a great communicator. So I'm sure our viewers are understanding each point of yours. And friends, the best part is, in case if you're having any problem or any trouble in your employment-based visa, then please go ahead and you can visit out this link and get in touch with attorney Jessica, and she would love to help you out. Okay, so with that, Jessica, let me go ahead with my next question.
Sure. Can I just add something also? That we're here as immigration lawyers to protect you. If there's a law, if there's a way to keep you here, we are going to try to do that. We cannot keep you here if you do something unlawful and there's no way to protect you. I've had clients call me up completely desperate to stay here, and I've tried. There's no way that I can help them, but I will try my best. If there is a way, we will try to help you. But if you've been here unlawfully for years and there's no regulations that are going to help you, we can't help you. So that's our goal, is to help you. That's the bottom line. We try to.
That's beautiful. Okay. So now I think let me go ahead with my next question. And Jessica, it is that why are we now seeing green card delays, not just for India and China, because India and China have been one of the top most, I think, like top 5 numbers in terms of getting delayed and backlogs. But it's like people from other countries are also facing the same problem. So what's causing the shift, and what is happening? If you can just let us know about it.
Okay, so there's a lot of different factors here. Okay, first of all, America is still a very popular country to come to. So there are 140,000 employment-based green cards issued per year. Each country has a 7% allotment. So yes, like countries like China and India, where there's like tremendous, there's a lot of people wanting to come here, there's going to be backlog. But now we're seeing other countries as well, because a lot of people want to come here, and we have those limitations. But other factors as well, as we have system issues. There's some inefficiency at the consulate, at the National Visa Center. Some people go back and forth so many times trying to give documents over, and finally when they clear it and the case goes to the consulate needs to go to, then the consulates are backlogged now. Maybe they weren't backlogged, but now they're backlogged. Or their visa number, their priority date was current and now it's not current. So that creates a bit of a mess. Also, there's something called, just made a note here, it's called the Controlled Application Review and Resolution Program. And it's a secret, I don't know if you're familiar with it, a secret security system that the Immigration Services uses to check people's backgrounds. So if there's any delays in that process, that's also going to create, it's called CARP, C-A-R-R-P. And they use this to check people's backgrounds. And some people say they're using it from countries that they suspect more terrorists come from, that they're getting subjected to this more often than others. But it's out there, it's there. Also, more interviews. More interviews are happening. We had heard originally that everyone's going to be interviewed for employment-based green cards, including in the United States, not just at the consulates. But then I've had recently several clients that were not interviewed. And they were like, I'm surprised. I just got my green card in the mail. No interview. So it happens. But all of these factors are causing backlog. And in terms of solutions, well, we can say they need more staff. They need better systems, electronic systems, but it's not going to change the numbers. There's only a certain amount that they will issue of these green cards, employment-based green cards, per country, per year. And unless that changes, there's still so many people that want to come here, and it is backlogged. It's not a good system. No, another way to explain it, it's not a good system.
That's pretty sad, and I hope so that after some time we'll get a system more fairer and more transparent, and let's hope for the best. But okay, I think Jessica, you're not agreeing with the fact. Okay, no worries. So I think we do have a lot of questions, and friends, stay tuned, stay connected. And we will take away your questions, and those questions are also very interesting. Don't go anywhere. It's me, Sam, with my today very special guest, none other than attorney Jessica Ways. We'll be joining in just a minute, so don't go anywhere. Keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI support.
All right, friends. So once again, welcome back everyone to Immigration Talk Show. It's me, your host Sam, and today we are having a great discussion with none other than Attorney Jessica Ways on the topic U.S. through get a U.S. green card through work, and what are your options in 2025. So till now, we have covered some of the basic information, and we will go deeper into the topic. So hi, Jessica, and shall we move ahead with more questions that I have for you?
Sure, this is fun. I wouldn't say fun, but it's informative. But I'm enjoying it.
Okay, all right, that's great. And let me go ahead with this one. So USCIS has stopped requiring COVID-19 vaccine proof for green card cases as of January 2025. So how does this change impact the current and the future applicants?
This is great. This is really great because I can tell you story after story of people that did not file their adjustment status cases because they refused to get the COVID vaccination. I can tell you stories of people that applied for the waivers, medical reasons. It was medical, ethical, and it was also religious reasons. And they went through. All of the waivers went through. I didn't have any problems getting them through. But now you don't need it. You don't need a waiver. You don't need COVID vaccination. They've changed the rules. They're actually making a new form that will reflect that as well, that you have to use. I think it's dated like January 20th, 2025. You have to use a new form as of January 3rd for the medical form for the medical exams. And it really, I think it's going to help a lot. The only issue is going to be is that if you filed a medical exam and your case was denied and you're going to refile an adjustment of status for some reason, you can't use that medical exam. You're going to have to get a new one. So that's a little bit of like for people, they're going to have to pay again, whatever. But overall, this is good news. This is very good news. So cases will be processing and they're not required these COVID vaccinations anymore. So
that's right.
We're happy.
That's absolutely correct. A big point of relief. Okay, and following January 2025 changes to H-1B rules also, because every day, Jessica, we have been seeing new updates and new rules on H-1B visa. So what are the implications for employers in terms of sponsorship and green card planning?
So I would say a couple of things. On January 17th, 2025, I just see my notes here, that immigration came out with some more information about H-1Bs and what they're looking for. So they got very specific with, they want two things. They want more detail in the job description to show that this is a specialized knowledge position. And they also want ability to pay the wages. They want to see clearly that the employer has the ability to pay the wages. Now, those two are just general requirements. Then you get into the nitty gritty. If you have a startup company, sometimes they don't have ability to pay right away. So we have to prove it through investors signing letters saying that we're investing in this company. There are other ways to prove value, that a business is going to have potential value. So that gets a little tricky with newer companies. But detail, we're going to look at some of the trickier categories like tech categories like computer software and other ones that we're like, are they going to come after these market research analysts? Like, we're going to really try to get a lot more job description. And what we do now is we take their transcript from their bachelor's degree and we show all the classes that they've taken and we show how that relates to the position they're going to be in. So we can tie those two in together. And when we do that, we make a very strong case for them. So we're doing that more. I would say also people know as well the registration fee when you try for H-1B lottery, it went from $10 to $250 per person. So that was a change that we saw too. And then also we just see the amount of people that applied for H-1B. Statistically, I have here that it was 470,342 last year. And this year was 343,981. 981. So you had less applicants applying. But in the end, anybody that got the H-1B, now they're thinking, okay, I have the H-1B, how am I going to go to green card? So the whole thing needs to be evaluated together, because if you have an H-1B, a lot of times they want to stay here and they want green card. So whatever you put in an H-1B application, it better be consistent when you go for the green card. And we talk about the whole picture to make sure that, because sometimes they want to use experience from the H-1B for their green card. And there's certain ways you can use that, but we have to set it up properly. So we have to be careful with that, because we don't want them coming back saying, we did a beautiful H-1B for you, but now my green card, I'm stuck. I can't put it together properly. So it's very important, the strategizing of everything. And again, we focus on if there's been any changes to the H-1B, if they've increased salary. Also, another thing that's out there is maintenance of status, because you have a lot of the F1s that go to H-1B. We have to make sure that they can slide nicely into it, that they got their OPT to cover them during that period when a lot of them end school in June. And then it's called cap gap. And then they keep working OPT until they can start their H-1B. So we have to also make sure that's covered properly so they can start their H-1B October 1st. So we look into a lot of different things, but those are just some of them. What's going on?
All right. And
so, sorry.
I was just
another thing, the filing fees are very high now. So a lot of the employers are like, when they're writing that check, a lot of them are doing an expedite fee, which is $2,805. So when they write that check, it's almost $6,000, the filing fees, and employers have to pay it. So they really must want this worker. That's a lot of money for them to invest in a worker. So that's also another thing that's frustrating. And the E-Verify and the I-9 systems all have to kick in once the worker comes on board. So that all has to be also figured out. So there's a lot of factors. They really need proper advisement for H-1Bs. It's not something you can just say, I made the lottery and I'm just going to do it myself. It's not, H-1Bs don't work that way.
Absolutely. Yeah, and that's very well put up, Jessica. I'll say that thank you so much for, clearing up those factors. And we have been reading for the very first time in 2025, there are certain applicants, so there are some people where the H-1B demands are decreasing. So it is quite shocking and quite surprising, but it is happening, and maybe because of the factors and the reasons that you have mentioned. So let me go ahead with my next question, and this is again a quite interesting one, and regarding the gold card, that is a very hot topic right now. So what do you have to say, Jessica, that President Trump has floated a $5 million gold card, and he said that it can replace EB-5 visa. So firstly, is this feasible, and how would it interact with current green card pathway? What's your thought on that?
I like how you put it, it's floating. Floating the idea. It's still floating, I think, because it's not out there yet. We don't have the regulations. What he did do, and if anybody wants it, you go to trumpcard.gov and you can click on it and you can register to get updates on when this card's going to come out and all the requirements, whatever, of the gold card. But the EB-5 world, according to some of my peers that I've spoken to, says that it cannot happen without congressional approval. EB-5 had to happen with congressional approval. So they're saying he can't just create a gold card directly without getting congressional approval. So will it happen or not? Will it take over the EB-5? I don't know. I mean, they're claiming, what I see from my resources, almost 70,000 people click the trumpcard.gov. Now, I don't know if all of them are going for the gold card, but that's a lot of people. Yeah. So is it really that many? And when I talk to some of my clients in different countries, I say to them, I understand EB-5, it's a smaller investment, $1,050,000. But I said, do people really have $5 million? And he said to me, yeah, they do. He goes, there are a lot of people. If that's a fast track to get to America, they do. So I don't know. I don't know what's going to happen. I think it's going to keep floating until he brings it down and creates the regulations. And then we see like what's going to happen, because it's interesting. It could really produce a lot of income for this country. If that many people are interested in it, it could be very interesting when it happens.
Absolutely. I do agree. It is a very interesting topic, and let's see what happens, because if people have that much amount, then that's great, because that can also be the fastest way. Okay, and let me go ahead with my next question, and this is regarding cross-chargeability. So how does cross-chargeability work in 2025, and also how can couples use it to move faster in the green card line?
Okay, so cross-chargeability is two people are going to file for a green card. So we look at where were they born. It's not where they're a citizen, it's where they were born. And if one person, let's say, is from India and one person is from Canada, let's say, well, Canada doesn't have a backlog in certain categories. So if we go to EB1, for example, extraordinary ability, and we see that the husband is the Indian citizen and the wife is Canadian. So we note on the I-140 their places of birth. It's on the forms. And then we put it on the cover letter. We say, please note, this is cross-chargeability, that we want the employment-based visa numbers to go towards Canada for this family, not towards India. So that bumps them up. So then they can do it faster, the whole application. And you can do it if you're doing adjustment of status in the US, or they're outside the US and they're going to do consulate processing. But that's what it does. And it really helps if people are aware of that. So if anyone's from India out there listening to this, or China, if you're married to someone from a country that's not backlogged in our system, it's a great way to come here faster.
That's right.
Yeah.
A pretty way. But I think there might be some, what do we say, eligibilities or some criterias. I think if somebody is from Portugal or if somebody is from India, that Portugal also has to come some under category, right? Or how is it? If you can explain it in a little detailed way, then that will be easy.
Every country, like if you go to the Visa Bulletin, there are certain countries that are backlogged. So those ones we see very backlogged. But then, of course, each country has to be checked to see if they met their 7%. But they usually don't, unless there's some mad rush from particular countries. But sure, you have to check with each country and see. I know, because I work with a lot of Canadians, that they haven't reached it. So it works very well. But yeah, you definitely have to check each country.
Okay, that's interesting. And that's a very smart way, I'll say, to get a green card. All right. And another very important and a very demanding question, Jessica, that I have for you, that how do you counsel individuals who ask that what happens if I lose my H-1B job during green card processing? Also, can I sponsor family members once I have an employment-based green card?
Okay, so let's take each part of the question. So what happens if I lose my H-1B job during the green card process? So where are they in this process? So let's say they have an H-1B. Now, H-1B, as many of you may know, that you have a 60-day grace period. So you can go find another employer and file another H-1B. You're not subject to the cap, and you can get another H-1B. So that's one thing. We want to put you in H-1B properly. Okay, then the question is, where are you in the green card process? So is the I-140 approved? Is the I-140 still pending? So we need that I-140 approved, and the I-45 should be pending for 180 days. So if that has not taken place, then it's a bit messy, and I'm just going with a cleaner answer right now. So if that's taken place, then you can port to another employer. So you can, and it's not just the job title, it's the job duties need to be similar. So not all is lost if you are getting, your first job is ending. But the question is how to bring the family along. So it depends where they are in the process. Everyone should be listed on the I-140. When you file the I-140, that's the first part. Well, there's three parts to the green card process: labor certification, I-140, and then the I-45 or consulate processing. So the I-140 part, all family members are listed. If they're listed on there, then they just come along with the green card process and continue it as you continue it if you've ported to another employer. If they haven't been listed on there, then we need to understand, why were they not listed? Did you just get married? Did you just have a baby? We need to understand what's going on, and then you have to update the file. So you may have to do an amended I-140, add the family members in. So it just depends where you are in the process. But as you can see, this is complicated. And this is AC 21 was a rule that came about in 2000, I think. And this is trying to protect you. So if this happens, they created it because not every employer is going to stay on board for 5 years or however long. If you're from China, India, these countries, they have to stay on board for 10 years. I mean, it could be a long time they're on board. So you might not want to keep you as an employee. So this is why AC 21 came about, to help them. And the other thing is with H-1B, as you probably know, that you have a 6-year limit. That's it. So if your labor cert's pending for a year, or the I-140 has been pending for a year, if that's taken place, then you're going to get extensions of your H-1B. 1 year, 2 years, sometimes 3 years. And I've been in those situations with people from especially China, where I was with them the whole process until their priority date was current. And then we were able to adjust all their statuses, and they kept renewing their H-1B. And we have to keep explaining to immigration, because we're like, they're on the 10th year of their H-1B. And usually they see once it's 6 years, no more, but you could keep getting it for years. So you could be in a very good position as long as you have good legal advice, so you don't miss any of your deadlines. That's the answer. It's complicated.
It is, and actually very complicated and challenging. But you have explained us in a great way, and I'm sure our viewers are noting all the points down. So, friends, in case if you're having any doubt or any follow-up question or any query regarding the topic, then please go ahead and feel free to put them on the comment section. We are here for another half an hour and will surely take up your questions. And friends, the best part is you can also reach out to Attorney Jessica Ways. Just have to visit this link and get her contact details. Okay, and with that, Jessica, it is time for a short and a small break. So, Kritika, Ricky, and so many viewers, Karthik, thank you guys for joining us. Don't go anywhere. We'll be coming back just after a short break. So, keep watching Immigration Talk Show, and we'll be right back.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
All right, friends. So, welcome back once again to this very exciting webinar that we are having, and I'm sure you're enjoying it too. And don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. Also, we are not just here on YouTube, but also available on LinkedIn, Facebook, X, and on Instagram as well. So go ahead, and if you haven't followed us, then do it right now. Okay, and with that, Jessica, I think we have covered a lot in this webinar, and let me go ahead with some of our viewers' questions. So Karthik is here, and hi Karthik, thank you so much for your participation. He's asking what are the potential risks and consequences of transferring the underlying basis of my Form I-485 to a different employment-based immigration category? Yeah.
So different employment-based immigration category. So I would need to know probably which category he was thinking of, which category he was in, because usually you can't just, if you're in the I-45 part of the process, you can't just jump to a different category. If you're like, let's say EB3 or EB2 and you're dumping to a different employer, that's one thing. But jumping to a different category could create a problem. You may have to just redo it. Yeah, it doesn't work that way.
All
Yeah.
right, and that's right. And Karthik, do let us know, which category you're looking for, and if you're going to specify, then it will be easier for Jessica to answer. Okay, let me go ahead with Ricky's question. So, hi, Ricky, and once again, thank you so much for being here. Ricky is asking, can you give some idea on the typical processing time that you are seeing for NIW, I-140 petition, and the standard processing?
Okay, so the first part is filing with the Immigration Service, your application. So that I'm seeing right now processing times between 13 and 17 months, but that's if you don't expedite. If you expedite, you get an answer in 45 calendar days, but you're going to pay $2,805. So that's just the first part. Now the question is, when can you do the next part? So I don't have it memorized, but it's based on, it's the Visa Bulletin, and we look at the categories. So even, I could pull it up and you could pull it up really quickly. Just says, you just go to Visa Bulletin, just type it in as a search, and then pulling it up. I think there's a backlog of maybe 2 years, but I'm just double checking. And then there's two different charts on here on the Visa Bulletin when you go to Visa Bulletin Department of State, and you have to know which chart to use, and they refer you to the immigration website. I think it's about a 2-year backlog. That's what I'm seeing, yeah. Except for, again, countries like China, India, Mexico, and the Philippines, they have even longer backlogs usually. So once you get through that first part, you still have another 2 years to wait till your priority date's current. So total time, well, if you're not expediting, it could be 2 years, another 1.5 years, could be 3.5 years. Yeah.
All right. Thank you, Jessica, for taking up this. And let me go ahead with another question that we have from Ricky. Okay, so Ricky has a lot of questions, so don't go anywhere, Ricky. Stay tuned. We are going to take all the questions. So Ricky has that also, can premium processing increase chances of RFE for pending NIW I-140 petitions? If so, then how much will the chances of RFE increase?
You know, it's interesting. When we do premium processing cases, we really want them to be green light approved. So we are doing everything to prevent a request for evidence, an RFE. So statistically, I don't have statistics on this, but I know that if you're doing premium processing, it doesn't hurt your chances of it getting approved. I think it just, you're usually being a lot more thorough because we want our client's case to be approved the first time. So I almost think maybe it could help it a little because we're being very careful with we're always careful with every case, but premium processing, because they're paying that extra money, we want to really try to get it round one approved. But of course, if we don't, then we just go after everything. Every little thing they say on the request for evidence, we respond to everything, and we fight for our clients. So that's the best I can tell you on that one.
All right, and that's very well said. Okay, Ricky has another question, Jessica, that if NIW I-140 petition filed by the employer is pending, can one still self-file another NIW I-140 petition separately? If yes, then what things should be taken care of for the parallel filing? Yeah.
Okay, so I assume that it's the same paperwork. The national interest waiver, it's the same thing, but you decided to file two cases because you can file more than one case, but they might wonder if they see them filed at the same time. So you have an employer, but now you don't have an employer. So I'm almost thinking maybe you should try one first and then file the next one, because it does look a little strange that you claim you're self-employed, but well, let's go back a second. For a national interest waiver, you have to show you're working in your field. So you're going to have a letter in there, right? Unless you're doing your own company. So self-file is not the same as like you own your own company. So it could be that this may be redundant because you still have to show you're working for them. So I'm not sure I'm thinking just file one. I'm not thinking you need two, because why would you need to? You want two shots at it, but it's still the same heart of the case. The NIW, the national interest waiver part, all the documentation is going to be viewed twice. I don't think it's worth it. I think it's better to just file one. Why do people do self versus employer? Because they may want to work for other jobs, right? They don't want to be locked into that employer. But that's something that we'd have to discuss and see what is the strength of it. What would be, maybe there's other reasons I'm not aware of why you'd want to try for two. But I'm thinking it could be conflicting to them. They're not going to understand, why did you do two?
All right, no worries. Okay, let me go ahead with Kritika's comment. And hi, Kritika, thank you so much for your participation. So Kritika is asking that this question is on behalf of Dennis. I am currently on H-1B visa, and soon my sponsoring company would be applying for I-140 application. So I currently have credit card debts of around 23.5K due to layoff situation I had faced earlier around 2023. So could anyone please let me know if my current debt could affect my green card application?
So on the green card application, the I-45, they can ask you, what is your household assets, liabilities, income, those kind of things. And if they see there's very large debt, they can be concerned about that. They have a right to be concerned because they want to make sure you're here, you're stable, you're not a tax on our system or whatever. So you're not going to have, if they're getting ready to file the green card, you're going to have some time before you're going to have to go to this interview, if you have an interview. So I would say bring it down as much as you can, the credit card debt. I know it's not easy to bring it down, but I would try to bring it down as much as you can. And if they see you're making a good amount of income, but you do have credit card debt, that's explainable. You're keep working on it, bringing it down, and that shows you're going in the right direction. So I think it's still viable to go for a green card.
All right. Thank you so much, Jessica, also for explaining things in a great way, and Kritika also for participating. And Kritika, I hope you have subscribed to our channel. If you haven't, then please do it right now. All right. So these were the questions that I wanted to take up from our viewers. And coming back to my own question, Jessica. if we talk about AI, AI is like everywhere from good morning to good night. We are covered with AI. And USCIS is also enhancing their work, their job by using different technologies, and AI is helping process application. So, should people change how they organize or explain their evidence? What do you have to say on this?
Well, I have to say that if you're going to write very long, lengthy cover letters, supporting letters, those kind of things, I don't think it's going to work so well with AI because AI has a system and they're looking for certain things. So I would make things more concise and then they can handle it better. I would have headings, I would have more standardized wording, formatting. I think concise explanations will be better. So I think it would help to really make it more concise if since they're using AI.
Yeah.
And I think that's what I would say on that. Mhm.
Okay. All right. That's great. And moving ahead with my next question, Jessica, that if someone from India has been waiting for a green card for 10 plus years, so is it worth looking at other countries instead? Because US is having very challenging immigration policies right now. So people are
If
looking.
you hadn't said India, I would
Yeah.
have said, 10 years is a long time, but that makes sense because it's India or China or Philippines or Mexico, but it's very difficult. We try to talk to them about maybe there's other ways. We say, do you have a family member? Are you married to a US citizen? Obviously, that's the first way we try. But in the end, if this is their only way, EB2 or EB3 is their only way to get here, and there's tremendous backlog, the question is, are they here on H-1B? Then they can keep renewing it year after year. If they're not, then yeah, we might say to them, our system isn't so hot. You want to get on with your life. There could be other countries, maybe like Canada has something called the express entry. And I think it's about 2 years. I'm not an expert on Canadian immigration law, but I think it's a 2-year process to obtain a green card through them, through an employment-based skills professional system. But sometimes there are clients that go to Canada first and they just wait until their numbers call and they can come into the US. So they do need a long-term strategy. It is very difficult because it's so long. And don't even talk about brothers and sisters trying to come here from certain countries. That's like 15 years. I think Mexico or something, it's very long. So people have to plan their lives. And a lot of these categories, the EB categories, employment-based categories, have retrogressed. So when you thought it was going to be a year, it's now like 3-year wait. And certain categories don't have like H-1B. You can extend it after 6 years based on meet certain requirements. Some of their categories don't have that. So they're stuck. A lot of clients will leave if they have a category and they can't last here as long. And they'll come back hopefully one day if they still really want the immigrant visa. Yeah, it's not a good system. Yes, this is a flaw of it.
It does, and that's very well said that people are looking for other options too. And if we are going to see the same scrutiny and same, then of course, people earlier they don't even have to think about the other countries, but now the question are being arising: Are you looking for some other country or not? So a lot of changes and a lot of different things we have been seeing in 2025, and I think it's pretty eye-opening. And having these sessions with great attorney, I think it is one of the blissful thing that we have in 2025. So friends, if you are navigating any problem or any certain difficulties in your immigration journey, then I'll suggest that getting in touch with the expert and have a right guidance is one of the best solution. Go ahead, visit this link, and also don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. All right, Jessica, we do have few more questions, and that is, are there any real chances that US immigration laws will change soon to reduce wait times, like removing country caps or using old unused green cards?
I wish I could give you good news on this one, but I can't make it up. It really is not going well. I mean, we have so many, there's no laws in place right now to speed things up. I think India maybe is going to move up a month, maybe in some employment-based categories for the year, but that's movement. That's all the movement we're seeing. No, there's really nothing right now and we just hope it won't get worse. That's the thing. We don't want it to get worse. It's one thing we talk about that it's going to get better, but it can also get worse too. Like as more and more people want these categories, then it can create more backlog. If our system, we have a lot of things going now towards deportation matters. And even, as you know, some of these business visa cases, there's a asylum processing fee of $300 or $600, depending on the size of the company. 25 workers or more pay the higher fee. And so a lot of money and services are going towards the deportation right now. I'm hearing there's almost 1 million people that have self-deported, but there's a lot more. And this government right now, that is their focus. So this system is not their focus right now. I know you mentioned something about, I think we had talked before about raise, that it was a proposal or something a while ago that Congress had thought maybe this is a quicker way of somehow make things go faster to bring qualified candidates in for green cards. But that has not been talked about for years. So that was a proposal to move things along, but we don't hear a lot. We just don't hear a lot. So sorry, I don't have better news.
That's a pretty sad one. But I think that's okay. I mean, we can't do anything with it right now. But I think, Jessica, it's almost time, and we do have to come up after a short break. So don't go anywhere, friends. We'll be right back on Immigration Talk Show. Till now, we have covered a lot of questions from our viewers also and from my side. And now it's time to take up some Facebook questions because we have joined a lot of viewers on Facebook group as well. So just stay connected, stay tuned, and buckle up because I'm sure after the end of this webinar, you'll get a clear picture, a clear roadmap of which visa is going to be best for you. So don't go anywhere. We'll be right back. You just keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Hello, everyone, and welcome back to Immigration Talk Show. And today we are having a great discussion with Attorney Jessica Weiss on the topic U.S. green cards through work. What are your options in 2025? So till now, we have covered a lot and we are into a great conversation. So Jessica, I think with your permission, can we go ahead with some Facebook questions as well?
Let's try it.
Okay, let's go ahead. For control, please share the screen. All right, so Sunil is here. And hi, Sunil. Thank you so much for your question. He's asking a quick question that is it compulsory to hire an attorney or a professional to build my case for AB1? Yes, Jessica, what do you have to say?
I like the word compulsory in there. Nothing's compulsory. It's not required, obviously, but I can tell you in my 27 years of practicing, I've never seen anyone put together an EB1 that was strong enough for success. I've seen people put together EB1s, but I always have to go at it and take it apart and fix it up. It just isn't strong enough. It has to be, it's a very high standard. So someone with a great deal of skill that's been doing these for years can really take it apart and put it together, back together the way they like it. But even for a reference letter, it has to be written a certain way. They're looking for keywords. If it's too narrow that you made an impact in your local community, for example, that doesn't work for an EB1. They're looking for national or international accomplishments and impact. So I really do think an attorney needs to be involved. If clients are trying to save money to do some of it themselves, then they can try starting to put together themselves, but an attorney usually has to finish it. It's not enough to just do it on your own. I've never seen it. If it works, great, but I've never seen it work yet. Mm-hmm. So that's the story. Yeah.
Okay, and that's very well put up and very insightful because Jessica, in 2025, we have been seeing so many things and, it's better not to take a risk. So Sunil, I think I'll just suggest you can go ahead and reach out to Attorney Jessica Weiss, and she is an expert in handling all these cases. And
I love
go
ahead. Great cases. They're so interesting, the amazing things that people do and really reach the top of their career. I mean, I could tell you stories and stories of some very famous, I work with lots of athletes as well, some famous athletes I've helped, famous entrepreneurs. Like, really, they're very, and sometimes they're humble and they're like, what? I'm extraordinary? I said, if immigration says you're extraordinary, then you are, because they're humble. They're like, I'm really behind the scenes kind of guy or whatever. I'm like, no, you got an EB-1A, you're extraordinary. So they're fun. I really enjoy them.
Wow, that's a great point, Jessica, that you mentioned. People don't even realize that they have extraordinary ability, and by having a consultation with attorney, they are realizing after that. So I think that's great, and that's very beautiful too. So I hope, Sunil, you don't do this mistake. Do let your know. Please let your know about your skills and abilities, what you have. I think getting in touch with Jessica will be the best thing.
And
Okay.
can I share one more thing
Yeah.
also? Sometimes
Uh-huh.
people are so experienced and knowledgeable in their particular field, they don't believe that it's extraordinary level. Like, I had a gentleman that, like, he made a very particular type of food, and it was so rare in his industry, and he really had reached the top of it. And I'm like, it could be anything. We get creative. If you really think you've hit the top of your field and you meet those criteria, the 3 criteria of the list we give you, you could try. Anyone could try. But, what cases we actually take are the ones that we say, you know what, this looks great. Let's do it. So.
Okay, all right. Thank you so much, Jessica, for putting up these great insights. And let's move ahead with our next question. And this is Rizky. So, hi, Rizky. And Rizky is asking that, hi, I had an approval of EB2 and IW. I'm currently waiting for IVP. Somewhere I read that I need to submit police clearance certificate if I stay a country more than 6 months. I'm a British citizen, originally from Bangladesh, studied my undergraduate from India between 1996 to 1999. I wonder whether I need to get a police clearance certificate from India, as it's more than 25 years ago I stayed there. Any answer? Yeah.
I don't know how old this person is, but anywhere you've lived from the age of 16 and on, you need a police clearance certificate. So hopefully that answers his question. Anywhere. So, even if it was 25 years ago, if it was, 5 years ago, they want to see it. So he's going to need it if, 16 and up, wherever he was.
All right. Okay. Thank you so much, Jessica, for answering this question. And I hope, Rizky, you got your answer. Okay, let's move ahead with our next. And this we got from anonymous participant who's asking that anyone know how long does it take to be able to check status? If I filed E2 a couple of days ago, when I try to check status to see if it was received, the search does not return any results. Yes, Jessica.
So I assume that I'm thinking from the question that they filed a change of status in the United States to E2. Is that what they're saying? And they don't see where to check the receipt notice. That's what it seems like. So is that right? Is that what you're thinking? Okay, so then receipt notices are taking a long time. If you file premium processing expedite, you'll get it obviously faster. But otherwise, it can take a few weeks to get a receipt notice. There's nowhere to check it online, except here are some ways you can do it. So first of all, there's a form called the G1145. You can put this form in when you file your case, and you write your email and your cell phone. So when they get your case, they send you a text, we received your case. And your case number can be on there. So that's one way to do it. There's a form that you should have submitted when you filed your case. Another way is if you submit checks. If you're paying by check, then on the back of the check, when it's cashed, you could see your case number and proof that they received your case, because they give you the case number. They cashed a check, you get the case number. So with the official receipts, and the thing is, it's interesting because now, because of the rules since April of registration, if you needed to do a change of status, which would give you a right to stay here longer, you need some kind of proof that you're allowed to be here legally. So I always tell my clients, if you don't have the receipt notices, if you have the text, you can go online and pull the case number online at the USCIS website. There's a thing that says check the case status, which they did. And if you have your case number, you put it in, print that out if you don't have your official receipt notice. So there's several ways to do this if you don't have an actual receipt notice. But if you're in a situation where technically your status looks like you're out of status, but you filed your change of status timely, then I tell my clients to really probably wait for the receipt notice before you start traveling domestically. You're going to drive around, whatever, in your car, but you should bring whatever you can to show proof that you filed timely. Track it, that they received it, the check or the G1145, get the case number. But you should try to get something But you're right. You're not going to get a receipt notice or anything like within a couple of days usually. Regular processing in E2, change of status, you won't get that right away. It takes time. Yeah, it's frustrating. That's our system. I feel like I say that a few times. That's our system. That's what we have.
It's like full time you have been saying that, but
I
of
know,
course,
right? This is it. We don't. It's not great. It's our system. We try to help our clients. We want them all to have proof that they have a legal right to stay here. If they do, and that's what we try. So those are some ways we can help. Yeah,
that's right. And with that, I think we can just help you guys out. Okay, and let me go ahead with my next question. E2 visa holder can apply EB3 process. Is this create issue at a time of E2 renewal?
Okay, so I do a lot of E2 visas. It's one of my favorite categories, and I'm a national mentor on it. I educate young lawyers that are getting into the E2 visa field. The answer to the first question is E2 visa holders can apply for EB3 process, yes. And now the question is the timing. So we have to time it. We don't like them needing an E2 visa renewal. If they need an E2 extension of status as well, we'd like to time it. So this is how it works. So we have E2, if they get, let's say, a 5-year visa, every time they come into the country, they get 2 years to stay here. So then we say, where are we in the process? So as you know, EB3, you have to do labor cert first. That could be like a year, year and a half. So during that whole process, we can take care of all that. It's all through the Department of Labor, and they can renew their E2 visas and all that stuff during that time period. Now, when we do the next part, I-140, that's with immigration. That's where I say, let's figure out where you're at. If we need to renew an E2, let's do it before we do the I-140. Once we do the I-140 and we do the adjustment of status or consulate processing, I don't like them to be involved with an E2 renewal. So we have to time it right. If they're in a situation where they do need an E2 renewal, we always set up the I-140 where we check off consulate processing and not adjustment of status. So they are saying to the officer, if they have to go get an E2 visa, that, look, I'm going to finish my green card out of the country. I don't have full intent to immigrate because I'm not saying I'm staying here forever and doing my adjustment of status. So these are little tricks of the trade that we do so we can set them up properly. So, and I've done this so many times where we take E2 to EB3 and they get green cards, but you have to time it right. It's very important, the timing.
Absolutely. Timing is very important, and that's very well said. All right. So I think that's all. And we have covered all the Facebook questions. And Jessica, I have to tell you that you were absolutely fantastic. All the questions you have taken. And it's almost the end of our session. So I think before leaving, any message or any last tips or strategies that you would like to give to the employment-based visa applicants, then please go ahead.
Sure. So I would tell the applicants that you still have opportunity here. There are great ways to come to this country. It doesn't matter who the president is. You could see in the media, whatever. I've had so many different presidents when I'm doing this, and there's still tons of people that want to come here, but you have to do it right. And I know there are many people are desperate to come here, desperate to do their cases quick and this and that. You got to take patience is key, and you have to use competent people. I speak to everyone free briefly just to give them a little bit of direction. A lot of immigration lawyers do not do that, but I feel as a foreigner, they don't know anything. They need a little direction. If they like my style, they like my service, then they'll retain me, whatever. But it's my way of giving back a little bit because I know it's very hard. They don't know our system. So I tell applicants, I have a website. I have really helpful charts on it of all different types of categories. Read it over, read my articles on my website. And if I can help them, I'm happy to help them. But there are great opportunities to come here, but the paperwork has to be in order. So that's what I would say. Don't give up. I mean, even the people in India, 10 years, whatever the wait is, sometimes they go to other countries. Sometimes they, continue their lives where they live, and they have an opportunity eventually when their number's called, so to speak. They still have an opportunity to come here. And that's what we do. As immigration lawyers, we try to help them have opportunities. And it's not just for one person. It can be a spouse, children. It can be the whole family now will have an opportunity to come here. So I'm happy to help them. I love what I do.
And we are happy to have these sessions with you, Jessica. You are absolutely, brilliant, energetic. And we love having these conversations with you. And also our viewers have enjoyed this session a lot. So thank you so much. Let me greet to our viewers also, Kritika, Ricky, and Karthik. Okay, thank you guys for being here. And in case you are having any doubt or any query regarding the topic, then even after the live stream ends, you can still put up those questions on the comment section. Now, me with my team will get back to you and will provide the answer. And with that, Jessica, thank you so much. It was our honor to have you in our show. So thank you so much for being here and have a great day.
Thank you so much.
Thank you, Jessica. All right, friends. So that's all for today's this very wonderful and very insightful session. I hope you understood what are the different options in 2025 if you're looking to get a US green card through work. So it is a pretty challenging time, but as Tony Jessica Ways has said, that patience is key. Keep believing in yourself, and just keep yourself motivated and informed. And don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. So thank you so much, guys, for joining us. And it's time to sign off. So go ahead and check out our channel. We are not just here on YouTube, also on LinkedIn, Facebook, X, and on Instagram as well. Thank you so much for being here. See you next time. Till then, keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI support.
Hello, everyone, and welcome on Immigration Talk Show. This is Nipasa, and I'm going to be your host for today's session that's lined up. Thank you so much for joining us. We are streaming live right now on YouTube, and you can also definitely check us out on LinkedIn, Facebook, X, and on Instagram. Ask your friends and folks to join. And before we head on with today's discussion, I have this important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So I hope that you keep that in mind throughout this whole conversation and discussion today, because it's going to be a very interesting one on this topic. Can you really become a European resident without giving up your US citizenship? So folks out there who are trying to, explore some other options for yourself, I think this is where you should be. So thank you so much once again for joining us. And in today's episode, we are going to be joined by our guest who's going to help us, explore more on this topic and maybe even answer some of your questions. So, joining us today is someone whose expertise spans both immigration law and complex civil litigation. I'm very honored and happy to welcome Katia Piera Baptista, a team leader and associate lawyer at the Immigration Department of Cayado Guerrero. So, yes, with over 13 years of experience in civil litigation, Katia has been a trusted legal advisor to credit institutions, rental companies, and a wide range of service providers. So, please help me welcome her once again on this show. Hi, Katia. How are you doing today?
Hi, thank you so much for the introduction. I'm doing well, and you?
I'm also doing good. I'm finally
Great.
so happy to have you here. This has been long pending, and I'm sure folks out there also have been looking forward for this. I'm super glad we're able to do this today.
Me too. Thank you so much.
Tell us what's going on with you and your colleagues out there. How's it, especially at this time of the year?
Yeah, so we are now starting summer, so it's good, it's great, great weather. As for our workload, we have been having crazy times these past weeks because we are always and constantly being contacted by US citizens regarding European residence and Portuguese citizenship, and only exploring how they can have like a plan B because of everything that we've been experiencing this past weeks. And I think everybody wants to have some kind of stability, and these are very unstable times. So yes, there have been lots of questions lately from US citizens on how they can come to Europe, how can they try and get away a little bit of what is happening and try to get as far as possible from, well, war that seems to be everywhere nowadays. And we are trying to explore those paths and help everybody since we are one of the most Pacific countries in the world.
Right, right. Thank you so much, Katia, for giving us a sneak peek into your life and the firm you're working with right now. I can only imagine. Yes, it's been chaotic and surprising every day, I think, with a lot of immigration updates and new policies, new things coming up each day. And I really hope folks out there are not missing out on anything that they need to keep in mind. So I think
we do our best.
yeah. I mean, I cannot imagine, especially right now, navigating through any of these immigration statuses without a lawyer, a real attorney, who can really guide you. So
even as a little bit confused sometimes. So it's very, very complicated. Yes,
it is indeed. So thank you. And I can already see Ricky for joining us. So hello to you too, Ricky. Thank you for joining. We are going to take up your questions. Stay with us, all right? And Katya, I have a couple of questions. So I think without further ado, let's dive right into them. So,
of course.
What are the basic requirements for a US citizen, to become a legal resident of a European country like Spain, Portugal, or Germany?
So I'll start by saying that Spain and Portugal are undergoing lots of changes regarding the residency status of foreigners. Germany has been more or less consistent over time, so it's always kind of difficult to obtain any kind of residency there. Spain, for example, just harden the legal requirements for visas and the investment visa, and Portugal is now the one that you can look if you want to make an investment visa. But the requirements in any European country will always depend on the route that you choose, because different visas have different requirements. And of course, different countries have different requirements as well. For example, in Portugal, generally you need to show proofs of sufficient income and financial resources to secure some kind of accommodation, buy, rent a property or purchase one, have health insurance, provide, of course, a criminal record that is not with felonies registered. This one is transversal to all the visas, and of course, apply for the visa that makes more sense to the applicant. The work visa, the investment visa, you have retirement visas. So all the visas have requires of accommodation and health insurance and those minimum amounts of sufficient income. The exception is the golden visa, who does not require accommodation of any kind, and you only need to spend 7 days a year in Portugal. So generally, the basic requirements are the ones that I mentioned.
Thank you so much. I'm sure this must be very helpful for folks out there who have been questioning this. So, what about knowing the language of the country, whether it's Spanish or Portuguese or German? Is it important? How important is it?
It's different from country to country. For example, in Portugal, almost everybody speaks English, or at least make an effort to understand English. In Spain, they are very patriotic of their language, so often it's difficult to if you don't speak a little bit of Spanish. As for the visas, normally you don't need as a requirement to speak the language. For the permanent residency after 5 years living in a country, or for the citizenship, yes, it's needed to take, in Portugal's case, a Portuguese test. It's A2 level test. In Spain, you also need to know the language, but a little bit more profound than the Portuguese. So yes, it's very important to know the language, but it's not mandatory for the visas. And like I said, in Portugal, almost everybody speaks English.
All right. I just asked because this is one of the most frequently asked questions, and thank you for that, for taking that up. So, my next question to you, Katya, is: do most EU countries, European countries, allow dual residency or dual citizenship for Americans, or are there any exceptions?
Most countries allow the residency without requiring you to renounce the US citizenship. Dual citizenship will, of course, depend on the country. Portugal allows it. You can have up to 3 citizenships. Spain allows it as well. Germany has a little bit more stricter rules, but allows exceptions. So if you are thinking about applying, for example, for the Portuguese citizenship, this does not imply losing the one that you already have. You have some countries that you cannot acquire a different citizenship than the one that you already have. On Europe's case, normally you can add up 2 or 3 citizenships, so that will not be a problem for American citizens.
All right. Well, thank you so much for taking that up. And hi, Selomit. Thank you so much for joining us. I can see your questions already, and we are going to take them up very, very soon. So, my next question, Katya, if you can tell us, if you can walk us through the difference between a residency visa, a long term visa, and citizenship in the European context.
So, European Union is very extensive. Even if I wanted, I couldn't walk you through every country because there are lots of countries. However, I can speak about Portugal because it's the one that I live in. And of course, I'm always suspicious to talk about Portugal, but I think it's really a great option in the European context, and it's a beautiful country. So without further ado, I will have a little bit of the differences between the residency visa. So residency visa typically is a visa that allows you to live in the country up to 90 days. In some specific situations, it is possible to extend this period, but it always needs to have some kind of you need to request this extension, okay, and have a valid point for the extension. So you cannot go to our immigration office and request for extension unless you have a real motive to do so. You have long-term visas. These are the ones that are typically granted over the 90 days and in specific situations like work, study, retire, and normally implies that the applicant lives in the country at least 6 months a year, okay, in order to renew. So for retirement or for study or for work, it's always needed to live the 6 months and renew until you make the 5 years if you want to live permanently in Portugal. For the citizenship, it's very different because you already need to have lived in the country. You have countries that start in the 7 years of residency for you to be able to submit the citizenship, and it can go up to 10 years. What happens is, for example, in Portugal, this time was 5 years. The government is now upping to 7 or 10 years, depending on the country. And you need to take the A2 level test. And of course, this is normally granted after several years of residency. For example, in the case of the Golden Visa, you don't need to actually live here. When I say residency, I say legal residency, as in having a legal residency card. And in the Golden Visa case, for example, you only need to live 7 days, stay 7 days a year in order to apply for citizenship, for example. You can also get the permanent residency, which is after 5 years of a non-European citizen living in a country, and it offers you the right to work, to live, access to public services, and you don't need to renew every 10 years, and it's a pathway to citizenship as well. So lots of visas to think about in this context.
Yes, great options out there that you can explore, friends. So definitely look out for them and stay with us because there's so much more to talk about. And, if you have your questions as well, please keep them coming because we are going to take them up shortly here in this session. But right now, it's time for a short break. So please do not go anywhere. Stay tuned here on Immigration Talk Show. Today, we have with us none other than Attorney Katia Pereira Baptista. And yes, we are speaking about this very important topic. Can you really become a European resident without giving up your US citizenship? So we'll talk more on this, but right after this short break. It's me, Napasa, on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we have with us none other than attorney Katia Pereira Baptista from the law firm of Keadu Gurera. So it's really lovely having her today because we have been speaking on this. I would say important because at this time of, the year or what is happening right now, if you speak about the scene around immigration, then people have been looking for a lot more options. And Europe is one of the options that they're looking forward, whether it's for studies or for work or even getting a residency or citizenship. So thank you so much, everyone, for joining us and keep watching. We are Immigration Talk Show. Our handle is at Immigration Talk Show. I hope that you have been enjoying this discussion. Please share this and like as well. Share with your friends and family or folks out there who can join and benefit and maybe get their questions as well answered. So, yes, I think, Katya, I have more questions, so I'm going to throw them right at you.
No problem.
So, are there any specific income or investment thresholds that US citizens must meet to apply for European residency?
Well, each member state has its own immigration rules and residency permits. Only citizens of European Union countries grant you the right to live and move freely across the European Union. So when we are talking European residency, it's always for a specific country, okay? Only after you become a citizen of that country will you have the right to have the European residence, because you will be able to travel freely and work and study in every European country. For Portugal, for example, you have what we call the D-type visas. They have several numbers. For example, you have D7, which allows a person that has passive income of 870 euros, which is our current minimum wage, a month. They can relocate as long as they demonstrate that over 12 months they have that minimum amount of the Portuguese minimum wage per month in passive income. We have other types, the digital nomad, which we call the D8 visa, allows you to remote workers to work from Portugal as long as the monthly income it's 4 times Portuguese minimum wage. For the golden visa, for example, you don't need any income. You only need to make minimum investment, which starts in 250,000 euros. And you don't need to prove, of course, you will need to pass compliance for the transfer, but you don't have to prove that you have a specific amount of income, only the investment. So depending on the type of visa that you choose, you will have to accommodate the income. But as you can see, for Americans, these are fairly low amounts to be considered for the European residency.
All right. Well, thank you, Katia, for taking that up. And I think we should definitely address some of our viewers' questions. We have Cynthia also has joined us. So let's take up Ricky's comment. Can India-born green card holders have dual citizenship, Indian and US? And can you give some idea on the typical processing time that you are seeing for I-140 petition? I think let's go with the first one first.
Yeah, but I don't think that's a question for Europe, because yes, you can have dual citizenship, but if you have Indian and US citizenship, your question is if you can add European, of course it will depend on the country. In Portugal, yes, it is possible to have the 3 citizenships at the same time.
That's interesting. And I think for the next questions, we might have to skip because they are not based on, well, Europe or even Portugal for that matter. But I'll read them anyway. Thank you so much, Ricky, for dropping them in. His other question was, asking, can you give some idea on the typical processing time that you're seeing for I-140 petition? and we have to skip that. And the next was also, can premium processing increase chances of RFE for pending NIW petitions? If so, how much will the chances of RFE increase? Well, Ricky, thank you for your questions, but I think we will have to save them for another time. Right now, if you have any questions, especially if you want to explore Portuguese visa, or maybe go work there, study there, you might as well ask your questions. This next one is from Selomit. What are the different types of visas or residency programs available in Europe that would allow me to live there while keeping my US citizenship? Can you explain the pros and cons of each?
Well, I can't because I would be here all day, but in very short words, you have several options. The first thing is choose the country that you want to apply and the type of visa that makes sense to you, because all of them have some kind of program for study, for working. And in the Portuguese case, for example, you can request the passive income if you have the 80 and 70 euros per month in rent, for example. You can relocate and work in Portugal. If you want, you can work remotely for a US company, for example, or you can find a job here in Portugal. You can also make the investment visa, which starts in 250,000 euros, and you don't have to relocate if you don't want to. You only relocate if you are able or willing to. And all of this, you will not ever lose your US citizenship. So you don't have actually a con in any of these visas. The only con, I would say, is in the D-type visas, you need to relocate to Portugal in this case and be here for at least 6 months a year. If you are not able to relocate. If you go through the investment route, you only need to spend 7 days a year, so you don't have this con per se. But other than that, I would say you don't really have anything to be afraid, because it's fairly straightforward process, and it only takes a little bit of time, but everything starts in the US. And in the Golden Visa case, for example, you don't need to come to Portugal for anything, only for the biometrics appointment. So it's very straightforward process.
It's very nice and good to know. I think this is very appealing. And Selomit, I'm sure if you're looking for your options, go for it. I would say all the best. And she actually has another question. Sorry, she or he, I'm not very sure. But if I get a European residency, will I still have to pay taxes in both the US and Europe? And how do tax laws work in these situations? And is there a way to avoid double taxation?
So again, when we talk Europe, there's a lot of countries. Every country has its own specific rules. So you can choose a country that's more appealing in a tax perspective. For example, in Portugal, you will only become a tax resident if you live here for more than 183 days. If you don't live here for that amount of time, you will not become a tax resident, and you will not need to be taxed in Portugal. For example, if you are an investment visa holder, the Golden Visa, you don't need to become a resident, so you will not be taxed. If you follow the path of any other visa that implies that you live in Portugal, yes, you will be taxed here after you become a tax resident. But some countries, in the case of Portugal, you have a rule of non-double taxation. So you only be taxed here for what you are not taxed in the US. But in regards to tax matter, it's always best to talk specifics and know what type of income that you have, before moving forward. And it's something that we here at our office do because we have tax lawyers. And if you are willing to give it a try, contact me and I will let you know how it works.
Yes, sure thing. And Selomit and folks out there, if you really need a one-on-one consultation and you might need to speak with attorney Katia, then why not visit this link which you can see on the screen. Check it out and maybe contact her. This next one is from Cynthia. Cynthia is asking, are there any specific European countries that have more favorable laws and regulations regarding dual citizenship? How can I determine which country might be the best fit for me?
Well, there are a lot of countries, so I would say do your research because, of course, I know, for example, that Germany has a little bit more tight laws on the citizenship part. So it's a matter of you doing a quick study of around the European countries and see the one who makes more sense to you, because in your specific situation might be different than the other person. What I can say is normally and typically in Portugal, you can hold up to 3 citizenships and you don't have any kind of discrimination on your citizenship or your birthplace. So in this sense, Portugal is very welcoming. Spain, for example, I know they are too, but the thing is, acquire citizenship is very much harder than it is in Portugal. So the thing that you need to have in consideration, it's not only the welcoming of your citizenship in specific, but how hard will it be for you to become a citizen? So I would start there, do a research, and if you need any help, just let me know.
Definitely, friends. Once again, let me tell you that you can reach out to attorney Katia, and that you can do by visiting this link, which you can see on the screen. And better even, call us right now since she's here live. We are live right now, and the number is 425-436-6335. And the access code, when they ask for it, you need to dial in 988-888. So join us to ask your questions or just comment wherever you're watching. We are live right now on YouTube, LinkedIn, X, and on Facebook. But also check us out on Instagram. And so connect with us and ring that bell icon. Our handle is at Immigration TalkShow. Like and share with your friends and family and folks who can join us. It's time for another short break, and friends, we will discuss more on this topic with attorney Katia Pereira Baptista. Do not go anywhere. Stay tuned on Immigration Talk Show. It's me, Napasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa. And today we have with us attorney Katia Pereira Baptista from the law firm of Keadu Guerrera. So it's been lovely having her with us, with over 13 years of experience in civil litigation. And Katia has been a trusted legal advisor to credit institutions, rental companies, and a wide range of service providers. She's from Portugal. So definitely check her out and ask your questions if you are looking to maybe having a future out there in Portugal or even visiting there even. So maybe base your questions on that or call us, if you want to ask the questions yourself. The number is 425-436-6335 and the access code is 988-888. Call us, friends. And well, Katya, I hope you're ready for more questions. I have many more coming.
I am.
So my next question to you is, how does the application process, typically work? Is it something that can be done from the US, or do you need to be in Portugal, since you're basing more of your answers in Portugal. So how to apply?
So normally Portugal and other countries have two types of visas. The ones that you need to apply in your country, in this case in the US, and the ones that can be applied directly in the country. So work visas, retirement, study, all the visas that imply you to move to Portugal typically need to start on your country. So in the coming months, it will be very difficult, I'm saying, to schedule appointments for US residents, because like I said at the beginning, if you are joining now, we are having lots of inquiries from the US, so it's very difficult to book appointments, but normally it's through an appointment online on the VFS site, which is the entity that our state has now to take care of this from the consulate. So first step, choose your visa, book the appointment, and only then you come to Portugal. If, for example, you are looking for the investor's visa, you don't need to book anything. You just need to hire a lawyer. It's not mandatory, but it's highly recommended, because you need to do everything in an online platform, and you will need to have all your documents legalized and certified, etc. So you will not need to come to Portugal only for the biometrics appointment. So only when your visa is pre-approved will you come to Portugal, do your biometrics, and go back to the US, go back to your life. You don't need to be here. So it's typically a two-step process if you are talking about the D-type visa, or the golden visa. You only need to come here for the biometrics appointment. No need to request anything.
All right. Thank you so much, Katya, for taking that up. And well, so much more to ask you. So now my next question is, how long does it usually take, from application to approval for a residency permit?
So in Portugal, normally the D-type visas take around 6 to 8 months, okay? From the moment of the first appointment until you have the appointment here in Portugal. The golden visa was taking around 2 years. However, they have a new process and everything is working much smoothly at the present. So they are promising that within 1 year you have everything completed. So the type visas 6 to 8 months, and golden visa up to a year. This in Portugal.
Okay. Well, thank you. That's very good to know, I think. And friends, if you have more questions, keep commenting or dial in the number which you can see on the screen. And do not forget to subscribe. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram. So, Katya, for my next question, what kind of documentation do Americans generally need to submit, whether it's financials or insurance, criminal record, etc.?
Okay, so typically for all the visa types, you have documents that are almost certainly needed. So first, passport. Normally it's needed the full copy of the passport. It's very important that it's a scan and not a photograph, because sometimes it's very difficult for us to submit the information with only a photograph. So it's important to be a scan. Proof of income, if you are applying for a D-type visa, or proof of investment if the goal is the investor's visa. Bank statements for you to prove that you have means of subsistence in the D-type visas. For the golden visa, you only will need to prove the source of the money. health insurance, which is mandatory until you have the visa, the FBI background check, which is the criminal record, and you cannot have the criminal record that has you shown that you were convicted in crimes that in Portugal would be you would be sentenced to prison to over a year, for example. You cannot get a visa if you have a criminal record. Proof of accommodation in the D-type visas, in the golden visa you don't need it. And of course, the visa application forms duly submitted and everything in order. So these are the documents that typically you need to have. The important thing to know is, for example, the criminal record is only valid for 3 months. So don't rush and get the criminal record to submit a visa before you have everything settled and before you have your appointment, because chances are that it will expire and you will have to get a new one. So this is very important.
Thank you so much, Katya, for highlighting those important things to keep in mind, especially with regard to documentation. So very important process, very important to keep in mind during the whole process. And now the next question is about the typical fees or hidden costs, associated with applying for European residency. If you can talk about them as well.
Of course. So there are very different types of fees depending on the type of residency. Normally, you have two types of fees. You have the legal fees for the lawyers, and you have the government fees. So government fees normally are not very high for the D-type visas. They are between 100 and 500 euros. And the legal fees normally are within 1,000 euros. In some cases, they can be a little bit higher because every case is a case. You always have the translation costs depending on the language of the documents, and you have the apostille of the documents. Normally, it's $95 for documents to be apostille. You will have the health insurance. In Portugal, they are not very expensive, so don't think that the health insurance will be like in the United States. We are talking 30, 40 euros for a person for health insurance, and registration and tax number fees that are 100 to 100 euros. So of course, this will all add up, but a typical visa, it's not very expensive. For the golden visa, it's different, okay? Because the fees, only the fees for the government are around 7,000 euros, not including the renewals. And this is per person. You will have an initial fee of more or less 600 euros and per person. And when the card is issued, when you go to the biometrics appointment, it's around 7,000 euros per person. For the investors that want the permanent residency, the government fees are 11,000 euros. I'm sorry. So it's very expensive permanent residency for the investors. These are the costs more or less for the process. Bear in mind that, for example, golden visa, we are talking 5-year period. So you will need to dilute this amount for the 5 years. The other visas, you need to renew every 2 years, and only a small fee for the renewal. Normally, it's not very significant.
All right. Well, thank you so much, Katya, for taking that up as well. And I do have more questions. And friends, if you also want to know the answer to this, what rights do you gain as European resident? Can you work, access healthcare or travel freely within the Europe? Well, we are going to get the answer very, very shortly after this break, which is lined up. So do not go anywhere. You're watching us on Immigration Talk Show. This is Nipasa, your host. Don't go anywhere.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose Emmy support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we have with us none other than Attorney Katia Pereira Baptista from the law firm of Kea Du Pereira. So it's been really great having you here, Katia. And before the break, I was asking you this question, and I do want to know, especially for folks out there, what rights do you gain as a European resident? Can you work, access healthcare, which is very important, and even travel freely within the European Union?
Okay, so you have two stages. Okay, it's very important to highlight that the European residents, it's not something you acquire with a visa, only with citizenship. So for example, in Portugal and in most countries, if you become a resident, you will have the right to live and work and study and have access to all our healthcare system, which is free in Portugal. We'll also have access to security. You will have access to free education. And you can travel the Schengen area up to 90 days. So this is what you get with residency. If further down the line you get the citizenship of a European country, then you will acquire the European residency, which means you are a citizen of a European country, so you can move freely. You don't need visas to work in Spain, for example. I can go to Spain, to Germany, to Italy, to France, and I only need to register there. So I will need to let them know that I'm there, but I don't need anything other than that. So this is the freedom that you want to gain. As long as you have the passport, you can do everything within the European Union. If you only have the residency, then of course you will need to, you will have all those regalies on the country for Portugal or Spain or Italy. So you can do everything in the country, but you will need to, you cannot stay in other European countries more than the 90 days. So the only way of you not having to worry about these timelines is with the citizenship. But other than that, if you don't intend to be traveling around more than the 90 days per 180 days period, you can do whatever you want and benefit for everything that we do as you were Portuguese.
All right. Well, thank you so much, Katia, for taking that up and for giving us a detailed explanation. And guess what? We do have our viewers from our Facebook groups as well who have so many questions which we would like to address them here now. So they're ready. And this first one is actually from an anonymous participant. It's asking, in which section should the cover letter go in VFS self-upload portal?
It will depend on the visa. Okay, you need to choose the visa, the specific visa that you are applying for, and afterwards you should see a list of the appointments that are available. If you are not finding the visa that you are looking for, it's probably because they don't have any open slots. On the VFS website, you will need to spend a day, a week, a month refreshing and hoping for a slot. Because when they don't have slots available, normally they don't show the visa type that you are looking for, and maybe that's why you are not finding it.
All right. Thank you, Katia, for taking that up. And this
You're
next
welcome.
one is from Wendy asking, Hi, group. Hope you're all well. My mother and father in law have just received their UK visit visa for 6 months. When they come to the UK, we were thinking of taking a short trip to Amsterdam or Germany with them both. Has anyone tried applying to either embassy for a Schengen
Schengen.
visa and sorry, Schengen visa and found it easier if the UK visit visa is in place? Many thanks.
I don't think it really makes a difference because the normally the difficulty it's on getting the appointment itself because for United States and the UK we normally didn't have a big amount of submissions. In your case, you want to travel to Amsterdam. I'm probably they are facing the same problem because before Brexit, they don't need it. You don't need it, any kind of visa, and now you do. So everything is cramped up. So my advice would be do it with time, so you don't need to be rushing because sometimes it's fairly difficult to get an appointment. I don't know how the consulates from Amsterdam are right now, but if I had to guess, I would say that everybody is facing a significant delay because we are having much more inquiries from the US and from the UK these past months.
Right. Thank you, Katia, for taking that up for Wendy.
You're
This
welcome.
next one is also from an anonymous participant asking, Hi everyone, I received a message from VFS today asking me to collect my passport for my UK visa application. Is there any way to know the decision before collecting it from the center? I didn't get any email about approval or refusal. Appreciate your help if anyone has experience with this.
Well, I don't have lots of experience with UK VFS. I have experience with UK VFS requesting visas to Europe, not the other way around. But I would say if they, because typically when you are notified to gather your passport, it's because the visa was either approved or denied. So you will need to go there and check.
Okay. Thank you, Katia, for taking that up. This next one is asking, I had 6 month visitor visa from December 2024 to June 2025, and I visited UK 2 times during the 6 months, and every visits take 3 weeks and returned SL before my visa expires. I'm a doctor from Sri Lanka and I wanted to apply for 5 years visa as visitor. In my cover letter, what are the things I need to include for the success visa approval? For some personal reasons, I would like to visit UK frequently. No plan for asylum. That's why I wanted 5 year visa.
Yeah, I'm not from UK. I see that we are having lots of inquiries from UK. UK, it's not even part of the European Union, so I really can't help with UK visas. But I can, if you want, contact me, and I will refer to someone that can help you with all that you need for the UK. Because I don't feel comfortable because I don't have the experience on those types of visas.
All right. So, folks out there, definitely visit this link, which you can see on the screen, in case you want to speak with attorney Katia Pereira Baptista. So, check her out, contact her, and maybe get your answers because every case is different and more information is definitely needed. So, I think it's best to consult directly. So, thank you, Katia, for taking that up. And
You're very welcome.
all right, so I do have more questions. And now, if you could tell us, are there legal or consultancy services people should consider to avoid mistakes, during the application?
Well, mistakes to avoid. Normally, the thing that can imply more with any application for any country are the forms. They need to be well submitted, and they will need to be written in a context that the reader can understand what's there. So that is very important. And of course, the criminal record. Okay, it's very important to have the criminal record translated. All the documents should be translated, but the criminal record, it's very, very important. And sometimes you will need like a legal translation, because a literal translation, it's not sufficient, because you can have something there that it's a misdemeanor and does not have any relevance for the visa, but a normal translator will translate it to the letter. So the reader will not know what that is in the other country's context. So spend a little money, if you have, on the legal translation for the criminal record, if that's the case, of course, and avoid mistakes like trying to submit everything by yourself without checking with somebody that has experience, because some visas, like a Schengen visa, it's fairly easy to obtain. So you make the appointment, you go there, you say what are your intentions to visit the other country, everything goes well. If we are talking about a work visa, for example, you need to prove a lot of circumstances, and it's very important to talk with somebody that knows and can guide you through all the visa process.
Right. Right. Thank you so much, Katia, for taking that up as well, and for patiently taking so many of our questions. I still have more, so I hope you have a little more time to spend with us.
I do.
All right. So my next question is, you know, are there any limitations or obligations that come with residency, whether you talk about taxes, minimum stay requirements, or reporting duties?
Okay. So again, it will depend on the visa type. Okay, limitations on the minimum stay. For example, for the D-type visas, you need to spend at least 6 months per year, in this case in Portugal. So minimum stay 6 months for the D-type visas. Work, retire, even the high qualified, any type of D-type visa, you need 6 months or more. For the golden visa, which is the investment visa, you only need to spend 7 days a year. Taxes. You will become a tax resident if you stay over 183 days a year. So look out for that. If you are holding, for example, a work visa, after the 183 days, you will become a tax resident, and my advice is consult with a lawyer or with an accountant, so you know what to expect on the tax perspective. And the renewals. It's very important to know that your card has expiry date, and to be attentive to the renewals. Typically, they are every 2 years, so be aware of that deadline for you to submit the renewal. So in very basic lines, these are the obligations that come with residency. So the minimum stay, the tax after 183 days, and of course the renewals of the cars that you need to keep track if you don't want to lose your permit.
Okay. Thank you so much, Katia, for addressing that as well. And friends, do check us out. Our handle is at Immigration Talk Show. Like and share our content with your friends and family out there who can also benefit and participate in this conversation we're having right now with Attorney Katia Pereira Agure from, Kaya Do Law. So check us out, and nothing better, because we do have more questions, and this is your chance, to ask your questions directly. Call us on this number 425-436-6335, and the access code is 988888. So Katia, I do have more questions, and it's actually a case study. So this is about David and Linda, who are a retired couple with $55,000 per year in income, and they want to retire in Italy or France. They're not looking to work, just settle and enjoy life in Europe. So, can retired Americans like David and Linda get long term residency in countries like Italy or France? And what basic financial or healthcare requirements must they meet?
So normally for retire, the importance of the income that needs to be passive income. Okay, so you need to wait until you are actually getting your pension, or you can retire without being old. We all aspire to that. So you can have rents, you can have any kind of investment that gives you return, and with that you can apply for a passive income visa, which is typically associated with the retirement visas. So with the 50, in the Portuguese case, for example, 55,000 euros dollars would be more than sufficient for David and Linda to retire. Of course, you will need to find out if the countries have different amounts for the income, and the quality of life that you can have with that income. Italy is a little bit more expensive. Portugal, it's Portugal, so you can do a lot with that type of income. So I would probably share that the most important, it's not only to see if you fulfill the requirements for the visa, but as well the quality of life that you can have. So look that up before you decide on the country. Europe, it's all beautiful countries, it's fairly secure, and the thing is where you feel more comfortable and where you want to spend more time, and with that amount of income, as long as they don't have criminal record, they should be able to get residency, whomever they like.
Yeah, sure. Sounds really very fascinating. Thank you, Katia, for taking that up as well. So
Very
there's
welcome.
another case study, and this is, about Sarah, who is a U.S. citizen, earning $85,000 per year as a freelance graphic designer, and she wants to live in Europe long term, but keep her U.S. citizenship. So she's considering countries like Spain or Portugal. And the question is, can Sarah qualify for a digital nomad visa in Europe without giving up her US citizenship? And what would her path to long term residency look like?
So we are talking in Portuguese case, the amounts that you need to earn are fairly low compared to the ones that you earned in the US. So in Sarah's case, she will need 4 times Portuguese minimum wage, which is 870 euros at the present, in order to be work as a digital nomad in Portugal, for example. So she would more than qualify with the income that she has. If she likes Portugal, what she can do is keep the freelance graphic designer job, keep working in Portugal for 5 years. After the 5 years, she can apply for the permanent residency and have a card, and that card would be valid for 10 years. After the time that she meets the requirements for Portugal at the moment, it's 5 years. For Spain, it's 10 years of living in the country. She can apply for citizenship as long as she passes the test. In the Portugal case, it's A2 level test. Spain is a little bit tighter, but only speaking a little bit of for Sarah to acquire the long-term residency and become a citizen if she wants.
That sounds really good. Thank you so much, Katia, for taking that up.
You're very welcome.
So, you know, I was wondering, why are so many Americans considering European residency? And is it about lifestyle, work, healthcare, or something else? especially that you said that you've received a lot of applications recently, right? Would you like
Yeah,
to tell us about it?
of course. So until 3 months ago, we were talking key reasons: better work-life balance, quality and affordability of healthcare, safety and education. We get lots of clients that have.
Oh, I think there is a disconnect with Katia, but I really hope that she can come back, for answering our questions. And friends out there, what I would like to say is check us out. We are at Immigration Talk Show here on YouTube, LinkedIn, Facebook, and on X. Check us out, and well, subscribe to us as well. I really hope that Katia can join us back. But meanwhile, let's take a very short break. Don't go anywhere. It's me, Napasa, on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, friends, on Immigration Talk Show. It's Napasa here, and there has been a technical issue, but we were super glad to be able to cover a lot with none other than Attorney Katia Pereira Baptista from the law firm of Keadu Guerrera. So, folks, if you do have more questions, check her out and visit this link, which you can see on the screen. It was a great show, nevertheless. I really wish she could be here for just the end notes that you would like to share, but it was lovely having you with us, Katia. So check her out because it was really an honor and a pleasure to have her with us, a team leader and associate lawyer at the Immigration Department of Keadu Guerrero. So yes, with over 13 years of experience in civil litigation, Katia has been a trusted legal advisor to credit institutions, even rental companies, and a wide range of service providers. And she also plays a key role in managing asset portfolios both for national and international investors, especially in areas of non performing loans or NPL and real estate owned REO assets. So check her out for sure. And it was really lovely having you with us, Katia. I wish we could still continue our conversation, but it was a great show indeed. Really great having you. So, friends, once again, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And check us out on YouTube, LinkedIn, Facebook, and on X. And ring that bell so that whenever we have discussions like these, you can also join us. And I would say stay tuned on Immigration Talk Show because we have a lot more coming in that you don't want to miss out. And if you have your questions which you want to direct them to me, or maybe have some suggestions or some things you want to share with me as well, you can get in touch with me. I have a phone number which also has a WhatsApp. The number is 408-335-6444, and you can email me at nipa@staffingly.com. So this is it for now. Y'all out there, keep on having a great day ahead and keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
So, money can't buy you a happiness, but can it buy you a green card? Well, that is $1 million question, friends. And do let me know what is your answer. Is it a yes or a no? And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. So, friends, hello everyone, and welcome back to Immigration Talk Show. It's me, your host, Sam. And today we are here with another very exciting webinar that is lined up just for you. So make sure to watch this session till the end and participate as much as possible. We are not just here on YouTube, but also available on LinkedIn, Facebook, X, and on Instagram as well. So do subscribe to our channel. Our handle is at Immigration Talk Show. All right, now talking about today's topic is very demanding and very hot as well. That is EB5 or Gold Card. Which one buys you a better life and faster? It's like choosing between a sports car and luxury yacht. Well, both promise a smooth ride, but only one will get you there. And to figure out which one, You have to watch this session till the end because I have a guest who has an expertise in this topic. Also, who is a leading immigration attorney and one of the finest immigration attorney, who is an expert in US immigration policies, none other than very insightful, great knowledge, only immigration attorney Uma Mantrawadi. So I think without any further ado, let me welcome her. Hi, Uma, and welcome back to Immigration Talk Show. How are you doing today?
Pleasure to be back.
All right. So, how was everything going since the time we last met? I'm sure it might be a busy week, right?
It is busy. We have the H-1B deadline coming up on June 30th, which is Monday. And typically we have a lot of people doing things in the last minute. So as usual, every year we go through this. We'll be filing a lot of documents, packages today, tomorrow. We're working this weekend as well, Saturday, most probably Sunday too. And in the midst of all this, I'm also moving my house. So,
wow.
It only adds to the flavor, But I guess that's part of life. Everything has to go on. The show must go on, nothing stops.
That's right. That's lovely. And I think the only thing that is constant is change, whether it's immigration or your real life. It is going to happen. And I think,
Absolutely.
yeah, and we have one viewer also. Okay, Ricky and Mark is also here. So, guys, stay tuned and stay connected. Just after some time, we are going to take up your questions. Until the time, if you haven't subscribed to our channel, then please do it right now. All right, Uma. So I think today the topic is very, exciting and very interesting. As always, we have so much to learn from you. I think today also our viewers are ready with their notepads to note all the points. So what they can expect from today's webinar, if you can just give us a sneak peek.
Well, there's so much to talk about EB5 and the gold card. The gold card is the topic that has been discussed in the recent past. So, a lot of people are still wondering if this is real. Is this going forward? Has there been any legislation? Have we actually seen any forms, stating that the USCIS has implemented anything? So those are the things to expect, and we're going to talk about that as well. And I also, off the topic of this, I wanted to bring up some good news for students, which is the FMNJ visa applicants, that the State Department has been told to start issuing visas for the FMNJ visa applicants who've been waiting because there was a pause for them. And it's good news that, they're going forward. Now, how quickly will the students get the visas and come to the US? We don't know yet because there has been a pause and it's going to take a little time. And also there is increased scrutiny on the applicants', backgrounds, their social media, their whatever platforms they've been on. So there's going to be a little more increased vetting with the students. But the good news is that they have opened up as of June 18th, 2025. Just wanted to share the good news.
Absolutely. That's very important. And thank you so much, Uma, for bringing up that good news and very important update. All right. So now I think without any further ado, let me go ahead with my very first question. So it is, Uma, that how is Trump's new gold card different from the traditional EB5 visa?
Well, the proposed gold card, if it is enacted, would offer considerably or supposedly a faster, more direct path to US residency and citizenship for the extremely wealthy individuals who can invest about $5 million directly into the US government, as compared to the EB5 project, which is more where you're investing into a regional center and which requires about either 800,000 or 1,050,000 if you're going to do a direct investment. And the 800,000 or the 1,050,000, the intent of the legislators was to make for place for a job creation. So the EB-5 program was always intended by the legislators to be a program where there is an investment, but that there is definitely going to be job creation. Whereas the EB-5 proposed, it's not yet the law, is not looking at creating jobs. It's only looking at giving the government 5 million and getting a green card. But we haven't seen any implementation of this, any forms coming out, any indication by the USCIS when the forms are going to be out, what is the fee going to be like. Nothing has come out. So this is still in the stage of proposed.
All right. Okay. So I think that's a good insight, and thank you so much, Uma, for letting us know about the latest update of the Gold Card, because people are quite confused, like whether it's implemented or what is the procedure going on. So, friends, it is still in the process, and we don't have exact information about when it's going to be implemented and what will be the date. Okay, and with that, Uma, talking about Gold Card, we would like to know the reason. Like, why was there a need to introduce this a new option like Gold Card when EB-5 already exists?
I guess this was mainly meant so that the government gets the money, as opposed to right now, there are regional centers who get this 800,000, or an individual directly invests into a program where they're creating jobs for 10 people. I feel that the government felt like this is not coming to the government. The money is going to the regional centers or the target employment areas. Of course, it is creating jobs, which is a good thing, but they felt like the money has to come into the treasury directly, as opposed to going to a target employment area, regional center, or where the individual is controlling the entire investment and the job creation. And the big part of also the comparison in that is you give the 5 million to the government and you'll never get the money back. Whereas the EB-5 legislated investment program is where you will invest the 800,000, and the regional centers do return, most of the time return the money back.
Okay, that's pretty interesting.
So
Yeah.
very direct answer is that the money is going straight to the government, not to a regional center.
All right. Okay, that's very well put up and to the point answers, and that's really great. So thank you so much, Uma, for putting up those things.
Welcome.
And friends, yeah, please go ahead, and in case if you're having any doubt regarding EB-5 or Gold Card, then please feel free to put them on the comment section. And the best part is you can also get in touch with attorney Uma Mantrawadi. Just have to visit this link and you'll get the contact details of her. So go ahead and reach out to her and ask any query or any question that you're facing in your immigration journey. Okay, and with that, Uma, here's another very important question that, most of the time, I don't know whether it's a rumor or people say, but is it really that Gold Card can replace the EB-5?
I doubt it, Sam. This is, of course, my personal opinion. I'm just stating that. I doubt if the EB-5, if the Gold Card will totally replace the EB-5. The legislators who brought about EB-5, the intent mainly was not just to bring the investment of 800,000 or 1,050,000, but more if they can actually. Sorry, I'm trying to mute my phone. If they can actually create jobs for people, and the Gold Card is not going to create jobs. It's like I said, the money goes to the government, to the US government, and then they haven't stated how long it will be before a person can get a green card and when will they be eligible for citizenship. They haven't come out with all these details. But knowing what the legislators intended, I think they will still continue with the EB-5 project because it is definitely creating jobs, and which is very, very important for the economy of the United States. So, in my opinion, EB5 will continue. Right now, the legislators have kept it in place, and it is going to sunset on September 30th, 2027, and they probably will extend it. But if the Gold Card program does come about, I think it'll only be parallel, and not everybody can afford the 5 million, first of all. It's going to be the very, very rich and the elite, a handful of people, maybe 100, maybe 1,000, who can afford to give 5 million and forget about it, because they're not going to get that money back. So most people would be interested in investing the 800, create the jobs, and look forward to get that money back.
All right. That's very well put up. And of course, I think, Uma, I do agree with it. Yeah, please continue.
Yes, and in continuation, there are many countries who have the similar kind of programs. For example, Canada has also got an investor program. Australia does, UK does, many countries. So if the $5 million does come through or try to replace the EB5, I think more people will then look into other countries where the investment amount is less and where they can get a green card. So if that diversion is going to happen, then a lot of people will not be encouraging the government to go forward with the replacement of the EB5, rather just keep the gold card as a parallel to the EB5, because that's going to take away the EB5. And the interest of people investing just for the gold card is definitely going to not be as high as one expects. Right now, we see a lot of countries who invest. India is one of the highest countries that are investing into the EB5. So, it'll be a lot of people who are going to be discouraged if they take away the EB5 and just implement the gold card. So I doubt if that's going to happen.
That's right. And I think that's very well said. So thank you so much, Uma, for taking up this question and clearing up about the reason behind why it has been implemented, and also can it replace the EB5. So I think now, friends, it's time for a short and a quick break. So don't go anywhere. It is me with my guest, none other than Attorney Uma Mantrawadi, having a great discussion on EB5 or Gold Card, which one buys you a better life and faster. In case if you're having any doubt, please put them on the comment section. And after a break, we are going to take all those questions. So keep watching Immigration Talk Show and don't go anywhere. We'll be right back.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
All right, friends, once again, welcome back, everyone, to Immigration Talk Show. It's me, your host. And today we are having a great discussion with none other than Attorney Uma Mantrawadi, who is one of the finest immigration attorneys and also having an expert in US immigration policies. So today our topic is about EB5 or Gold Card, which one buys you a better life. Until now, we have discussed a lot what is a Gold Card, why it has been introduced, and is it really going to replace the EB5 or not? And with that, Uma, I'll say that let's move ahead with our next question that I have for you. And this is a very weighted question that our viewers were looking for, that which one is going to be, better fit for EB5, and also who should consider a golden visa instead?
Like I said, the EB5 is for 800,000 if you're investing in a regional center or a target employment area, or if you want to do a direct investment, it's a 1,050,000. Whereas the gold card is clearly just give the money to the government and you're never going to see the money back. And they haven't provided any key insights as to when to expect the green card. Even with the 5 million, is it like if I give the 5 million, will I get a green card in 2 months, 1 month? Because the amount is so high. Then people would say then it is worth it for them. They're giving 5 million, and of course, never to expect that money back. We haven't had any further clarifications on all these questions. So this is yet to be seen. So at the moment, what I tell people is right now the EB5 is valid until September 30th, 2027. For those of you who want to get your green card quickly, especially people from India, because the waiting lines in EB1, 2, and 3 is pretty late, especially EB2 and 3. So for those of you who are in the US who've saved up some money, this is the best time to go ahead and jump into the EB5 and get your green cards, especially if your children are likely to, turn 21 and above, and they may not be eligible to get their green cards under the EB2 or EB3. So this is a good opportunity to jump in and do this. And to further state, Sam, I work with 2 companies in Houston that have already done EB5 projects in the past and given green cards to more than about 150 people. So I'm working with 2 EB5 projects, and if anybody is interested, I can put them in touch with the EB5 project owners so they can get all their questions answered. And if they are interested, then they can move forward with it. But I highly recommend if anybody is in the US on an H-1B under the EB2 or EB3, because for India, the waiting is way, way, way too long. And we're looking at 20 to 30 years. And so their children can definitely cross the 21-year deadline, and they won't be eligible for it. So my suggestion is, if you do have the money, or if you can save up and jump into the EB5, do it. Now is the time. And since the gold card, there is no clarity, there's no legislation, there is no further discussions about how to go about. I would not rely on just a proposal at the moment. And to me, again, 5 million is a lot of money. And I was looking at it, it's for an Indian currency, just for India, I'm talking probably it's around 45 crores. So that's a lot of money.
Of course.
And never to see it back again.
That's right. And I think that's, very difficult to earn that much and also to spend that much. So I'll say that, friends, this time it is very important for you to have a proper knowledge and where you are investing, how much you're going to invest. Be very particular about it because there are so many people who are involved in the fraud activities. And it's you who have to be very careful and very vigilant about it. And for that, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Yes, Uma, please go ahead.
And I also wanted to add one more thing for the for the gold card. But, we don't have any track record at the moment to say that this program is successful, people have gotten anything or got the green cards or citizenship. Whereas the EB5 program has been in place for a very long time. There are many, many people who've gotten their green cards and have become even US citizens. So we do see a track record which is established under the EB5 versus the gold card, where there is no track record or regulatory framework that has been established as yet. So which one would I prefer? I would definitely go for the EB5 investment project. One, it's also creating jobs. So that is definitely what one should be looking at.
Absolutely. And that's pretty little easy and less complicated as compared to the other card.
And more
So
affordable.
true, more affordable, and it has a very logical aim, I'll say, to create jobs. So it's
Correct.
like benefiting others, also benefiting the person who is investing. So it's like a win-win situation for both the parties.
Correct.
All right. And okay, moving ahead, Uma, that if someone wants to move soon, then which one is faster, EB5 or Gold Card?
Well, there is no, it's only a proposed rule on the gold card. We don't have any regulations published in the Federal Register as yet. So I cannot tell somebody go with the gold card path because there is nothing in place. As I told you, the USCIS has not come up with any forms, USCIS fees, timelines. Is there a premium processing? Nothing has been specified as yet. It's only a proposal, it's only a discussion at the moment. There's no regulatory framework that has been established, unlike the EP5, which is already in place for a very long time. And there is a track record where lots of people have gotten their green cards through the EB5. So I would only focus on EB5 rather than the gold card.
All right, that's very well put up. And I think now, Uma, let's take up some of our viewers' question too. So, hi
Sure.
Ricky, hi Mark, and Samantha also. We have a lot of questions, so let's start with Ricky. So, Ricky
Sure.
is asking that can you give some idea on the typical processing time that you are seeing for NIW standard I-140 petition?
Every case is going to be different, so we cannot give you exact timelines or approximate timeline because it all depends on the documentation. And, of course, there is premium processing. So, Ricky, if you are going through an attorney already, you should ask your attorney, if they can give you an approximation because they have all your documentation. So, it'll be hard for me to assess that. But you're more than welcome to reach out. And if there's anything I can help you, I'll be glad to.
Okay. And Ricky, to reach out to attorney Uma Mantravadi, you just have to visit this link and you'll get the contact details of her. So in case if you are having any doubt, then feel free to reach out to her. Okay, and Mark is here. So hi, Mark, and thank you so much for your comment. He's saying, hello, Sam and Uma. I'm currently on L1B in the US, but given the lengthy perm processing, I'm considering alternative ways to maintain my status until I receive the GC. So I have few questions. I think let's go one by one. Firstly, it is, provided that I'm qualified, can I transition to an E status with my spouse? Yes, Uma.
I don't know what country he is from. If he is from a country that has the visa bilateral treaty and he's a signatory to that country, then yes, he can change his status to E. But I don't know. India is not, the only three countries in South Asia is Pakistan, Bangladesh, and Sri Lanka. India is not, Nepal is not, many other South Asian countries are not. So without knowing that, I can't say a yes or no for sure.
All right. Mark, I hope if you're watching us, then please let us know about from which country you are from. That will be easier for Uma to, give you the right answer. Okay, now this is the second question, Uma, from Mark's side, that does USCIS adjudicate E1 or E2 and E1 or 2S at the same time if filed concurrently with USCIS?
I don't know why he would want to file E1 and E2 concurrently. So the question itself is very confusing. And there is no E2S. There is no such thing as an S. So there is an E1, which is a treaty trader. E2 is a treaty investor. So depending on, again, there has to be a treaty with the country. If he is a part of the country, which is a signatory to the bilateral treaty, then he can either go with E1 or E2. So, not knowing that, I cannot answer, but I don't know why somebody would even think about filing both concurrently. Doesn't make sense.
Okay, and this is the third question. And it is that, is the E status a dual intent? If not, is it better to transition first to an E visa and then, when I'm ready to file my I-485, recapture my remaining L-1B time?
E-visa is not a dual intent, that is correct. But I wouldn't know whether you can recapture your remaining time of the L1B because I don't know where you are on your L1B right now. So without having those details, I cannot say whether you can or cannot. And we don't know what will happen in the future, whether the USCIS is going to allow you to recapture, not allow you to, what will be the policies, what will be the regulations. We cannot predict at the moment. Based on today, the answer is possibly yes. What will be in the future? I don't have an answer. I would say, your questions are very confusing. So you definitely need to speak to an attorney to clarify, to get a proper clarifications as to what you want to do.
And here Mark is saying that he's from Canada.
Yeah, Canada is a signatory to the E, so you can definitely apply for the E2, but you can't apply for E1 and E2 at the same time.
Yeah. Okay, so thank you, Uma, for taking up these questions from Mark. And Mark, I hope there are quite confusing questions, but I hope you are understanding the facts and getting these insights. In case if you're having any follow-up question or any other doubt regarding the topic, then please go ahead and put them on the comment section. And we are here for another half an hour and would love to take up your questions.
I also wanted to say something on the E because the question about the E2 has come up. I work with a lot of clients from different countries, from UK, from Canada, from Pakistan, from Bangladesh, who are eligible for E2s. And I also work with a lot of real estate agents who then, bring me the possible E2 investment opportunities for my clients. For example, it could be a restaurant that's up for sale, or could be a beauty parlor that's up for sale, or could be a laundromat or a wine shop. So I work with the realtors who bring in, genuine E2 investment businesses, which I then share it with my clients so that they can actually verify all the documentation of these businesses. And if it is a good business, then they can move forward with their E2 investment, because Sam, as you know, there's so much of scams going on, so many types of scams that is going on. E2 requires a minimum investment of 100,000. So still, I feel 100,000 is a big amount. And people do get scammed with money a lot of times. So I tell my clients to be very, very careful as to who they're giving their money and for what they're giving their money without knowing. Do not give the money because you may never see that money back. Never. And we'll talk about it one day, particularly about scams. There are various different scams, even immigration scams, particularly now where people are calling and telling somebody, I'm from ICE and I'm coming to pick you up. And if you don't pay X amount of dollars, I'm going to put you in jail. Things like that. And I've had a guy in Houston who succumbed to this scam, in a way, and he lost $670,000.
Oh, God.
$670,000. So I am just telling people, be careful with your money. Be careful where you're investing. Even an EB5 regional center, you need to check out all their documents. You need to make sure this is this is not a scam. You should actually visit their project site, make sure that the project is real, So that's why, as an attorney, if I'm recommending an EB5 project, I wouldn't recommend it unless I know for sure that this is real and this is not a scam, because
Yeah.
it's my reputation at stake. So I'm just telling people this is a lot of money, whether you're going for an E2 or for an EB5, which is 800,000, it is a lot of money. So be very, very careful as to where you invest, what you invest in, whether it's real, not real. Make sure you have all the contracts in place, have an attorney review your contracts so that you don't lose your money.
That's true. That's pretty sad. But I think, Uma, by having these live webinars only, we can try our best to educate people and make them aware because they don't believe, that these scams happen. It's
Yes,
very easy to fool people around, especially this time because everybody is afraid, everybody's scared.
exactly.
So,
People are taking undue advantage of the situation
yeah,
and trying to scam people out. And there are a lot of vulnerable people, vulnerable elderly, vulnerable even youngsters, people on F1s, and they are scared, they just don't know what to do.
yeah, that's right. And that's pretty sad. But I think, friends, you don't have to worry because just make sure one thing that if you have all the knowledge from your side and if you have the right guidance, then you won't be falling into any trap. And just stay informed, stay connected with us. We have these very informative webinars for you guys to make sure that you are informed and you're educated. And for that, you have to subscribe to our channel. And don't forget to hit the bell icon because whenever we come live, you'll get the notification. And with that, Uma, okay, yeah, please go ahead. After that, we can
Yeah,
continue.
and I was going to say one more thing. Typically, with the E2 visas, also, I tell people not to give the money even to me as an attorney. We usually have a third party who holds this money in an escrow. So let's say, for example, the person is outside the United States and they want to do an E2. Somebody's from Canada, somebody's from UK, and they're like, okay, we are ready, we want to buy this. So I tell them, don't give the money even to the seller, put it in an escrow. Once you get the visa, then you can release the funds to the seller because then you are sure that you've gotten your visa. Let's say you don't get the visa, you can at least take your money back. So we find secured ways of working because this is a lot of money for an individual.
That's right. And that's how, people can trust. And that's how
Absolutely.
honest people do. I mean, they don't take money first and then they give the service. Firstly, they are,
Exactly.
yeah, confirming that yes, you take the service. After that, you give the money.
Right. Let's say the visa got denied, whatever reasons. At least the person has not lost their 100,000. Okay. They spent about 5,000 or 10,000. They won't feel that bad. But if you lose the entire 100,000, that's a lot of money.
That's heartbreaking.
And that's the same thing with the EB5 projects that I work with, which I mentioned earlier in Houston. Even they don't take the money. The project owners do not get the money directly. The money is put into the escrow only when the project owner gives all the documentation to the attorney and to the applicant. Then the money is released from the escrow to the project owner. So it's sitting safely in a bank account.
Yeah, that's right. All right. So there are so much to talk about it, Uma, and I'm sure you come across with so many cases in your daily life and you have a lot of stories.
Yes,
We will
someday I should be writing a book.
That's right. And I think one day we'll have a particular session on this topic and, we would love
Yes,
to know more stories from you. Okay.
yes.
And with that, Oma, it's time for a short break. So I think, friends, stay tuned, stay connected with us in case if you're having any topic or any question in our mind, don't hesitate to put them on the comment section. We are here for another half an hour and surely love to take up your question. Till then, keep watching Immigration Talk Show. Don't go anywhere. We'll be right back.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI support.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and here's my guest, very special guest, none other than attorney Uma Mantrawadi, who has joined us today. And Uma, your insights are again exceptional and very eye-opening and very great. So I think now let me go ahead with my next question. And this is in case, for example, if Gold Card comes out and implements. So can the Gold Card solve the long wait times that some EB5 applicants face, especially from countries like India and China?
As I said, this is only a proposal, a discussion. They haven't really come and stated how long it will take once you get the 5 million, whether they'll give a green card in 1 month or 3 months. They haven't come up with any of those proposed regulatory reform or information. Usually, all this information is given as a proposal in the Federal Register, and they allow people to comment on it for 60 days. Once the comment period is completed, then it comes in as a regulation. And I would imagine this has to go through congressional legislation because EB5 is a congressionally legislated investment program. So I'm assuming that's how this is going to be. If this is merely coming with an executive order, I think there's going to be a lot of legal challenges to that by a number of organizations. So we don't know yet. They haven't said anything yet. Nobody has applied yet. Nobody's gotten anything yet. So we don't have a track record. We don't have a regulatory information.
Okay, all right. And Uma, we have Samantha also. So hi, Samantha, and thank you so much for your participation. I hope you're enjoying our session. And she has a question, Uma, that if I go through the EB5 program, will I have to stay actively involved in the business I invest in? What happens if my business does not perform as expected? Does that affect my permanent residency status?
Well, if you're investing in a regional center, you will not be involved in the day-to-day business of the regional center. They take care of everything. All they have to do is give you the documentation required to satisfy the USCIS so that you can get your green card. So you don't create the job creation, you don't do anything, you don't run the business. So you don't have to be worried. So it's going to be up to them to run the business. And most of the projects that we have seen, we've never seen them going into a bankruptcy or anything like that, because they're very stable companies who've already done EB5s in the past and had people get green cards. So we don't expect that. But if you're going to be doing a direct investment, yes, you will be involved in the management, and they expect you to create and maintain the job creation for at least 10 US workers until you get the green card, which may take 3 years, 4 years, depends.
All right. Okay. So I hope, Samantha, you got your answer. And, in case if you have any follow-up question or any other question regarding the topic, then please go ahead and put them on the comment section. We will take them up. And Mark is here. Mark is saying, Uma, that thank you. I'm just referring to my spouse. E1S or E2S? Okay. I was talking about
Those are called as E2 dependents. Again, it's not an E1S or an E2S. They are the dependent visas. If they are outside the US, there's nothing to apply. They just go to the US consulate, fill up the DS 160s. If the spouse, the principal applicant or the principal investor, E2 investor, got the E2 approved at the consulate, then the spouse and children under 21 can apply for the E2 dependent visa. If they are in the United States, yes, we do apply concurrently for the E2 principal applicant and the E2 dependents at the same time.
Okay, all right. And here, Mark has another question that he wants to ask. My second question is about, with your experience, does USCIS adjudicate my E1 application together with my spouse, or does she have to wait for months?
It all depends if you're doing regular or premium. If you're doing regular, even yours can take months and months, and possibly even your spouse, because they'll wait to see what is the status of your case, because they are a dependent. Until the principal is approved, they won't approve the dependents. So it all depends whether you're choosing to do regular or premium.
All right. Thank you so much, Uma, for taking up our viewers' questions. And now I think we should move ahead with Facebook questions, because there also we have a lot of viewers who have joined us. So let me go ahead and Control, if you can please share the screen, and let's go with the Facebook questions. Okay, so Islam is here, and he's saying that is it possible to purchase a trucking company for AB5, or it has to be different type of business? This is for AB5.
No, you can. If it's a direct investment he's talking about, he has to invest 1,050,000. He can invest in a trucking business, but he also has to show that he is creating employment for 10 US workers until he gets the green card.
All right.
I wouldn't do a direct investment. I would definitely opt for a regional center. There are less risks involved in that.
Mm-hmm. That's right. Okay, so let's move ahead with our next question. So here we have from anonymous participant, and the question is approved I-526, waiting for I-485 here. So anyone in the same situation, then what is the process? Also, how long does it take for you to get approved? Any RFE, please, any information is much appreciated. Yes, Uma.
I wouldn't be able to comment because I don't have any of his documentation to, say whether he'll get an RFE or he won't. If he's already working with an attorney, I would suggest them to contact their attorney so the attorney can tell them if they're lacking anything or would they expect an RFE. Again, even their own attorney cannot tell them that because it all depends on an individual officer adjudicating this. So without looking at his document, I cannot comment.
All right, so I think this participant needs to get in touch with our attorney. So, friend, I think there should be more detailing about your situation, about your case. So please go ahead and feel free to get in touch with attorney Uma Mantrawadi. She would love to help you out. Just share your case, share your situation, and ask any question directly by reaching out to her. Okay, and let's move ahead with the next viewer. Bill is here. So, hi, Bill. And he's saying that I'm thinking about applying for EB5 investment visa, a British citizen. But I want to apply this visa while in the United States, not from UK. So, do you think I need B1 or B2 visa on my British passport prior visiting USA? Can anyone
Yeah, because, go ahead, sorry.
No, it was just, can anyone share any link for specific this information? Yeah.
Well, UK citizens or a lot of European citizens can come on something called as ESTA, and from an ESTA you cannot change your status. So definitely, yes, if you can come on a B1, B2, but it takes a year to 2 years for the whole process to be completed. So you cannot stay on a B1, B2. You'll have to convert that either to an E2 or an F1 or an H1 or whatever he qualifies for. So without knowing that, I cannot say, whether he can stay here and get his green card here on an EB5.
All right. Okay, and let's move ahead with the next one. Okay, Sahej Deep is here. Hi, Sahej Deep, and thank you so much for putting up this question. He's saying that there's a quick question. I want to do direct EB5 investment. We are on E2 visa now from Canada, Indian born. Project is an unreserved area. I saw the news saying only 60 investors from India applied under EB5 unreserved category in last 3 years. 700 visa are available per year for EB5 unreserved category. So is it possible in coming months that EB5 unreserved come to current from 2019? My point is that more and more people applying for reserved category, rural and high unemployment. Is any chance EB5 unreserved becomes current?
I cannot predict that. We hope it will become current, but we don't know, what can happen. As I keep saying, Sam, I'll have to get a parrot from India who's going to pick up one of those tarot cards and tell me all these questions.
That's right. That's right. And it is so easy to ask from attorneys that when it's going to be current, but we can't tell.
I tell people it's like asking a certified financial planner also, will Microsoft stock go up or down? There's no way to predict that.
That's right. I think, yeah, that's right. And, that's how people are right now. People are very confused and they're very restless.
I understand. I fully understand where they're coming from. There's a lot of uncertainties. There's a lot of frustration. There's a lot of, vagueness to the whole system. So everybody is almost, I can say, like a scatterbrain. We don't know whether to go this way, that way. I can fully understand that, but that's where the professionals come into play. An attorney who has been practicing, for years and years, we are pretty much grounded, we are calm, we think calmly and analyze the situation and recommend the best available options for that individual. There is no copy paste in our practices, whether I'm doing 50 H1s or 200 L1s, there's no copy paste. Everyone will be distinctly different based on their background. So I fully understand that people are confused, vague, frustrated, even I can say that. But in all this also, we have to maintain our calm and, go to an attorney, go to a professional to get the right advice and to move forward.
Absolutely. That's very well said. And I think that is the thing, very important thing that our viewers should do. And with that, Uma, we have covered Facebook questions and viewers' question. So I think let's come back to my questions. And this is a very important one that I have for you. That, for example, if Gold Card comes into reality and anyhow the plan gets succeed. So can we expect that Gold Card is going to attract more global entrepreneurs or high net worth individuals to the USA?
I would think so. Like I mentioned a few times ago when we did a webinar talking about L1s and all that, it's going to be a very selected number of people who can afford $5 million and, and never expect to see that money back. So there's going to be not many people, and I'm pretty sure the number of visas, whenever they actually approve this, will be a very small number.
Okay.
Because I don't think many people can afford it.
Mm-hmm. That's right.
So it's going to be very limited.
Okay. And friends, in case, if you're having any questions or any doubts, then please go ahead and put them in the comment section. Until now, if you haven't subscribed to our channel yet, then please subscribe, also like and share our session. This is going to be very important and really very helpful. Okay, and with that, Uma, here's another question that, just if we are predicting if gold card comes out, then is it going to affect the future of the EB5 program, or can both continue side by side without any disturbance?
Well, like I said, I would hope that they will continue EB5 because that's a job creation program as opposed to just taking the money and never to see it back. So as an attorney, as somebody who I have seen EB5s for the longest period of time, I would think that they should continue the EB5 and not take it out.
Okay, that's great. And with thousands already signing up for Trump's gold card, is America building a new class of immigration for the rich only? What do you have to say on this, Uma?
I don't know where they're signing up. We haven't seen anything. We have no idea unless it's going directly to the White House where there is a sign up. We haven't seen anything as a lawyer where people can sign up or say, I'm going to invest, I'm interested. USCIS has not published anything. So we as lawyers have not seen anything.
Okay. And
So
with
if
that,
there's a rumor about this, that somebody is signing up somewhere, I'm highly skeptical about this.
yeah, that's right. Okay, and with this, Uma, I think I have my last question for you. And this is that in shaping immigration policy, should the United States place more value on applicants who invest financially or those who directly create jobs and contribute to local communities?
I would highly recommend or continue with the EB5, which is giving more value to creation of jobs, especially this year, as most people have seen, there's been a lot of layoffs, even with the big Fortune 500 companies, there's tremendous layoffs. And the EB5 could be a way out for job creation with the money that's being invested simultaneously. So I would highly think that is a better route to keep it going and encourage the EB5 and not the gold card. I don't think so. But then if the government is looking purely for money and keep it parallel, then that's fine.
Okay, and with that, Uma, we are done with our questions, and everything has been explained wonderfully. So I'll just say that thank you so much, and you are, as usual, very insightful, and providing these answers is really great, and very great facts and great stories too. So once again, thank you so much for being here, and as usual, it was lovely having you in this webinar too.
My pleasure, Sam. Good to see you again, and we'll be back again with more interesting topics too.
Absolutely. Thank you so much, Uma, and have a great day.
You too.
Thank you.
Thank you. Bye-bye.
Bye-bye. Okay, friends, so that's all for today's webinar. This session was packed with a lot of insights and, great information. I'm sure you enjoyed it and have developed a lot of questions. In case if you're having any question regarding the topic, then please go ahead and put them on the comment section. Even after the live stream ends, me with my team going to come back to you and provide you the right answers. And don't forget to like, share, and subscribe to our channel. Our handle is @Immigration TalkShow. We are not just here on YouTube, but also available on LinkedIn, Facebook, X, and on Instagram as well. And with that, thank you so much, everyone, for being here. Stay informed, stay connected, and stay motivated. And keep watching Immigration Talk Show. It's me, Sam, your host, signing off for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are here with another very exciting webinar that is lined up just for you. So make sure to watch this webinar till the end and also participate here by joining us on dialing up this number. And you can also write anything on the comment section. And before diving into the topic, let me go ahead with the disclaimer first. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information at your own risk. All right, friends, with that, once again, welcome back to Immigration Talk Show, and I'm your host, Sam. And we are live on LinkedIn, Facebook, X, and also on Instagram as well. And you can follow us on these many platforms too. And talking about today's topic is another very important and very interesting one. EB2, EB3, and EB5. What is the fastest green card path for you? So, we all know, friends, that getting a green card is a very big deal. But you know what? Our focus shouldn't be just to get it, but also to get it faster and quicker. And that is why we are here. We are having this live webinar where we are going to talk about these three very popular green card paths: EB2, EB3, and EB5, where we are going to explore some major differences like what are the process, what are the eligibility requirements, and most importantly, which one can get you your green card the fastest. Okay, and before diving into the questions, let me also tell you that the great news is we have an expert over here who will be joining me in a bit, who is really, I would say, great in her insights and provide expert advice in a great way, none other than attorney Rani Manti, who has 28 years of experience in helping employers and foreign workers to navigate the complexities of immigration law. So I would just like to welcome our attorney and our today's guest. Hi, Rani, and thank you so much for being here. Really excited for the show and looking so pretty today.
Sam, thank you for having me. It's a pleasure, and I'm glad to share some valuable information about the green card process, which is a very important process for nationals, foreign nationals all over the country. And so I'm very happy to be here.
Absolutely. Likewise, I think our audience are also very excited for this topic. I think this is a very catchy topic and a very important topic, especially in 2025. So, friends, the best thing is that you can also reach out to our attorney, Rani Amandi, and you just have to visit the link that will be visible on the screen. And you just have to go there. You'll get the contact details of her and go ahead and join her. Okay, and with that, Rani, here we have a very important topic. And this, friends, I think let me go ahead with my very first question that if we can understand some basic information, because there are so many viewers, who are not very much clear regarding these three popular paths. So, Rani, if you can let us know, what are some major difference between these three categories in terms of process, eligibility, and cost.
Absolutely. So there are approximately 3 green card processes that we're going to discuss today. The first is going to be we're going to focus on the EB2, the EB3 category, and the EB5 category. We have an EB1 category which relates to individuals of extraordinary ability in various fields and known for their extraordinary talent. But we're not going to go there. We're going to just focus on EB2, EB3, and EB5. So in terms of what are the major differences, number one, it's eligibility requirements for each of these EB1 or EB2 categories. And secondly, it's going to be the timeline. And that's the most important part, of course. And number three, it's going to be the costs also. So we're going to share some of that with you. In terms of the eligibility requirements for the EB2, let's start with that first. One should possess at least a bachelor's degree and 5 years of work experience in a particular field of study. Whereas for the EB3, you need at least just a bachelor's degree or 2 years of work experience. So the distinction for EB2, you could also have a master's degree. So those are the two primary differences between EB2 and EB3. EB2 is master's plus any years of experience, and or a bachelor's degree and 5 years of experience. Whereas EB3 is just 2 years of experience and or a bachelor's degree. For the EB5, you don't need eligibility in terms of education. You just actually, your qualifications there are capital. You need to possess $800,000 of capital in order to invest in this, to obtain the EB5 visa, which turns into a green card. The reason we talk about EB5 is because it actually, at this time, has the quickest processing times, and that is of paramount interest to our viewers. The biggest issue is, what is the quickest green card? And I'm going to highlight that is the quickest green card right now. The processing time for the EB5 currently can be as quick as 2 years and can go to 4 years, regardless, at this point, regardless of your country of nationality. In terms of the EB2 and EB3, in terms of their timeline, for the rest of the world, the processing times can be much quicker. Typically, they're in 2022, 2022 timeline for the EB2 or EB3. But if you were talking about India and Indian nationals, the timeline right now for the EB3 category is they're working on April 2013 cases, whereas for the EB2 category, they're working on February 2013 cases, which means we have a timeline backlog of 12 years, because now it's 2025, and you take the difference between that, the fact of what cases they are processing currently. So when you compare the fact that you've got a 12-year wait period versus before you even file for your adjustment of status versus your EB5, where you're actually receiving a green card possibly within 2 to 4 years, we're talking about a time difference of 8 years that it's quicker. The EB5 is quicker by 8 years. So that's the crazy part about it. And let's talk about the costs. Let's talk about the differential in costs with all of these. The EB2, EB3 green card is typically paid the majority of the costs are borne by the employer. Sometimes the employer may pass the costs on to the employee, maybe at the last stage. We see fees ranging from $8,000 to $10,000 to $12,000 for this green card process. But don't forget, the first two stages can be completed within the first two to 3 years, and hence 2/3 of the legal fees are paid up then, typically by the employer. As a matter of fact, the employer is legally obligated to pay at least the first stage of the perm application and even the first stage, and could also pay the rest. Whereas for the EB5, the green card process it's substantially higher. Those fees can be up to $60,000 as to the legal fees. It could range from 25,000 on average for the legal fees. But in addition to the legal fees, there is a management fee cost that also has to be paid, and that could be another 35,000. That's why we say 60,000 out of pocket there, in addition to the investment of $800,000. But the good news about the EB5 investment, and I'm sorry that this is not a quick differential between the three, because it's a general question you asked me about their timeline and the differences. The last point I'll make about the EB5 is that you can accumulate the investment capital for the EB5 through family and friends. You can also, it's primarily family, and who can give you gifts. You can also take a loan to accumulate that capital, a loan against collateral, or even receive just a promissory a note with take a loan with a promissory note. So that's it to wrap up the differences between the EB2, EB3, and the EB5. And now I'm sure I thoroughly confused everybody.
No, absolutely not. You are very much. And with that, Rani, as you have explained about the difference among these three, I would also like to ask that you are saying that EB5 is better than the rest of the two, right? But as we have been looking into the news also that EB5 may be replaced with the Trump Gold Card. So if you can also shed light a bit on that, like about the golden visa card, right? We have heard that, and we have been also hearing, we don't know whether it's a rumor or it's a fact, but what it is, and if it's going to replace, then how everything gonna be? If you can also let us know.
So the information surrounding the Trump Gold Card is not clear. And when it's not clear just yet, because it has to be implemented with regulation or policy, typically that would be a congressional approval for that process. And we haven't heard further information about it just yet. So I think at this time we just have to go with what we have, and there's no need to wait, because even if you start the process and file a case, it's not the case that it will be eliminated. Those who have filed those cases will be grandfathered in to continue their green cards. So you can either wait for whenever any new law arises or is implemented, or you can take those steps and be proactive if you are able to meet the eligibility criterion for the EB5. So that's what I think. That we're not sure of how it'll take impact. But don't forget, it's a $5 million amount, and very few amount of people can do that. Hence, if you compare the EB5 to the Gold Card, the EB5 is an $800,000 investment. If you tack on certain legal fees, it can be another $60,000. So that's why I think that I don't see any issue at this time in not moving forward with all your other options.
All right, that's a great one, and I think that's fairly said, Rani, about this question, and we all agree with that. And with that, I would say that there are so many people who have joined us, and I can also see a list of questions here. So, hi Ricky, hi Magic World, hi Nubi, hi Rudra, Ricky, Fawad, everyone, guys, thank you so much for joining us. We are here live for an hour. Go ahead, ask as many questions as possible. Our expert is here and she would love to take up all your questions. And also, don't forget to like, share, and subscribe to our channel. Friends, our handle is at Immigration Talk Show. So I think Rani, let's take one of the questions from Magic World and let's see what he's asking. So Magic World is asking that could be please let me know how to check in H-1B amendment case whether the employee changes his location in the MSA or outside the MSA. And how do I will come to know? Please let me know about this.
So it's not a green card question, but I'll be happy to answer it. First, if you're the employee, the law that governs H-1B amendments is whether the new location, the worksite location that you will be working at, is within the same metropolitan statistical area called the MSA or not. That is checked by the attorney. Typically, the same MSA is a 60-mile radius from within that area. And hence, you can generally estimate that if it's within commutable distance, which is according to the Department of Labor rules, about a 60-mile radius, then you are fine, you're within the MSA. However, it has to be checked by the attorney. And that is about a different county, whether it's a different county, you could look that up. If you've got a new city, look up the county. If it's not the same county, then, it's based on the labor condition application of the U.S. Department of Labor guidelines. When you look up a particular city, sometimes it falls within the same counties, but this is not something that you can verify per se. It has to be under the Department of Labor rules, which the attorney typically checks. So that's how it has to be done. Have the employer verify with the attorney, or you could look up whether it's within the same county. But as I said, some cities fall within the same county anyways. I hope that answered the question.
Absolutely. And thank you so much, Rani, for picking up this question. Okay, and friends, also don't forget to subscribe to our channel. And Magic World is here, so I hope if you have any doubt or any other following up question, then please go ahead and put them in the comment section, or you can also get in touch with Attorney Rani Amanti. The link is here. You just have to visit this link, and you'll get the contact details of her. And with that, let me go ahead and pick up some other questions too. Okay, Ricky is here. So, hi, Ricky, and thank you so much for your participation. He's asking, my NIW I-140 petition was filed by employer. NIW I-140 petition processing time for the Nebraska Center is 16.5 months as per USCIS website. So can you give some idea on the typical processing time that you are seeing for the I-140 petition? Also, if the employer lays off, then what happens to the pending NIW I-140 petition? Yes.
Time is whatever you got. That's 80% of the time of the cases are being processed within that period. So you can estimate some are quicker, some are slower. So it doesn't mean that it's 100% going to be processed that way. So just keep that in mind. It's a good average processing time. If the employer lays off when the pending national interest waiver is pending, that's a problem. Maybe it'll get approved without, further request for evidence. But when you file for your adjustment of status, based on that, you do need the employer support. So that is going to be an issue that affects your case, unfortunately.
All right. Okay, that's okay. And Ricky, thank you so much for your participation. In case if you have any other doubt, then please go ahead and put them on the comment section. Till then, I think Rani, we can continue with our questions too, because I have so many questions to ask from you. And that is, what happens if someone qualifies for both EB2 and EB3? How should they choose that which path to take? Basically, which path is better, EB2 or EB3?
I'll just make it very simple. It's simply about the processing time. If you qualify for EB2 or EB3, say you have a bachelor's and 5 years of experience, or if you have, basically that's the, if you are qualifying for both, you'd have to have the bachelor's plus 5. And I would say that you want to have the quickest green card processing time. The green card for employment-based petitions are made up of comprised of 3 stages: the perm application, the I-140 process, and adjustment of status. It all boils down to the adjustment of status timeline. When is my priority date going to become current? At this current time, for the month of June 2025, the EB2 is being processed they're processing January 2013 cases, whereas for EB3, they're processing April 2013 cases. And that means that April 2013 is quicker, which is related to EB3. However, I have been looking backwards for several months to see what's been going on. And what I see is that when one moves forward, the other one might sit there, but then the next month or two, the other category may move forward. If you want to start now, start with the EB3 process, as it's a couple of months quicker at this time. But these cases move back and forth with the priority dates. That means that the number of green cards being processed or green card visa numbers that are being given out, sometimes they catch up quicker and they've processed them, and that's why they move the dates forward, saying that we're going to process the older cases now. And so I would say you just, go with the one that's quicker at the moment, but you know what? It could also pull back a little. So it's almost like they are neck and neck, frankly speaking. So they're almost the same.
Okay, that's great. And also, Rani, if you can give us, green card cheat sheet that will help our viewers to determine the best path for them, depending on their status, education, or experience, and other factors, then that would be wonderful.
Sure. What I wanted to talk about is, in terms of the cheat sheet, it's really the simple thing is like, number one, what is your education and experience? If your education is at least a bachelor's degree, or if you have 2 years of experience, so we're talking about the eligibility criterion. Is it the bachelor's degree? Is it a 2 years of experience? If you don't have more than 4 years of experience, if you don't have a bachelor's in 5, you're going to have to go for EB3, I'm sorry, the EB3 category. If you do possess a bachelor's degree and 5 years of experience or a master's degree, you're going to go for EB2. That is your criterion based on your education. The final thing is with the EB5, you can go for the EB5 if you have the capital through your family members, or if you've taken a loan for that $800,000 investment. The cheat sheet is that the EB2 and EB3 are just going to take, for Indian nationals, they are going to take you 12 years right now. What's quicker in processing time is the EB5, which is going to take you 2 to 4 years for the initial green card. But it's all about the capital that you have. So it's really about the criterion, about what your education is, what your experience is. So I'd love to hear if anybody has some questions just about that. But that's really your way that you're going to go. The other part is if you have a family member, going to your little categories, if you have a family member who's a U.S. citizen, who can sponsor you for your spouse visa, or a parent or a child, then you're going to go that route. So you really, those processing times for the family-based immigration, can take about 18 months. So it's not that bad, but it's family-based. So if you're stuck with just employment-based, you're looking at those criteria. The other point is if you have, if you're an individual of extraordinary ability in a particular field, and you are able to demonstrate you're in the top 2, 3, 4, 5% in the world in this category, then you can shoot for the EB1 extraordinary ability green card. And those processing times are around about 3-year backlog at the moment. So you could still get your green card through the EB1, but that's going to be at the higher level. You are in an extraordinary ability category, go for the EB1. So that's it. I just wanted to wrap it up and just kind of show you all that these are the pigeonholes that you can evaluate yourself and your merits on, and that's how you can go. With the EB1, keep in mind you can self-petition, whereas for EB2 and EB3, you need an employer. With the EB5, you don't need an employer, but you need capital. So that's the issue at hand.
All right, that's wonderfully explained. And thank you so much, Rani,
My pleasure.
explaining things in a very detailed way. And let me go ahead with my next question. And this is a very demanding question, right? That most of our viewers do ask. That why do some EB5 investors lose their money and still don't get a green card? What do you have to say on this?
So it appears that the unfortunate aspect of such a case would be the attorney and the investor failed to conduct due diligence in regards to the viability of the regional center project. That means that number one, is it certified by the United States Citizenship and Immigration Services? Most likely, yes, because the attorney would not have gone that route. However, the failure lies in that the regional center perhaps has not had a track record of processing green cards. And that is what it's surprising when this happens, because one, the investor should not have invested or move forward with such an application without understanding if there was a track record. And that's what we encourage. We do not guide you to a regional center that just sounds good. Oh, it's creating the basis of a regional center is to create 10 jobs for 10 U.S. workers based on the capital, the capital given by the investor. The regional center is an economic center that has been sanctioned by the United States Citizenship and Immigration Services that is creating jobs for multiple people because they're taking investment capital of many investors. What is happening is that it's an economic unit that one portion of the funds to create that capital or economic activity would be investor money, maybe only 25%. Another 25 to 30% could come from a loan from the bank for that regional center, and the final aspect will be cash from the operators of the regional center. Regional centers are nothing more than shopping centers, apartment buildings, malls. It could be development units. So these are huge capital projects that can run to a few $100 million and $100 million, $200 million, $300 million. And as I mentioned, the capital from the investors ends up being a small portion. Sometimes it's 10, 20%. But that means that for every $800,000 that is invested by the individual from the investor, then 10 U.S. jobs have to be created. So furthermore, so they take X number of investors to reach that certain capital to meet that, the projections. But if the growth of the regional center over time, you get your first green card perhaps within 2 to 4 years. It's a temporary green card for only 2 years. Prior to the expiration of the temporary green card, the investor has to file for the removal of the temporary condition to obtain the permanent green card. So the regional center has to be viable throughout that entire period, which can be up to 5-6 years. And If it did not, it did not stay profitable, the investor loses their money because there's no income to the EB5 at the permanent stage. The permanent green card stage will be denied if it's not profitable at that point. And that's where the investor loses their money and their green card. But that's why it's important we use a FINRA licensed broker. It's a broker. There's only 12 FINRA brokers in the United States. They are specifically held accountable. We consult with them to ensure that we're working with regional centers that have viable projects and have a track record to issue green cards. So that's the difference between someone losing their money and failing to conduct the due diligence.
All right, that's really great, and thank you so much, Rani, for taking up these questions very patiently and explaining things in a great way. Now, I think let me go ahead with some of our viewers too. Fawad is here, and friends, also don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Okay, so let's see what Fawad is asking. So Fawad is asking that I have a master's degree in computer science and about 5 years of experience in tech. Some folks are telling me to go for EB2 NIW, and others are saying EB3 is safer. Okay, so can you help me understand which one would likely be faster for someone like me?
So, with a master's plus 5 years of experience, you just because you meet the qualifications for an EB2 application does not mean that, and the national interest waiver, which has a quicker processing time, doesn't mean that you may qualify for the national interest waiver, because again, you have to demonstrate that your work is in the national interest of the United States. So you have to be able to show that through certain criteria. There's 10 different criteria to show that you've been published or you have articles written, and the nature of the work is within the national interest of the United States. If that's the case, certainly try for the EB2. But if I were you, if you're able to, through whatever means, is lock in your EB3 priority date, lock it in through the employer, and if the employer is willing to pay, or you are, then spend the extra money on the EB2 national interest waiver if you meet the criterion, and then proceed with both. Just because I would not rely just on the EB2 national interest waiver in case it doesn't work out. But certainly the EB3 is safe, and I certainly would recommend start with the EB3, then work on the EB2.
Okay, I hope Fawad, you are understanding, and EB3, good luck with that. And in case if you have any further question, then please go ahead and reach out to Attorney Rani Amandi. You just have to visit this link and you'll get the contact details of her, and feel free to ask any question regarding your immigration journey, and she would love to help you. And with that, let me go ahead with my question, Rani, that I have for you. And okay, let me go ahead with this question regarding let me talk about some denials, okay, because most of the time we have been hearing that there are so many reasons that the EB3 green card applications get denied. So I would like to know it from you that what are the most common reasons that the EB3 and EB2 green card applications get denial or delayed?
I think that some of the issues that affect the PERM, there's 3 stages for the green card. That's the PERM application. So that is the stop. That is the location where you're looking at potentially, once it's filed, the Department of Labor could issue an audit, and the audit sometimes is, it could be just a simple matter, a simple question as to, justification for the particular position, meeting that requirement. Has the employer been overly restrictive in filing this particular labor certification? Have they made it too narrow? Because if they made it too narrow, it's kind of blocking U.S. workers from applying? Have they tailored it closely to the beneficiary, the foreign nationals' experience? So things like that might pop up. In my 2.5 decades of practice, we've had a 100% success rate because we are very careful. I think that when you take a case, you have to carefully document the case. You have to ensure you're not being overly broad or restrictive in different ways. I would say it's like a 99% success rate, but what we make sure is that you have to be very careful when you're drafting the requirements. The other reason a case can be denied is if there's incomplete, if the employer's failure to correctly document the recruitment campaign. So prior to filing the perm application, the employer has to run advertisements in 4 to 5 different media sources, the employer website, an employment-based website, 2 Sunday newspapers, and a third other option, which is a one-time ad in another newspaper. After completion of the recruitment campaign, there's a 30-day wait period, at which time the employer has to document the response for any resumes received and whether any of those workers were qualified. If there were U.S. workers that were received who are qualified to meet these requirements. So if the employer failed to document that, that's a problem. If the employer received resumes from qualified U.S. workers, that's it, game over. The employer has demonstrated that there are U.S. workers available for the position. If there are U.S. workers available for the position, then there's no green card. The basis for this green card to be issued is that they could not find any qualified U.S. workers. So the moment you have that could be a problem, and it is a problem, and the case will not be certified. The fact is, again, it goes down to carefully documenting the job position and job duties with the employer, pulling out all the technical aspects of the position and ensuring that the position is correctly documented. And so that's the other areas where the recruitment fails, because the recruitment report fails to correctly document and that U.S. workers have responded. Sometimes it could be the prevailing wage determination, which takes forever, but typically, the prevailing wage is a 4-month process, 4 to 6 months process that is filed prior to the perm application being filed. But either way, it will be certified, but it might delay the case a bit. So delays can come from the perm because sometimes they take longer. They can go to 8 months sometimes, and that could be another potential delay. But audits also delay cases. So audits can delay cases by adding another 4 to 6 months onto the perm processing timeline. Currently, the perm is taking 14 months for approval. It was running even more than that in the last few months, but right now it's come down to 14 months, a little under 12 to 14 months on average. But as I said, the triggers on an audit on the prevailing wage can add 4 to 6 months on to any case. So that's basically the basis on which some cases are delayed or denied.
All right. I hope our viewers are understanding. And friends, I hope you're keeping a note of everything whatsoever Attorney Rani Amandi is explaining. And let me go ahead with my next very important question and that I have prepared for you, Rani. And most of the time we have seen that some of the EB5 applicants, they start, but after some time they get a good job. That means that they qualify for the EB2. So, what if someone who is starting EB5, but later on, if they get a good job, who are qualifying for EB2, should they switch or keep going with the EB5? What's your call on that?
So, my position has always been: let's be safe. Let's be innovative, but let's be safe. let's secure our green card spot. And what I would say is that I would always keep two open if I can. I would, if you had started the EB5, go ahead with it. If your employer is willing to go ahead with the EB2, go ahead. And when you are the EB2 or the EB3 has a three-stage process: the perm, the I-140, and the adjustment of status. Whereas for the EB5, it's going to be your investor application, and then once it's approved, it's the adjustment of status. Currently, EB5 is current for rural investment regional centers. That means you can actually file the I-526E and the adjustment of status at the same time. You could actually do that. I would do that if I have a track record with that regional center, so you can file at the same time. Whether, as to which case, if you have two adjustment of status cases pending based on an employment-based application and the investor application, I would say let them both be processed, and you could then see, you can actually change the basis on which the adjustment of status application is being processed if you see a quicker timeline from one or the other. If you're an Indian national, EB2 and EB3 is just not, is 12 years behind. So we're not even talking about that. So if you're a national from any other country, that's when you really want to evaluate this and see if you want to switch between EB5 and EB2 and EB3.
All right. Thank you so much, Rani, for taking up that question. And this is really very important because most of our viewers, get really confused between these two categories and they have faced similar situation. But let me go ahead with another question, and that is regarding the international student. So, what is going to happen? And can an international student OPT plan for a green card through EB2 or EB5 just away? I mean, right after the graduation?
Absolutely, nothing prevents an F1 student from having an employer sponsor them. The issue that arises is that while the perm stage can take, actually, since it's taken 12 months or 14 months for the perm processing, it takes another 6 months for preparation with the prevailing wage to be filed and approved. So you're looking at least at 18 months, which is a year and a half, before your first stage can be cleared. Once that stage is cleared, you have to file, the employer will file the I-140, which is the actual immigrant petition. At that point, the immigrant petition is in contradiction to you as an F1 student, because an F1 student is has a temporary visa and is not permitted immigrant intent. It doesn't mean you can't process the green card. It means that don't travel until you receive your green card. And that makes no sense for Indian nationals because you're looking at 12 years that you can't travel. So it makes sense for other nationals from other countries because they're only maybe 3 years behind on the priority dates. So maybe that student will say, I'm going to finish my schooling, I'll wait, and I'll file my I-140 and my adjustment of status application. So they will be in a position to receive their green card, but it's not for Indian nationals to file that F1, that green card if you're an F1 student visa holder, because of the incompatibility of the non-immigrant intent of the F1 student, and which is in contradiction to the green card immigrant intent.
All right. Thank you so much, Rani, for that answer. And I would like to now shed light on some of our viewers' questions too, because I can see so many long questions are here. So let me take up Rudra's question. And hi, Rudra. Thank you so much for your participation. If you're participating for the first time, then make sure you have subscribed to our channel till now. And if you haven't, then do it right now. Okay, so Rudra is asking that I'm a VAWA approved applicant. I recently had my second interview on 4th February 2025 after my 601 and 212 waivers approved. After interview, my case went to AP. Is it the bad sign even after waivers? Okay, I think I'm so sorry, Rani, but here's a little explanation of the whole scenario. So let me take up this question. I hope this will be clearer. So, hi, I'm a VAWA approved applicant. I recently had my interview at Mumbai Embassy after my both waivers approved, 1601, sorry, I-601 and I-212. Interview went pretty well, but officer put my case under administrative processing. Is it that common for case goes under AP? And
This answer with the fact that I don't process FAWA applications, nor do I process the 601 waivers. However, the one point I can speak to is administrative processing is the additional verification that the consular officer conducts, which delays a case. Good news is you were approved, so that's wonderful. However, administrative processing is where they could conduct some background checks and due diligence back in the United States to verify the basis of what happened for your VAWA case and check on fingerprints. So it could take anywhere from a few weeks to 6 months. So administrative processing unfortunately puts everything on hold. The question is whether it's going to be quick or not. If you have someone in the U.S. who's connected to a congressman's office, you can have that person bring this up. If it's someone connected to your family, bring this up and see if they can intervene. A congressman every congressman has an immigration unit. So I would reach out specifically to a congressman who's a senator, a U.S. senator, that's part of the Senate. He or she is part of the Senate, U.S. Senate, not the House of Representatives. But that is one way to see if they can. They sometimes have direct answer to the U.S. conflict.
I'm so sorry to interrupt, Rani. I'm really sorry to interrupt, but there's some audio issue from your side. And I think it's a little major audio issue because we can't hear you at all, and there's some different type of sound coming. So I think if you can join us back,
Can you hear
or if you
me?
can do something.
Can you hear me now? Okay, or not?
Yeah, it's fine. It's fine, I think. Yeah, we can continue.
Yeah, because actually your voice also got a little staticky just now, so maybe it's just some internal thing. Yeah, okay. So what part did you hear? What part did you hear?
I think you can just give us a brief about it because it was tracking some different sounds. Not that much.
Oh, okay. Shall I go ahead? Okay. What I was saying is that I don't have experience in 601s and VAWA applications. However, administrative processing is something that happens even once a case is approved. And the consular officer is conducting some additional background checks on the case. That time can range anywhere from a few weeks to 6 to 8 months. If you have connections with your family, if anyone's here in the US, they can contact the local congressman's office and see each congressman has an immigration unit, and they can inquire about that case. Sometimes congressman's office, or they will contact the consulate directly. If there's some urgent matter, there's a reason that you need to get here quicker than later, they can look into it and try to understand what the issue is, and they can help expedite.
All right. Okay. So I think you got your answer. And in case if you still need any help or any other thing, then please go ahead and put them on the comment section and we will definitely take them up. Next, Jay is here. So hi, Jay, and thank you so much for your participation. The question Jay is asking Rani that how much does the country I was born will affect the speed of each option? I am from India and I have heard that things can be painfully slow. Is that true for all three paths?
Unfortunately, the first two are slow, painfully. Yes, 12 years is a long time for you to wait, and you have X number of extensions in the country to bide your time until your date is current. Once you have filed your green card application. The EB5 is a quicker route, as we talked about, that it can take 3 years for your green card approval. But yes, the reason why is that historically, countries such as China, India, and the Philippines have had historically greater number, and Mexico, the highest number of applicants. So because they have the highest number of applicants, and there's only a certain number of green cards or visa numbers issued in a particular year, that's why these country nationals are bumped to wait. They started a waiting game because they used up all visa numbers in that particular period, and it goes year by year by year. So unfortunately, yes, it is a waiting period. Good news, if you're not married, of course, everyone knows about a U.S. citizen. Marrying a U.S. citizen, you can get a green card in a short time. So you're lucky if that can save you your time, because you actually get married to a U.S. citizen. Now, besides a U.S. citizen, if you marry a national from any other country than India, that national's country of birth will expedite your green card. So, if you marry someone from Pakistan, if you marry someone from Bangladesh, if you marry someone from United Kingdom, France, they fall under all countries' chargeability. And right now, the backlog there is just about 3 years on average for those countries. So you can actually have your green card in that shorter period of time, depending on the country of birth of your spouse. And the person should not just be a naturalized citizen. It has to be based on their country of birth.
All right. Those are very important points, and thank you so much, Rani, for explaining things in a very detailed and very clear manner. Thank you, Jay, also for your participation and asking this very important question. This was a very important one. Okay, and also don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Now, let me go ahead with the Bivek one. So, hi, Bivek, and if you're joining us for the very first time, then welcome to Immigration Talk Show. And the question is that how fast will the visa bulletin change for EB3 for Nepal? As my PD is June 8, 2024, how long it takes approximately?
I don't have the visa bulletin in front of me. However, Vivek, you would fall under all other countries' chargeability. So I think they're at around 2022. So you're not far behind. You are in good shape. You're probably just a year and a half behind. So that's all you have to wait. I not offhand, I don't have it, unfortunately, but you do fall under all country chargeability, and we can look that up, and you will see. And you just take the difference between what they're processing right now. You look up the Visa Bulletin, just Google Visa Bulletin, go to the month of June, go to the all country chargeability column. You fall under that there, even if your country's not mentioned, because you are not one of the other countries with backlogs. And then you would just take the difference between your priority date and the number that's currently mentioned. I think it's about 3 years on average. 2. Right now, I think they're processing 2022. It might be 2021, but you take the difference, and then you're in good shape. You're not far off.
All right, that's a good one. And all the best, Vivek, and thank you so much for participation. Now, let me go ahead with Supriya's comment. So, hi, Supriya, and Supriya is asking that EB5 seems very risky. Is my money secure? And have you seen people getting their investment back? If yes, then after how many years?
Yes, we've seen investments being returned. Typically, the investment capital can be returned within within 5 years, 5 to 6 years on average. As I stated in the past earlier, that you must seek someone who is either guiding you with connection to a FINRA broker. These brokers have studied all the different regional centers. They are also held accountable because they are going to review and give you 2 to 3 different regional centers. And we only find regional centers with track records of giving green cards, of issuing the green cards, and who have a reputation in the industry. So these are large construction companies and whatnot, because they're the ones who are developing and building. So it's not risky if it's done through appropriate professionals, and that's what we've been dealing with. So that's the point at hand. Find out if you can, whoever you deal with, I want to go through a FINRA broker to help make my decision in selecting a regional center. That's what you're going to do. That's what you're going to say.
All right. Thank you so much, Rani, for your answer. And Rudra is back and he is saying, thank you for answering my question. I just want to add one more question. Okay. I had my dismissed forgery charges. Is that could be a major reason for my case to went AP? Yes, Rani.
Probably. Luckily, it's dismissed. Then they are verifying that information. It's possibly that, because if they're verifying fingerprints, it's going to be, they will look to see were the fingerprints taken, and fingerprints are related to the criminal database. So yes, it looks like it could be the issue. And if it's dismissed, that's good. So it might take some time for them to review that and make the decision.
All right. So Rudra, thank you so much for. And if you haven't liked, share, and subscribe to our channel, then please go ahead and do it right now. Okay. Okay. Vivek is also here, and he's also saying thank you so much for getting me the guidelines. Thank you so much, Vivek. And go ahead, like, share, and subscribe, because most of the time we come up with these amazing webinars with attorney Rani Amanti, and hope you don't want to miss it. And also subscribe to our channel, then also hit the bell icon so that whenever we come live, you'll get the notification. Okay, and with that, Rani, let me go ahead with my question, another very important one. And that is, about this, that some founders apply for EB2 NIW while growing their startup. So, what do you have to say? That is this a smart choice or a risky one?
Okay, so I don't think anything's risky if you really have to have it evaluated very carefully with an experienced attorney. The reason why you are going this route, seeking immigration advice, is you want the best possible advice. So it's risky. If it's risky, the attorney should say, I think it's risky, and you want to do this, you want to try this yourself, then you can, but understand you have a slim chance of success. Our job as attorneys is to advise of the likelihood of success. And then the individual makes the decision. If I tell you something's 50-50, I will say it's 50-50, and you have to say, okay, I'm going to take my chance, because 50-50 is not 80%. So that's our job, to advise you, and hopefully the attorneys, we have a professional duty to be honest and advise you appropriately. So, it's risky if the attorney tells you it's risky. If the attorney says you have an 80% chance of success, then go for it. Hopefully you research the attorney enough to know that the attorney's experienced. If the attorney's experienced and has a good, 10 plus years of experience, that should be good. And research your attorney that you're dealing with. That's the number one thing that you individuals must do. So that's what I think is very important, is research your attorney who's giving you the advice, and ask, what is my likelihood of success? Yeah, that's a good question. So once again, I don't know what your startup I know nothing about that, but it's a general question. But we would have to look at the facts of your case to tell you and advise you your chances of success.
Absolutely, friends. And with that, if you need a proper guidance, then I would suggest that don't wait anymore. Directly go ahead, visit this link, and get the contact details of Attorney Rani Mandi and ask any question or any complexity that you're facing right now in your immigration journey. And with that, Rani, I have a few questions, that I would like to go ahead with the Facebook group as well. So I think I'll take just a couple more minutes. I hope that will be okay for you. Okay, sure. Then let me go ahead with this first question. And there's anonymous member who is asking that, hi there, what is the average processing time for EB5 if I'm from Vietnam, but already in the US? I'm looking forward to hearing from all of you. Best regards.
So the average processing time, if you're in a rural project and you apply within the month of June, perhaps July, is approximately 2 to 3 years. So we're seeing the approvals are coming within under 2 years. And at the same time, for the rural economic project, you can also file for adjustment of status while you're in the United States. So that means you are in legal status. If you are here on another legal status, that's fine too. So yes, you are seeing approvals within 2 to 3 years for your initial green card. The initial green card is for a 2-year period, and prior to the expiration of the initial green card, you would apply for your permanent green card, and then that processing is another 2 to 3 years. So, but you do get your initial green card within a 2-year period. That's possible, 2 to 3 years.
Okay, that's great. And yeah, this is the next question. That hi, few years back, I had enrolled in a PhD program using day one CPT. I was able to get my first H1B stamping successfully in 2022, and now I'm planning to get my renewed H1B visa stamping via Dropbox. So, any thoughts if it is safe for travel given these conditions? Yes, Rani.
Look, I mean, I don't see any issues as long as you haven't criticized the United States government or engaged in any sort of it's going to be, they're looking into social media carefully. They're looking at if you have a criminal record. Those are the simple things. It used to just be about your criminal record, but other than that, now the countries are looking into social media. So you want to make sure you don't have anything that's contradictory to the interests of the United States. And rightly so. If you come to the United States, you're looking to have better opportunities. So it's rightly so. You shouldn't be, you don't want to be too critical of the United States either. So other than that, if you're going to get an H-1B, it's fine. We haven't seen any issues. As long as you've not committed crimes, and I don't see any issues. Yeah.
Okay, that's great, and that's a pretty positive attitude. So thank you, Rani, for participating in this very important question. And let me go ahead with this the last question that I have for you, and that is, I booked my Dropbox appointment for next week for H1 and H4. So I wanted to see if I can move it by 2 to 3 days, but I'm not able to log in, and it says, sorry, you have been blocked. In fact, when I sent email to support, they keep on sending the response that we have responded to your query. Please log into account and check under feedback or request section. I sent a couple of emails saying if I'm not able to log in, then how do I check my account to see what solution they are suggesting? So, yes, Rani, any suggestion? Also, anyone having any idea if there are Dropbox appointments available in June for the week of 15th June?
Okay. The Dropbox matter is an administrative issue to be dealt with the U.S. consulate directly. This is not an immigration question. It's a technical, administrative question related to a particular entity. So it's not something that I can answer. I think that maybe somebody else online can give him help, but I would also drop by the consulate and see if you could, get more information and keep wait for the email response, or keep trying through email and phone call.
All right. I think that's all, Rani, and it's almost more than a year. I mean, more than an hour, sorry. So it was really a great session, and so many important questions, and that to a very demanding topic. So I would just like to say, thank you so much for giving us time, and also your insights were really great. Our audience, we got really a great amount of engagement. So many people have joined, and Girish is also here. So I think, Rani, let's end it with Girish's question, and after that, we can take a leave. So Girish, thank you so much. And Girish is asking that his friend applied U visa, has lost H1B job, and traveled to India with son. Lost H4 status and stayed 5 months in USA without status and unauthorized work on H4 EAD. She dependent USA. Any option to return back to the USA?
Departed, I would think. I don't know what happened to the U visa, because if you would apply for it, that's what you would wait for. I mean, the only basis for you to be in the United States again is for someone to get a job opportunity. I understand you're saying that the question may be whether being out of status for 5 months in the US and working, it says, and unauthorized work on a H4 EAD. It sounds like a lot of little things going on, little facts that are not clear, but if you get a new opportunity, to come to the United States on H1, you or your husband, then you simply will be questioned on various things at the consulate. But if you did not stay beyond 6 months out of status, then you're okay. Because if you stay beyond 6 months out of status in the United States, you have a bar of 3 years. If you stay out of status for over a year, you're barred for 10 years. So I think that you just made the cutoff, so you should have a chance, and I would try again and see what happens. Because if you want to come back, try on a different visa. If it's a work visa or if it's a student visa, try and see what happens. But I'm not sure what happened to your new visa, though.
That's right. And I'll say, I hope, Girish, you got your answer. And thank you so much for the participation. We are just about to end this webinar, but in case if you have any question, then please go ahead, put them on the comment section. Maybe not now, but after the live stream ends, then also my team will connect with you and surely try our best to provide you the answer. And with that, Rani, I think that's all for today's webinar. So thank you so much. It was really a pleasure and honor to have a show with you, and really looking forward to have a next show with you next week. So thank you so much for joining us.
Sam, thank you. It was actually enjoyable, very enjoyable, because I like to see that we have viewers who are concerned and have those questions, and it's something that we can resolve and provide them some good information in a quick time. So I'm happy that we were able to do that. Thank you. I look forward to working with you again, and thanks for the opportunity. It's been a pleasure.
Likewise. Thank you so much, Rani. Have a great day.
And you too. Thank you.
Okay.
Bye.
Bye-bye. All right, friends. So that's all for today's webinar. I hope you watched it and enjoyed it too. And you can also get in touch with Attorney Rani Amandi. And you also don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And with that, friends, also don't forget to join us at 4 p.m. EDT. We will be coming live on Daily Immigration Dose. And thank you so much for joining us. Make sure to stay smart, stay safe, and keep watching Immigration Talk Show. Thank you, everyone. I'm Sam, signing off for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Hello, everyone, and welcome to Immigration Talk Show. I'm Nipasa, your host for today, and I'm super excited because we are going to have our guest join us pretty shortly, so stay with us. But before we start off with today's episode, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. And once again, friends, thank you so much for joining us here on Immigration Talk Show. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And check us out. We are on YouTube, LinkedIn, Facebook, X, and on Instagram. So stay connected with us and do not forget to ring that bell so that whenever we have discussions like these, you're notified. And another important thing is like and share our content because we have so much information that most of your friends and folks can also benefit. So share now, ask them to join in because we are going to be joined by a very renowned, managing attorney at EEG Immigration Law Group, which is led by none other than attorney Erin Green. So I think, yes, without further ado, please help me welcome him back to Immigration Talk Show. How are you doing, Erin, today?
Hey, good. How are you? Good to see you.
I'm doing good too. It's always good to see you and lovely to have you. I'm sure folks have not seen enough of you in our channel, so we'd love to know you better. Tell us more about what's going on. You have a pretty busy schedule.
Just about my work. Yeah, I'm just living and breathing H-1Bs and L-1s, you name it, all the fun stuff. Just constantly working, solving problems, strategizing. It's never ending. But it's good to be here with you and talk about some of these issues.
Same here, Erin. And folks out there, do not forget to check out attorney Erin Green. You can visit this link, which you can see on the screen, and get to know more about him or how to get in touch with him. So today, our topic of discussion is another very interesting one. H1B picks are down and what's behind it, and should you be worried about it? So I'm sure, folks who are in this H1B cap time and before the fiscal year, pretty worried because there have been less picks because of so many reasons, whether you talk about fee hikes or so many other things we're going to talk about in today's webinar. So I am pretty ready and I can see, we already have viewers joined us. So welcome viewers here on Immigration Talk Show. Ricky says hello. So hello to you too, Ricky. Good to see you once again. And he has a question. We are going to take it up a little later in the show. But before these questions, Erin, I also have a couple of questions and I'm going to just dive right in. So if you can break down, how the new beneficiary centric system changed the dynamics of this year's lottery, H1B lottery. Was it fairer, you think?
Oh, yes. I think it was much fairer. Did away with a lot of the job shopping and fraud. They went to more of a deduplication. They supposedly, so instead of taking all the registrations, and even if there were doubles, you could get selected 2, 3, 4 times. They announced that they were going to duplicate by beneficiary. I think that means that when a beneficiary was chosen a second time, they wouldn't put the second one in. Instead, they would choose another random person. Is what I understand. that means. So this led to yes, definitely less applications and less people being chosen. I believe the statistics were 7,800 multiple entries versus over 47,000 last year. So that's a big change. This is duplicates, so this would be a person being selected twice. Certainly has had a big impact there.
Right. And lovely to have you, friends out there. This is attorney Erin Green, who is an immigration attorney and an H-1B expert. So if you are, one struggling with your H-1B this year, or have so many questions because you're planning to get into the lottery very soon, feel free to join in to ask your questions. All you have to do is comment wherever you're watching, or dial this number, which you can see on the screen above. And the number is 425-436-6335. And when we ask for the access code, dial in 988-888. So, Erin, also, given the big drop in multiple registrations, which according to the statistics, it shows over 80%, what are the biggest takeaways for companies and applicants alike?
Well, the biggest takeaway is that we're not wasting all these H-1B lottery slots on people getting selected 2, 3, 4 times by different companies. A lot of that, probably most of that, was the job shopping. If people don't know what job shopping is, it was these companies that would form maybe non-affiliated companies, but still had similar like a friendship group, let's say, that could own different companies. And then let's say they took 100 employees, they could, if they had 10, 15 companies, they could apply 100 times per company. Think about how unfair that is to just one person who's trying to get an H-1B cap slot. So by doing the lottery this way and some of the changes, yes, including increasing the fee, it appears that we can see the statistics. There were much less multiple applicants picked, and in addition, less numbers. And I don't think that has to do with the economy, but I think it has most to do with cracking down on the job shoppers.
That's true. That's true. And it's really nice. I feel like it's much fairer this year. Whether you talk about, I think transparency is also another good thing that's happening recently, as we see, because firstly, there are no duplicates. Nobody can register more than once, or no matter how many companies are registering, but you'll be counted just as one. So all of that is, I think, pretty fair to everyone. It's like an equal chance for everybody in the lottery, right?
Yeah, I mean, I can tell you, our firm, we got almost just about 50% this year, which is very rare of our lottery, of our H-1Bs. In the past, we were, at 40 or 35. I think the overall percentage this year was at 30. I don't know if I have that. 35% approximately that were selected thus far, which is okay. It's over a third. It would be nice if the actual rate was like at 50%. That would be really a much better chance, obviously. But yes, it did feel like a better lottery this year so far. So we're looking good.
All right. So do you expect to have another lottery soon? I mean, the second lottery or a third, maybe?
Well, it's hard to say. So what they do is they see so the end of the filing period is at the end of June, as you know, at the end of this month. And then they will see if there's any withdrawals or just those cap cases that weren't filed. And then they traditionally will hold a second lottery. We really don't know. It's hard to predict what that's going to look like. When obviously our clients and employees that call us all the time and say, well, I didn't make it. What's my chances for the second lottery? We tell them not to get your hopes up because it's usually not a very big number. Last year was okay. It was a little bit better than the year before, but we really don't know what kind of numbers there will be for a secondary lottery.
Okay, so let's not keep our hopes up, folks out there, but definitely keep asking your questions. Hello, Sunita. Thank you so much for joining us. We are going to take up your questions a little later in this show, so stay with us. And also, Erin, we were talking about duplicate filing. So How has USCIS's crackdown on fraud and duplicate filings, impacted these legitimate applicants and their chances? What do you say?
Well, as I said, well, now the legitimate, well, you can see the percentages are going up, and the legitimate filers have a better chance. If you can get rid of all they don't call it fraud. It really is fraud, but what they're doing technically was, just groups of people filing for mass filings. When you do that, it normally, you say fraud, and I agree, because in many of those cases they don't have the jobs available. They're going backwards. They're trying to get numbers and then trying to pop these people into jobs that they can find after that. So yes, it was fraud, and now hopefully, well, it looks like it's much better for those who are just normal, regular cap lottery, applicants getting their number selected.
So is it true, like, there's a lot of scrutiny going, as in, like, people who have been registered for a special occupation, do they really check if there's a job like that or a vacancy like that for each and every case?
Well, the problem is they can't check when you're doing the lottery. So yes, after you file the application, that's when you have to submit all the relevant data and all about the job and everything. But yeah, I mean, years ago we used to the lottery worked where you would submit the application up front, and so there was a lot of work and a lot of fees, a lot of attorney's fees. Now there's a little bit less, but yeah, I predicted that when they switched over to the online method, that this exact trend of job shoppers would have it easier. Now this year, also by raising the price to $200, which is huge. It was $10 last year, and now each applicant was $200. So if you are job shopping and you have hundreds and hundreds, that's a huge cost that they're taking on and a big deterrent. So hopefully that has helped as well. And again, just the way that they intook the multiple beneficiaries also. So both of those combined should have been a deterrent to job shoppers, at least in the outcome, and even in maybe some that were applying. And so you can see the overall numbers were down this year as well.
Right, Erin, and thank you so much for taking that up as well, and for giving us a clearer picture on what is going around. So, friends, feel free to join us, and do not forget to subscribe. Our handle is at Immigration Talk Show. We have with us attorney Erin Green, who is an immigration attorney and, of course, an H-1B expert. So, to get to know more about him, visit this link which is on the screen, and keep commenting. So, Erin, what kind of red flags is USCIS looking for now, especially when reviewing H-1B filings, especially post-lottery?
Okay, well, yes. So we are seeing trends now because we've obviously filed a lot of H-1B lottery cases. We did receive an RFE, which I haven't seen in many years, which was a level 1 wage. We used to see those RFEs about level 1 wages years ago. Now I received one, which was interesting, questioning if it's a level 1 role. That had died down for a while, so that might be coming back. Also, we're seeing, let's see, what else do we have with our RFEs? They're questioning again. It seems they're questioning the job, the educational category. So sometimes, like if you file for an IT person, you might say the job requires a bachelor's in computer engineering, electrical engineering. Sometimes they'll put mechanical engineering, information science, data science, etc. You put a bunch there because large companies have the same role being played by employees with a variety of backgrounds, which do qualify for the role. We have seen a couple of those recently. They were not cap cases, but other cases where they questioned the degree requirement, which it's very ticky-tacky now for USCIS to start doing that in today's age where most of these degrees are acceptable and very relatable for IT roles, software engineering, etc. I think it's very ticky-tacky on their part. they're supposed to be looking again at third party. We haven't gotten any yet, but third party work sites. So for people who are working at third party sites, they used to heavily attack those. I remember that was about 6 to 10 years ago. Then it died down, and they announced that third party sites were not going to be scrutinized that hard. They might be coming back with that as well. So if you're going to be working at a third party site, you really want to document your application up front. Obviously, you need an itinerary, but we like to include SOWs, MSAs of the work contracts with the third party. And now they claim they're going to be looking into the third party itself, which is interesting because they're not the employer. So other than the statement of work and the MSA, I don't maybe some other documents relating to the particular job. I don't understand what they're going to look for in the third party client site, but we'll see if we get RFEs like that. Haven't received any yet.
All right. So, would you like to tell us, especially with H-1B cases that your law firm has been dealing with, or we will get to that very, very soon. Actually, it's time for a short break. So, folks out there, don't go anywhere, because today we are speaking with attorney Erin Green, who is an immigration attorney and also an H-1B expert. Get to know more about him by visiting this link, which you can see on the screen. And don't go anywhere. Stay tuned on Immigration Talk Show. It's me, Napasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa. And today we have our guest with us, attorney Erin Green, who is from Dallas-Fort Worth Metroplex area. And, well, he is an immigration attorney and an H-1B expert. So go check out EEG Immigration Law Firm and definitely join us for this conversation today, because we are speaking about H-1B picks are down and what's behind it, and should you be worried about it. So if you have your questions, especially with regard to H-1B, please feel free to join us. Comment wherever you're watching us. We are live right now on YouTube and also on X, Facebook, and LinkedIn. Also, friends, do check us out in all of these platforms. Stay connected with us, and you can call us to ask your questions. The number is 425-436-6335, and the access code is 988-888. So it's lovely, Erin, to have you. And I was just before the break, I was going to ask you about your firm, EEG Immigration Law Firm. Tell us about what has been happening, H-1B cases, or anything interesting that you want to share with us.
Well, other than those RFEs, which I just shared, which are some of the new trends we're seeing in RFEs related to H-1Bs, everything else is pretty running, as normal. Wait times are, similar. Maybe without premium, we're looking at anywhere from 2 to 6 months approximately to get H-1Bs back. As you know, the premium gives you a first response within 15 business days. They changed that from calendar days, so they're giving themselves more time for the same amount of money, which is kind of a ripoff. But yeah, other than that, everything's running pretty smoothly. Hopefully, we'll see how much we did. We are experiencing a few RFEs now that we haven't seen in the past couple of years. So hopefully the RFE numbers won't get too bad, but we will see how that goes.
All right. Thank you so much, Erin, for sharing how's it going there with EEG Law Firm. So, friends, if you have your questions, I can see Girish has also joined us. Mansi has joined us. We are going to take up your questions. Please stay with us. In a short while, we are going to address your questions. So, Erin, with a 35 selection rate and cleaner data this year, what are the real odds of a second lottery? I already asked, but how do you feel, the differences? Because though there have been less registrations, but the picks are, I think, still all right, right?
Yeah, I mean, there was over what 300,000. What was it, 370 this year? So it's pretty strong indication of the economy and the jobs that are needed. Um, yeah, I don't see any problems.
Okay, and if a second lottery happens by any chance, what are the timelines and what should, unpicked applicants do now to stay prepared, if you have any tips?
There's nothing they can do except wait. And if they normally will do a second lottery, I think usually towards the end of July, so next month, if they do it. But again, as I said previously, I wouldn't get your hopes up because there are not very many slots given in the second lottery traditionally.
Okay, okay. But I think that's good. Thank you so much for your response. And folks out there, do not get disheartened, but wait. Let's just hope that things open up for some of you somehow. Anyway, let's take up some of our questions from our viewers who have joined us. I think we should not keep them waiting too long. So let's take up Ricky. If one is on H1B, should one persuade the employer to try the O1 route if it has any benefits?
Yeah, I mean, the O1 is certainly provides a way to get a work visa. The problem with the O1 is you have to be an expert in your field, and that's very hard to prove, much harder to prove now than it was 15, 20 years ago. To go into the O1 category would take a while, but there's basically criteria of 10 different groups, and you need to prove 3 of those very well. So for example, if you've done a lot of one of them is like refereeing for like journals. If you can show that you've been invited to referee or to look at others' papers, but you can't just have done it like once or twice. You need to really have a good number of those. For example, articles that you've written with IT, which is the number one H1B, but in O1 you're looking at a lot of journals, whether it's IT, medical, whatever the field is. You really want to have a lot of Google citations. So sometimes folks are very brilliant, but they don't have they haven't been cited, maybe only 50 or 100 times. They do look at that. So those are like the weaker cases. If their work has been cited, let's say 500 to 1,500 times, then you're looking at a stronger case. The only way to really know if you have an O1 case is for an attorney to look at your resume, full resume, which includes all presentations, all your journals, all your work, everywhere you've spoken, conferences, things like that. If you have, the best thing to do is to put that in a very comprehensive resume, and someone like me can look at that and see if you have a legitimate O1 case or at least a solid chance of getting approved. But those are not for everybody. Those are just the highest, considered experts in your field, and you have to really show that you're either nationally or internationally known as an expert in that field, whatever your expertise is.
Like exceptionally good. So thank you, Erin, for taking that up. And Ricky, we are going to take up more of your questions, but now we'll quickly take up Girisha's question. So if H1B applicant has prior visa overstays of 5 months, departed USA, does USCIS flag it now with Christine Noem's guidelines, or it can be addressed in DS-160 for consulate interview? If filed new H-1B petition with new employer from outside the USA.
So I don't know that Christy Nome has implemented any new guidelines. I'm not sure what they're talking about there. That might be just fear mongering, because they do fear mongering of Trump. Everything that's Trump, they like to fear monger. But to answer your question, yeah, if you had an overstay and you have a new H-1B and you're doing the DS-160 and you're going to have your interview, yes, please, you must disclose it on the DS-160. It'll ask a question, you answer it truthfully, explain what happened, the dates, and yes, if it comes up, then you gotta discuss it at the interview. Do not try to hide and overstay. That's the worst thing you could do, because then there's going to be fraud and you're going to be barred for years from the United States.
All right. All the best, Girish. And thank you so much, Erin, for taking that up. So let's take up Sunita's now. Sunita's asking, I've been following the H1B numbers closely and I'm concerned about the impact on my chances. Are there specific reasons why fewer people are getting picked? Is it because of a change in the lottery process or something else?
Okay, fewer people are not getting picked. The same amount of people are getting picked. The same amount of people have a better chance this year of getting picked than last year. So I don't know where it's who's saying fewer people are getting picked. It was 60,000 and 20,000, total of approximately 80,000. They select over 100,000 for those who, will withdraw, et cetera, or fraud. So it's exactly the same number of people getting picked, no less.
Okay. All right. Thank you, Sunita, for asking a question. And thank you, Erin, for taking that up. Now we got Mansi asking, doesn't the fact that an H-1B visa is employer sponsored create a power imbalance, potentially leading to exploitation? Specifically, if an H-1B visa holder feels pressured to accept lower pay or unfavorable working conditions that a US citizen in a similar situation would not tolerate. Can it be argued that they are being taken advantage of?
No. So first of all, as far as the salary goes, the employer offers a salary to the employee. The employee can accept the salary or not accept the salary or negotiate for a higher salary. U.S. employers have to treat H-1B employees exactly the same as they do American employees. So all the benefits that their American employees get have to be offered to the H-1B employee. So there can be no mistreatment of an H-1B employee in that sense. As far as salary goes, salary is always a negotiation between the employer and the employee, whether you're an American employee or an H-1B employee. That negotiation happens back and forth. With the H-1B, there is a labor condition application which protects the H-1B employee from the salary being offered as being too lower than the standard for that area. So that is already in place to help them. But, I've seen H-1Bs with very salaries much higher than the prevailing wage on the labor condition application in many times. It all depends on the company and, how they pay and what their guidelines are for their roles. But again, there's no difference between a company hiring an H-1B and hiring an American in terms of how they're going to treat that employee.
Okay. All right. Thank you so much, Erin, for taking that up for Mansi.
Mm-hmm.
We have more questions from Ricky, so let's take this one. My H-1B is up for renewal next year. I haven't gone outside the US for the first time H-1B stamping till now. For the first H-1B stamping, it says. So will I have to go for stamping before H-1B renewal, or can renewal be done while I am in the USA?
Well, traditionally, you can't renew your visa while you're in the USA. I think he's talking. So keep in mind, you don't need to get an H-1B visa unless you're leaving the U.S. Some people, we have clients that have been in the U.S. for 10, 15 years and never left, and they just keep extending their H-1B and getting new approval notices. You really technically do not have to leave. But most people do need to travel, whether it's to go home and see their family or whatever. They just business trips, vacations. They want to get that H-1B visa. That is done outside the U.S. at a consulate. You do fill out your DS-160 online. You make an appointment. You go to the interview. You bring your approval notice and some other documents, and then you get the visa. There was a pilot program they announced a couple years ago where they're going to maybe start trying to do that from within the U.S., where you don't have to necessarily leave to get that H-1B visa. That certainly would be nice and save everybody a lot of travel time, especially if you're from India or China, which is a long way to go. But I don't think that's in practice. I think they did some samples with that, but I'm not sure where that program is right now. But yeah, if they do change that and allow some mass, some people from getting in great numbers from getting visas in the U.S., I think that will be very greatly utilized. I don't trust USCIS to implement anything smoothly, so it's good that they're doing a sample run here. So we'll see how that goes.
All right. Thank you so much, Erin, for taking that up for Ricky. And Ricky, keep commenting. I can see more questions, but we will take them up after another short break. It's time for another break. So, friends, today we have with us none other than attorney Erin Green, who is from EEG Immigration Law Firm. And, folks, uh, it is led by attorney Erin Green himself. So, he's an immigration attorney and an H-1B expert. So, please feel free to keep commenting with your questions with regard to H1B so that we can address them in this show. And don't go anywhere. I'm your host, Napasa, on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we have with us attorney Erin Green, who is an immigration attorney and an H-1B expert, and we have been speaking about H-1B picks are down and what's behind it, and should you be worried? And you should definitely go check out EEG Immigration Law Firm. Focuses solely on corporate immigration and is led by none other than attorney Erin Green himself. So visit this link, which you can see on the screen, and get to know more about him. So, yes, I think our topic is like H1B picks are down, but in the real picture, it not really is very down, right? So
No,
that
when you
is
say picks, you're saying that the number of applications are a little bit down. Not to be, don't confuse people by saying, oh, there's less H-1B cap lottery slots this year. There's exactly the same amount as there is every year.
exactly the same amount.
That's a little bit misleading.
I think that is what I wanted to clear up so that people don't get confused, because I think it was Mansi or Sunita asking something similar like that. But yeah, lovely to have you, for so patiently taking up each of our questions, Erin. And we have more questions from Ricky, so we'll just take
Ricky's
them
got
up.
a lot. No, Ricky's busy. Ricky's keeping us busy. Okay.
Yes.
Let's go, Ricky.
Can you give some idea on the typical processing time that you are seeing for I-140 petition, he's asking?
I-140s?
Yes.
Well, it depends. If it's like EB1 multinational manager without premium, those are taking a long time. We're looking at like 8 to 13 months before you get a first response. If you're talking about I-140, EB2 or EB3, I would say between 5 to 10 months, let's say, somewhere in there. They're a little bit more over the map, but for some reason, the EB1 multinational managers have slowed down tremendously over the past couple of years with their wait times. You can now do premium in that category, so that's good. But again, the premium is almost $3,000 the USCIS takes. It's a big expense for companies to spend that. A lot of them do because they have a lot of money, but it's still and also, if you really don't need it, so let's say you have an Indian born and the perm's been approved and now you file the I-140 and they have a lot of time on their H-1B clock because you've done it early. Do you really need the premium? I know people like to know, oh, is my I-140 approved or not? But in a lot of cases, you can just do regular processing and save the company the money. I know that wasn't the question, but yeah, those are the approximate timeframes for those.
Yes, you already took up his next question, so there you go.
Oh,
It's already on screen. Yeah.
oh, the
So he
next
was
question.
also asking, yeah, it was related to premium processing. So he's also asking if he goes for premium processing, how much will the chances of an RFE increase? For a pending NIW I-140 petition.
Yeah, it's hard to say. Some people think that if you do premium, you have a better chance of getting a quick RFE. Just because and I guess I have seen this. I can't really prove it, but I have seen trends where you do file in premium, and these adjudicators have so many cases that they just send you these boilerplate RFEs. I don't know if that's. I mean, that would be pretty mean if that's the practice to do that, and impractical to give people who are paying you $3,000 more of a chance of an RFE. I can't see that in practice, but I mean, yes, we do see sometimes that it's just like you send these premium cases in on an I-140, and then towards the 15th or 45th day or 30th day, whatever their premium time is, you get that RFE like that. It's hard to say. I wouldn't discourage anyone from doing premium if they need it. Again, if you don't really need it, then there's no reason to spend the money. Again, premium can be useful. We have a lot of H-1Bs, for example, who are close to their 6 years of H-1B time, and they just got their perm approved, and they need to get that I-140 approval so that they can get extra H-1B time. There's an example where you would need it, so you're going to have to do it anyway.
All right. Well, thank you so much for taking them up, and thank you, Ricky, for so actively participating. I hope you're happy with all of our answers, and don't forget to subscribe to our channel and also share and like our content with your friends and family out there so they can also join in to ask their questions. And subscribe to our channel. Our handle is @Immigration TalkShow. So I do have more questions, Erin, so I'll jump into them. How has the jump in registration fees, from $10 to $215, influenced employer behavior or application volume, you think?
Yes, I did. We talked about that earlier, but it was really shocking to me that they went from $10 to over $200 just to enter the lottery. As far as my clients go, we haven't seen any impact at all. But again, my clients can be big $1 million clients, $1 billion clients, even smaller clients. They can pay the lottery fee. I think the whole point of that was to deter these job shopping schemes that were going on. And so, yes, as I mentioned before, if you're filing, 500 lottery submissions for, 10 or 150 or 100 people, look at the cost that you're getting by filing so much. So, yes, for the job shoppers, that can be a deterrent. So I would suspect that played a part in the reason why there weren't as many applications this year, and certainly multiple duplicate applications for the same person.
Right. So, but this has, you think, affected the smaller businesses? The bigger companies have still been.
I don't know. I think if smaller businesses know that the H-1B process is going to cost them anywhere from, if they make the H-1B, you're looking just between attorney's fees and USCIS fees, you're looking at, it could be anywhere from $5,000 to $8,000. So if they're willing to make that investment anyway, then another, $190 isn't going to change anything. If they're a legitimate company and they have a real need for an H-1B, and they're already accepting the fact and the costs of the process.
All right. Well, thank you, Erin, for taking that up as well. So now moving on to my next question, are you seeing a trend where companies are getting more selective about who they sponsor for H-1Bs now?
That's a hard question to answer because it depends on the company. If you're talking about big companies with thousands and thousands of employees, they will usually have processes written in place in their HR, in their guidelines for employees, where they have a set regiment of who can and who cannot If you're talking about smaller companies who don't really have rules set in place, where they go just on a case-by-case basis, nothing's changed. I would assume that for the bigger companies, for example, they might say, if you're working we will not sponsor your H-1B until you're working for us for a certain amount of time. I don't see how anything would change this year, though. But that's a hard question to answer. It depends on the company, I would say.
Thank you. Thank you, Erin, for taking that up as well. So I do have a few case studies. Let's take them up. So this first one is about a student, who's currently on STEM OPT, was not picked in fiscal year 2026 H-1B lottery. So their OPT ends October this year, and they are exploring day one CPT options. What risks should they consider before enrolling in another program, just to stay in status?
Yes, we did have that situation happen a few times recently where, the student doesn't get picked, and then they want to enroll in a master's or a higher, degree level. And yes, they can get the CPT. Before they enroll, they need to talk to the foreign student advisor of that school and make sure that the program that they're enrolling in will give them CPT. Sometimes it is on day one, and sometimes some of the programs won't give it to you until you're there for 3 months or 6 months, etc. So the most important thing to do is to speak with the foreign student advisor of the school that you're interested in and understand what their rules are for your degree study that you're going to do. And obviously your employer is counting on that. So you want to make sure that that's set before you invest in the school or enroll, etc. But yes, that can be helpful in the short term. We have had cases where students did do that. They used the CPT, they continued to work with the employer. And then, for example, maybe the perm was now pending for a year and we could apply for a 1-year H-1B, or, during that studies, we got the I-140 approved where we didn't have it approved before. And now we can apply for the 3-year H-1B. So it can be valuable in some situations.
Okay. Thank you so much for taking that up as well, Erin. And this next question also is another case study. I would like to address that as well. So a US startup filed an H-1B for its only foreign engineer, but was not selected. The company is now wondering if moving operations abroad temporarily is a better option than waiting another year. And what legal and strategic considerations should they keep in mind?
The question is a little weird. Are you saying that the whole company is going to move because one person didn't get selected in the cap, or you're saying they want to move the person offshore for a year, which is, yes, this is another way. If the latter, this is another way of keeping someone employed. If an American company has a foreign affiliate, not everyone does, but they can employ the person, let's say, in their home country or even in another country where they have an affiliated country. If they can employ them there for a year, not only will first of all, they will be eligible for an L1 potentially if they're a manager, or if they can accumulate specialized knowledge in that year of employment abroad with the company, or they've been accumulating it. Then after a year, the company would be eligible to file an L1A or an L1B for that employee, which is an alternative to the H1B. Or they're keeping the employee, and yes, of course, they want to apply for the H1B cap, in the next year when it comes. So you'll have both of those options while keeping the employee.
Thank you so much, Erin, for taking that up as well. And we have more questions from our audience on Facebook group, so we are going to address them as well. But it's now time again for another short break. So friends out there, don't go anywhere. We are speaking with attorney Erin Green from EEG Immigration Law Firm from Dallas, and we are speaking about H-1B picks, what's behind it, and should you be worried today? So don't go anywhere, because attorney Erin Green is an immigration expert and an H-1B expert. So keep commenting with your questions. We are going to address them after this short break. Don't go anywhere. It's me, Napasa, on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we have with us none other than Attorney Aaron Green from Dallas, and it's been wonderful having him. He is from EEG Immigration Law Firm, who focus solely on corporate immigration and is led by Attorney Aaron Green himself. We have been speaking about H-1B picks and what's behind the counts and should you be worried about it today. So it's been wonderful that Tony Aaron Green has been taking up each of our questions so patiently, and it's lovely to see all you viewers also so actively participating, especially Ricky and Girish as well, who has another question, and we will take that up before we take up our Facebook questions. So Girish is asking one more follow-up question. USCIS will not issue RFE for prior visa overstays or out of status. That is the question or a statement.
Um,
So
yeah,
yeah.
when you submit an H-1B, a part of the application is to show them that you are and have been in status. So, for example, every H-1B extension or change of employer, you want to submit pay statements from we like to ask for the previous, let's say, 5 months, just to be safe, to show them that you have been working as an H-1B while you're in the U.S. As far as the previous overstay goes, USCIS, maybe it depends on how deep they want to get into your travel history. It's possible they can look into that. Those questions are usually dealt with at the consular level when you're getting your visa. But RFEs never cease to surprise me. Sometimes we'll get some weird ones or some different ones. So it's possible they could ask anything depending on how far they want to look into your record, your travel history, and things like that.
All right. So thank you so much, Aaron, for taking that up. And Girish, thank you for your question. We will address a couple of questions from our Facebook. So Control, if you can please display them. So this first one is my H-1B visa interview was conducted on January 15th, 2025, and I was issued a 221G with the status showing refused. The case was initially created on January 13th, 2025, and has been updated on January 22nd, February 11th, February 18th, when my employer submitted the response, February 28th, and lastly on March 3rd this year. It has now been almost 84 days with no further updates since the last status change. What do I do next? And please guide me.
Well, in most cases, you can, or the employer or the attorney, or even yourself, can send an email to that consulate with the case number. You can go online and find the consulate, and sometimes they'll have instructions of how to use. Some of them have tools where you can basically make an inquiry online, or even the vendor will have that as well, meaning the vendor group who's transporting the passport back to you sometimes. But yeah, try to reach them by email is the best, and explain, give them all the information, put your, the day of your interview, your name, your birthday, passport number. If it's an attorney, he'll do that for you. if it's yourself, yeah, you can just ask them and then say, give them a little bit of the background. Don't make the email too lengthy or too drawn out. Just say specifically what the issue is and tell them how long you've been waiting. And hopefully someone will get back to you with an answer, whether it's on an email or in their internal processes where you can make inquiries.
I'm sure that'll be very helpful. Thank you so much, Attorney Aaron, for taking that up. Now, our next one, let's take it up. Control, if you can display, please. All right, I think there's an issue or something. Okay. So this is from Ashraf. Hi everyone. I'm currently pursuing my MBA in US, expected to graduate by December 2026. I plan to apply for the H-1B lottery in March 2026 while still on F1 status. Could anyone with experience in this process kindly advise me on eligibility to apply for H-1B before graduation, how to manage study and work timelines if selected, and steps I should take now to prepare? Any reliable consultant or organization that can guide me and help or recommendations would be greatly appreciated. Thank you.
Okay, well, you're an F1. The first thing you need to do is have an employer who's going to sponsor you for an H-1B. That's step one. Without that, there are no other steps. So assuming there is an employer that you're working for or will work for, and they're interested in applying for the H-1B for you, you mentioned that you're pursuing your MBA. So yes, technically, if you have an undergrad, you will have a 4-year degree. If it's a relevant degree, then an H-1B could be applied if the degree requires a bachelor's in that subject area. If it requires an MBA and you don't have an MBA by the time you're filing the application, then they're going to reject the H-1B application because you don't have the degree unless you have, the requisite undergrad degree plus years of experience. So be careful for that. We had situations when I worked at Infosys where we had some folks who they didn't have the degree yet. So they were doing their bachelor's, but they didn't have yet the degree. So we couldn't file the H-1B for them so from the date of filing, you should have the 4-year degree. So then you'd have to delay it until the degree was actually received. And I've seen RFEs where they get nitpicky, or sometimes you have earned the degree, but you haven't got the diploma yet, so you can't submit that. I've seen some RFEs on that years ago. But bottom line, yeah, you should have the degree, at least whatever the degree is required. And again, for H-1B, it's a 4-year undergraduate degree is required. The role must require that or its equivalent.
Well, thank you. And Ashraf, I hope that was very helpful. Don't forget to subscribe to our channel. Our handle is at Immigration TalkShow. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram. And folks out there, thank you for joining us. Keep commenting. So now we have our next one. This is from an anonymous participant asking, I'm seeking assistance from anyone with experience in this matter. I'm currently in the process of changing my J1 visa to H1B status within the US without returning to my home country. I recently got married and my home country may be on a travel ban list. My question is, if I obtain the H1B visa, will the ban impact my wife's ability to secure an H4 visa, considering I do not plan to travel back home? And can the ban affect her H4 visa status if I have an active H1B?
That's a good question. So you're saying you're going to get your H-1B in the U.S., you're going to change status, but the wife is abroad. She would normally be entitled to just simply going to the consulate in her home country and getting the H-4 based on your approval notice. So the question becomes, what about all these new bans if they're not processing people from that country? That's a very good question. I guess we would have to see what country it is and what the ban is, if there is a ban, or what it says. In some cases, it may be possible to obtain H4 in a different country. We had a client recently in the Congo, but there was the consulate was shut down, so we had to send them to Angola to get an L2 visa, and the wait time there was a year. So you can imagine all the headaches and problems in some countries. But yeah, that's a good question. It would be hard for me to answer that without more information and specifics of the country and what the ban is and what it says and how it's being, processed in that sense.
But I suggest, anonymous participant, if you're watching this, do check out this link and, get the details for attorney Aaron Green. You can, consult with him and probably get more answers after you give him more details. So now this next question, if we can have on the screen, please. Well, that's pretty long. If Aaron, you can also read so that,
Okay.
those.
Yeah, I'll read it.
Sure. So, hi, I recently got married and my husband is in the US on H-1B visa. I'm working in US based multinational IT company. My company is planning to transfer me on H-1B or L-1B visa in late 2026. Before that, I am thinking of visiting my husband in US for a couple of months in late 2025 or early 2026. Our query is, which is the best visa option, B2 or H4 for me in this situation, considering approval or rejection, possibly, or other aspects, if any. I'll take leave for a month in my company and resume work once back to India. In case of B2 visa, should I update my passport with spouse name and then apply for a visitor visa, or is it advisable not to disclose marriage right now and apply for a visitor visa with my current passport, presenting me as solo traveler while taking PTO from work? What kind of question can I expect during B2 and H4 visa interviews? Is there any risk in applying for a visitor visa, which is considered straightforward and safer option to get visa quickly? I'm planning for a short visit, so looking for solutions during this year till the time my company transfers me on work visa.
Yeah, okay. So here in this situation, it appears that the husband is in the U.S., the wife is abroad. I would apply for the H4 visa based on the husband's approval notice and the marriage certificate that she would have. That would be a lot better than trying to get a B visa where you have to show ties to your home country. And then when you have a husband in the US, that is going to raise a lot of red flags as to your immigrant intent, because not many people get married and live in two different countries, although it does happen. So yes, number one, I'd go for the H4, and it's pretty straightforward. The marriage certificate and the fact that he has been approved for an H1B would give you the right to get an H4 pretty quickly. That would be the smoothest way to go. They usually don't ask much on H4 interviews, but in this situation, they will see that you're married to someone living in the States while you're living, at least right now, abroad. They might ask about the dynamics of the relationship, but I mean, probably not. You just can explain everything to them about the situation. You have your job here, he's working there, but you want to go visit him. And yeah, the H4 would be for that. Technically, an H4 should be living and working and living and accompanying the H1B in the US. That's the reason for the visa. But in this case, even if you're going to go in and out for trips, I think it would be okay as well. So I would go for the H4 here.
Oh, there you go. Thank you so much, Aaron. For that was huge, but very clear question. So, and also a response from you, Aaron. So thank you so much. And I think with that we have covered most of our questions, especially from our audience who are watching us. Lovely viewers, I would say, with great questions. So do not forget to subscribe and please like and share, with your friends and folks who can also benefit from this content. And Aaron, before we go, we spoke about our topic of discussion for sure. But if you can leave our audience with, a couple of tips as well, maybe it'll be great. since anything with regard to corporate immigration or people with H-1B, and who are worried about their status, what can they do? Just leave us with some tips.
Well, if you're an H-1B, you're pretty much in a good position in the United States. As you know, H-1Bs can change employers. They are very, just like an American worker would be. They can be recruited and they can seek jobs. I've seen H-1Bs who've worked for 10 different companies in 15 years in the United States. It can be a little bit frustrating because of the backlogs. Like if you're Indian born, for example, and you go through everything and you get an approved I-140, but still you're not going to have a priority date for years. You got to keep extending the H-1B. That can be a little bit frustrating, but on the other hand, you're still able to live and work just as you would if you had a green card. So there's really no downfall other than the fact that you don't have your green card yet. As far as any, the fear mongering that goes on because there's a new president and people say they're going to affect the H-1B. I've heard that left and right. A lot of unscrupulous immigration lawyers will try to scare clients into thinking that somehow the H-1B program is going to be harmed or reduced, or it's going to be harder. We might see RFEs uptick a little bit here. We'll see. In the sense that they want to verify things. But other than that, there aren't really many changes just because there's a new administration now. We've seen this administration before. We're seeing it again. They're very pro-business. In fact, I would say they're pro-H-1B as well. It would be nice if Congress could act and, help with the H-1B process, maybe the backlogs or more numbers, but that's a long shot, because they're never going to come together and agree on some legislature in that respect. But to your average H-1B out there, yeah, I wouldn't worry about anything. There is a little bit of a downtick in the IT sector these days. There have been some reports that there are less numbers. A lot of these jobs are in IT admin, a little bit in engineering, and some people say because of the increase in AI, that there's less IT jobs available. I still think there's plenty of IT jobs in our country that we can't fill even now. But yes, for those who are studying, make sure that you're studying relevant degree fields like computer engineering, IT, even anything in AI would be great. That's the future. One of the reasons why the United States needs so many H-1B IT jobs is because our students, American students, in many cases are taking just ridiculous degrees in liberal arts or just things that are just not philosophy, things that are just not useful or practical, especially as our world evolves into internet and computers and IT and how we've been going. So that's something to keep in mind. But yeah, for your normal H-1B out there, nothing to worry about. Just, keep going. Don't have any fear. And the H-1B program is working as it has been, as it always has been.
Thank you so much, Tony Erin. It was lovely having you. Such a pleasure and an honor that you took up all of our questions and you made time out of your busy schedule to be a part of our session here on Immigration Talk Show. So lovely.
Thank you for having me. It's always great to talk to you. Thank you so much.
I hope you can join us again soon. I will keep in touch with you for that.
Looking forward to it.
Thank you once again.
Okay. All right. Thanks. Have a good day.
So, folks out there, check out attorney Erin Green from Dallas, and absolutely check out EEG Immigration Law Firm, who's focused solely on corporate immigration and is led by attorney Erin Green himself. And also, if you have more questions or any suggestions or topics that you want us to cover, please feel free to get in touch with me as well. Or if you have any questions, maybe address them, and I could take them up on our shows. My phone number where you can get in touch with me, call me, or WhatsApp me is 408-335-6444. And also, I have an email address. My email is nipa@staffingly.com. So check us out. And do not forget to subscribe to our channel. Our handle is @Immigration Talk Show. Ring that bell so that whenever we have discussions like these, you are notified. You can join us. You can participate by dialing in, by commenting, and check us out on YouTube, LinkedIn, Facebook, X, and on Instagram. Stay connected with us, and lovely viewers, it was awesome having you with your questions as well. Keep commenting. We will try to address them even after the stream has ended. So thank you, and stay tuned on Immigration Talk Show because we have so much more content that you do not want to miss out on. It's Nipasa saying bye for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.